Postpone further proceedings today on the question of approving any measure or matter or adopting an amendment on which a recorded vote or the yeas and nays are ordered. The first order of business is ratifying the new subcommittee roster. The clerks have distributed the roster electronically. I ask unanimous consent that the committee approve the appointments and assignments as shown on the roster. Without objection, the subcommittee roster is approved. The chair also notes that points of order pertaining to the engaging of personalities against the president will not be in order for the duration of this markup. Given the underlying subject matter of Hunter Biden's subpoena and this committee's investigation, members must be allowed to speak frankly. Now, pursuant to notice, I call up a report containing a resolution recommending that the House of Representatives find Robert Hunter Biden in contempt of Congress for refusal to comply with a subpoena duly issued by this committee. The clerk will report the report, which has been distributed in advance.
A report containing a House resolution recommending that the House of Representatives find Robert Hunter Biden in contempt of Congress for refusal to comply with a subpoena duly issued by this committee.
I ask unanimous consent that the report be considered as read and open for amendment at any point. Without objection, so ordered. The chair recognizes himself to offer an amendment in the nature of a substitute. The clerk will please report the amendment.
An amendment in the nature of a substitute offered to the contempt report as offered by Mr. Comer of Kentucky.
Without objection, the amendment is considered as read, and the substitute will be considered as original text for the purposes of further amendment. I now recognize myself for 5 minutes for a statement on the report. Today, the House Committee on Oversight and Accountability will consider a resolution and report recommending the House of Representatives find Hunter Biden in contempt of Congress for his refusal to comply with a subpoena duly issued by the committee. The House Committees on Oversight and Accountability and Judiciary issued subpoenas to Hunter Biden for a deposition to be conducted on December 13th, 2023. On December 13th, Hunter Biden failed to comply with the deposition subpoenas relevant to the House of Representatives impeachment inquiry and the committee's oversight investigations. Instead, Hunter Biden appeared on the grounds of the U.S. Capitol where he read a short, prepared statement without taking any questions from the media. Our investigation has produced significant evidence suggesting President Biden knew of, participated in, and benefited from his family's cashing in on the Biden name. Based on witness testimony, Joe Biden was the brand his family sold around the world to enrich the Biden family. The Bidens and their associates raked in over $24 million from 2014 to 2019 from countries like China, Russia, Romania, and Kazakhstan. Witness testimony confirms then Vice President Biden met, spoke by phone, dined, and had coffee with his family's foreign business associates. President Biden has repeatedly lied to the American people about speaking with his son's associates. We've also traced how money from the Biden's China deals and other influence peddling schemes landed in Joe Biden's personal bank account. We plan to question Hunter Biden about this record of evidence during our deposition, but he blatantly defied 2 lawful subpoenas. Hunter Biden's willful refusal to comply with the committee's subpoenas is a criminal act. It constitutes contempt of Congress and warrants referral to the appropriate United States Attorney's Office for prosecution as prescribed by the law. We will not provide Hunter Biden with special treatment because of his last name. All Americans must be treated equally under the law, and that includes the Bidens. Now, recognize Ranking Member Raskin.
Thank you, Mr. Chairman. We believe that everyone subpoenaed by Congress, whether it's Hunter Biden or Jim Jordan or Andy Biggs or Steve Bannon or Scott Perry, should engage in good faith compliance with the committee's requests and the committee's subpoenas. We are here today because the chairman has bizarrely decided to obstruct his own investigation and is now seeking to hold Hunter Biden in contempt after he accepted the chairman's multiple public offers to come answer the committee's questions under oath before the American people. This is at the same time that they stand by the categorical non-compliance of Republican members of Congress, like Mr. Jordan, who have material information about the violent attack that took
One
place.
moment. The cameras cannot be in the well. Cameras cannot be in the well. Cameras cannot be in the well. Yeah. All right, proceed, Mr. Raskin.
Thank you. But I was just making the point that our colleagues who are arraigning Mr. Biden today on charges that he has not rendered 100% compliance, allegedly with a subpoena, are standing by Republican colleagues who've rendered 0% compliance with their subpoenas, including Mr. Jordan, Mr. Biggs, and Mr. Perry, when they have material information about the violent attack on the Capitol, the Congress, and the Vice President of the United States on January 6, 2021. In any event, for the last 11 months, the chairman has repeatedly refused offers from Hunter Biden and his attorney to meet with the chairman and his staff and with members of this committee. On February 9th, just one day after the chairman's first letter to Hunter Biden, Mr. Biden's lawyer responded and offered Chairman Comer to, quote, sit with you and your staff, including the ranking member and his staff, to see whether Mr. Biden has information that may inform some legitimate legislative purpose and be helpful to the committee. The chairman never responded. On September 13th, Mr. Biden's lawyer again wrote to Chairman Comer after a Newsmax interview in which the chairman falsely claimed that he never got a response back to his original letter. Mr. Biden's attorney explained the chairman actually never responded to his offer to sit down and discuss the committee's request, but stated that he remained available to have the discussion, but the chairman again completely failed to respond. 2 months later, on November 8th, Chairman Comer and Jordan issued subpoenas to Mr. Biden requiring his appearance for a deposition on December 13th. In the cover letter, the chairman noted, given your client's willingness to address this investigation publicly up to this point, we would expect him to testify before Congress. Throughout the fall, the chairman urged Mr. Biden to come appear at a public committee hearing. On September 13th, on Newsmax, the chairman stated, Hunter Biden is more than welcome to come in front of the committee. If he wants to clear his good name, if he wants to come and say, you know, there weren't 20 show companies, he's invited today. We'll drop everything. On October 31, on a nationwide podcast, the chairman stated, we have mountains of evidence. Now we're ready to bring them in. We're in the downhill phase now because we have so many documents and we can bring these people in for depositions or committee hearings, whichever they choose. For depositions or committee hearings, whichever they choose, and we can ask these questions with evidence. On November 6th, again on Newsmax, our good chairman stated, I will extend that invitation on your show right now, Rob, if the Biden family wants to join Tony Bobulinski in an official oversight committee hearing and answer questions that the American people have, then that invitation's open right now. They can come on in and do that. On November 28th, Hunter Biden, through his lawyer, agreed to Chairman Comer's multiple public requests. He agreed to appear precisely at a public hearing under oath to answer the committee's questions on December 13th. Exactly what our good colleagues, the Republicans who had information about January 6th, never agreed to do. They never agreed to testify anywhere under oath about what they knew. The letter that came in from Mr. Biden embraced the importance of having a public proceeding that, quote, would prevent selective leaks, manipulated transcripts, doctored exhibits, or one-sided press statements, especially in light of the committee's past use of closed-door sessions to manipulate, even distort the facts,
Mr. Chairman,
misinform the public.
Mr. Chairman, I have an inquiry.
State your point.
Mr. Chairman, don't we have House rules and committee rules regarding subpoenas and then rules about having hearings and having questions with witnesses
We
that
do.
must be followed.
Mr. Chairman, I'd like to reclaim my
Could you
time.
state the rules, Mr. Chairman?
Hold on.
We
one
can
second.
just interrupt each
Mr.
other with an
Askew,
inquiry?
Your time was expired.
I'd like to know the rules of the House and our committee.
Read them.
They're available to every member.
The rules state, for a deposition, if that's what you're asking, 3 days' notice, you have to have the stenographer and all of that. So that's.
Mr.
So
Chairman,
just to clarify,
All right,
we can't have someone
Mr.
just
Askin's
walk
time's
in.
expired.
Mr. Chairman, point of
Do any
inquiry.
other members wish to be heard?
Mr. Chairman, point of inquiry.
Mr. Chairman, I did endure multiple interruptions in my opening. Could I finish? Would that be all
Well,
right?
you went over your 5 minutes, but I'll give you 30 more seconds.
Okay. The chairman refused to take yes for an answer from Hunter Biden. Instead, on December 1, they pulled a bait and switch. They changed the terms of their request. They rejected his offer or his acceptance of their offer and insisted that he now come in and sit for a secret closed-door deposition. On December 6, Hunter Biden's lawyer reiterated that Hunter Biden was willing to accept the chair's original request and once again offered to appear on December 13th or any other date in December to answer any question pertinent and relevant to the subject matter. He again raised concerns about closed-door sessions. That's what brings us to today, Mr. Chairman. He has materially, substantially, in good faith, complied with what your requests were.
He complied with the subpoena. I don't think he complied. All right,
We
your
would have
time's expired.
We
Do
would have
any-
loved that.
Do
kind
any
of
other members
compliance.
wish to be heard?
Mr.
Chair
Chairman.
recognizes Ms. Mace from South Carolina.
Thank you, Mr. Chairman, Chairman Comer. First of all, my first question is, who bribed Hunter Biden to be here today? That's my first question. Second question, you are the epitome of white privilege, coming into the Oversight Committee, spitting in our face, ignoring a congressional subpoena to be deposed. What are you afraid of? You have no balls to come up here and...
Mr. Chairman, point of inquiry.
Mr. Chairman,
If
The ladies recognize.
I'm not
If the gentlelady
Playing
wants to hear from Hunter
stupid
Biden,
games.
we can hear from him right now, Mr.
And you
Chairman. Let's
win
take a
stupid
vote and
prizes.
hear from
I'm
Hunter Biden.
speaking.
What are you
women
afraid
allowed
of?
to speak
What are you
in
afraid
here?
of?
Hold on.
Why-
Order,
why are you
order,
guys not
order.
willing to let
Ms.
Are
us
Mace,
women
finish
allowed
the
to
hearing?
speak in
All
here
right.
or no?
Okay.
Are women allowed to speak in here or no?
Order.
Because you keep interrupting me.
I'll interrupt the
You keep
chairman. I don't know
interrupting.
that he's a lady.
I think that Hunter Biden should be arrested right here, right now, and go straight to jail. Our nation is founded on the rule of law.
Come
And
on.
the premise
Come
that the
on.
law applies equally to everyone, no matter what your last
Point of order,
name.
Mr. Chairman. Point of
It
order.
doesn't matter who you are.
Point of order, Mr. Chairman. Biggs over here.
Donald Trump Jr.
Biggs over here.
State your point, Mr. Biggs.
Yeah, my point of order is this. Are we going to continue on with this blatant interruption? This is absurd and inappropriate. I intend to give my statement. I don't intend to have anybody interrupted. I'm not going to interrupt your statements. I think you should have decorum and courtesy and don't act like a bunch of nimrods.
You just interrupted a woman.
And that's 5,
I got
Can
permission.
we
I did-
agree everyone has
Mr.
5
Chairman,
minutes? Can we agree?
Point of order again. The assertion that I interrupted was absolutely false. That's typical of the gentleman who spoke it. I got permission to speak from the chairman. I spoke. I was interrupted yet again by the gentleman who doesn't choose to go through the chair and follow proper order. I encourage us, I think if we're going to have any respect at all, we need to have proper decorum.
Well said, well said.
I'd like to finish.
The rules are everyone's going to be recognized for 5 minutes. Anyone that wants to be recognized will be recognized for 5 minutes. Ms. Mace has 4 minutes and 13 seconds left. Chair recognizes Ms. Mace.
It does not matter who you are, where you come from, or who your father is, or your last name. Yes, I'm looking at you, Hunter Biden, as I'm speaking to you. You are not above the law at all. The facts in this case are crystal clear. This committee used and issued a lawful subpoena to Hunter Biden, a critical witness in this committee's investigation into Biden family corruption. Hunter Biden and his lawyers did not claim privilege of any kind because clearly he has none. They didn't contest the legitimacy of our reasons for issuing this subpoena, no reasons, because they clearly are legitimate. And yet, he refused to comply. Trump's family members, Don Trump Jr., he did not defy a congressional subpoena. He showed up multiple times for multiple depositions for several hours. In doing so, Hunter Biden broke the law. He did so deliberately. You did so flagrantly. You showed up on the Hill, on the Senate side, the day of that congressional subpoena to defy it and spit in the face of this committee. That's what you did. The question the American people are asking us is, what is Hunter Biden so afraid of? Why can't you show up for a congressional deposition? You're here for a political stunt. This is just a PR stunt to you. This is just a game that you are playing with the American people. You're playing with the truth. Hunter Biden wasn't afraid to sell access to Joe Biden to the highest bidder when he was in elected office. He wasn't afraid to trade on the Biden brand, peddle influence, and share those ill-gotten gains with members of his family, including Joe Biden. He wasn't afraid to compromise the integrity of the presidency and vice presidency by involving Joe Biden in shady business deals with our foreign adversaries. But Hunter Biden, you were too afraid to show up for a deposition. And you still can't today. I believe that Hunter Biden should be held completely in contempt. I think he should be hauled off to jail right now, because it wasn't long ago, too, my friends on the other side of the aisle, that you also believed in the power of a congressional subpoena. Not long ago at all. You believed in holding those who refused to comply with a congressional subpoena accountable. And I stood with each and every one of you. I am the only member in this room today who has held a member of my own party in contempt of Congress for not showing up for a subpoena. And I see nothing but complete hypocrisy on the other side of the aisle. The ranking member of this committee even so eloquently put it, the lesson is, please tell your children out there in America, if you get a subpoena to go before Congress, go. You have a legal responsibility to do so. So the hypocrisy is stunning. What are we to tell our children today? There's nothing the other side can say with a straight face. As the only member of this committee to vote to hold a member of contempt of my own party, let me be clear, this should not be a partisan issue. If Congress issues a subpoena, you show up, period. This is not a responsibility we take lightly. It brings no joy for us to do this, but the president's son broke the law and must be held accountable in the same way anybody else would. I urge my colleagues on both sides of the aisle to do so. And my last message to you, Hunter Biden, you play stupid games, you win stupid prizes.
Will the gentlelady yield for a question? Will the gentlelady yield? Will my friend yield from South Carolina?
Sure.
I do want to commend the gentlelady who was the only Republican who stood up and voted to hold in contempt the Republican members of the House who blatantly and categorically refused to comply with subpoenas that came from the bipartisan January 6th committee. I would like to ask my friend, Ms. Mace from South Carolina, whether she's aware of all the case law which says that the committee has to engage in good faith interaction with the witnesses they've called, and they're supposed to arrive at a solution. And what do you think about the fact that the chairman on multiple occasions gave this witness the opportunity to come before the full committee, and he agreed to that?
We issued a congressional subpoena, and I know with your constitutional law background, you know exactly what that means, and he should have showed up. And because of your vote and because of your statements, you should be voting to hold this man in contempt of Congress today, right now, if you're going to be consistent on your own policies and your own words.
Gentlelady's time's expired. Chair recognizes Mr. Moskowitz for 5 minutes.
Thank you, Mr. Chairman. It's good to see you after a long break. So I'm listening to the gentlelady from South Carolina about the witness being afraid to come in front of the committee. It's interesting. He's here. He doesn't seem to be too afraid. In fact, for some reason, the chairman, who on multiple occasions invited the witness to come on TV, apparently the chairman wants to pretend like his statements on television or in interviews don't matter, but it didn't happen once, it didn't happen twice, it happened multiple times. The chairman said the witness can choose whether to come to a deposition or to a public hearing in front of the committee. The witness accepted the chairman's invitation. It just so happens the witness is here. If the committee wants to hear from the witness, and the chairman gave the witness that option, then the only folks that are afraid to hear from the witness with the American people watching are my friends on the other side of the aisle. I don't know if there's a proper motion, Mr. Chairman, but I'll make a motion. Let's vote. Let's take a vote. Who wants to hear from Hunter right now, today? Anyone? Come on. Who wants to hear from Hunter?
Motion's out of order. Yeah.
No one. So I'm a visual learner, and the visual is clear. Nobody over there wants to hear from the witness. Oh, there's one. Thank you.
Will you yield for a question?
I'm not there yet, but I will eventually. So there's no one, well, other than one or two, that want to hear from the witness. So the majority of my colleagues over there, including the chairman, don't want to hear from the witness with the American people watching. So, Mr. Chairman, I just want to hear from you. Will you acknowledge that you invited the witness on television to choose whether he could come to a public hearing? And do you stand by your words, or do you renege that invitation to the witness?
To answer the question, I've said repeatedly, after the deposition, Mr. Biden can come in front of a public hearing.
Mr. Chairman, I don't want to play the video, but that is not what you said on television multiple times. We have the quotes. We can put them up. You said the witness can choose between a deposition
Listen,
or...
Mr. Moskowitz, Mr. Biden doesn't make the rules. We make the
No, Mr. Chairman, you make the rules. And the rule you made is that he can choose.
the rule is...
Those were your words, reclaiming my time.
He was issued 2 lawful subpoenas.
Reclaiming my time, Mr. Chairman. No, you issued those subpoenas after he took you up on your invitation to come, and then you were like, oh, no, oh my God, what did I do? I invited him to come so the American people can hear his side of the story. I put my foot in my mouth, so now I must bury him in the basement where we can decide what we're going to release to the public so that we can continue to tell that story. Mr. Chairman, you have said multiple times that this is not about Hunter. It's about Joe Biden. And even this morning on Mornings with Maria, she asked another simple question, the question you have been asked multiple times, which is, do you have evidence to impeach the President of the United States? Before you said, I hope so. Today you said, I think so. And the answer is, you don't. And you still don't. And so we continue to be here and have these charades. To my colleagues who talk about lawful subpoenas, I appreciate the gentlelady from South Carolina who voted to hold people in contempt. Listen, I'll make this bipartisan. I'll vote for the Hunter contempt today. You can get my vote. You can get my vote. But I want you to show the American people that you're serious. Here is the subpoena to Representative Scott Perry, who did not comply. I'd like to enter this into the record. Here is the subpoena to Mark Meadows. I'd like to enter this into the record, who did not comply. Here is the subpoena to Jim Jordan, who did not comply with a lawful subpoena. I'd like to enter that into the record. Here is the subpoena to Mo Brooks, who did not comply. I'd like to enter that into the record. Here is the subpoena to Mr. Biggs, who did not comply. I'd like to enter that into the record. And here's the subpoena to Mr. McCarthy, who did not comply. I'd like to enter that into the record. There's an amendment coming to add some of those names into the contempt order. You vote to add those names and show the American people that we apply the law equally, not just when it's Democrats, right? It's a crime when it's Democrats, but when it's Trump and the Republicans, it's just fine. No, show that you're serious and that everyone is not above the law. Vote for that amendment, and I'll vote for the Hunter Biden contempt. I yield back.
Gentleman's time's expired. Chair recognizes Ms. Green from Georgia for 5 minutes.
Thank you, Mr. Chairman. Excuse me, Hunter. Apparently, you're afraid of my words.
Whoa! Oh.
I like to reclaim my time, Mr. Chairman.
Kind of burst their bubble. Wow, that's too bad.
I think it's clear and obvious for everyone watching this hearing today that Hunter Biden is terrified of strong conservative Republican women because he can't even face my words as I was about to speak to him. What a coward. And this is also a coward that sat right here in front of Mickey Babbitt, Ashley Babbitt's mother, who was murdered on January 6th by Michael Byrd, the Capitol police officer. And you want to talk about a committee, a political sham? I'll totally disagree with you, Ms. Mace. That January 6th committee was not bipartisan. It was a complete setup to go after President Trump, go after Republicans, go after anyone that believes in free and fair elections, people that believe the Department of Justice should be fair and balanced, not a political weaponized department of the federal government that is targeting President Trump, his supporters, people that walked in the Capitol on January 6th, and now people that stood outside the Capitol. There's been no justice for Ashley Babbitt's family. Michael Byrd has never been charged with anything. He was let off, and he was given a promotion and allowed to walk free. And Hunter Biden just walked out. That is an example of not following the law. Hunter Biden thinks he's above the law. Don Jr., Eric Trump, Ivanka, Trump family members had to come in to Democrat subpoenas and be questioned by Democrats for over 8 hours, each of them. Hunter Biden runs away. Hunter Biden did not come when we subpoenaed him. He did not follow the law. And then one of our colleagues helped him evade his subpoena by going and reserving a press conference for him on his behalf, helped him evade the subpoena, helped Hunter Biden break the law. Let's talk about his own father's words. President Joe Biden said in October 2021 that individuals who defy subpoenas from the January 6th House Select Committee should be prosecuted. And the Justice Department indicted Steve Bannon for doing so in November 2021. Hunter Biden's father, the President of the United States, said that he should be prosecuted. Anyone that defies a subpoena should be prosecuted. Hunter Biden didn't show up for his subpoena. Hunter Biden showed up today to make a clown show of himself, to show that he is nothing but someone that will not obey the law, that wants to show up when he wants to, and sits here with a smug look on his face and runs away when it's my turn to talk. Not only is he a criminal, but he is a coward. Nothing but a coward. Let's talk about voting for things. We have members on this committee that are on record on their own Twitter accounts talking about people blowing off subpoenas on the January 6th committee that states the rule of law is stirring all over America. That's Representative Jamie Raskin. Right here, I'll enter this for the record. Representative Jamie Raskin. Steve Bannon has been convicted of acting in contempt of Congress. My argument with Rep. Gates is now settled. If subpoenaed, you show up and assert any privilege you think applies to specific questions, but you can't blow off the proceeding. He blew it off. Walking in today is too late. We have to hold Hunter Biden in contempt of Congress because he's not above the law, and neither is the President of the United States. And this committee has produced more evidence than any Democrat ever dreamed of having against President Trump and his family, while they constantly make up lies and attacks about the Trump family and President Trump. They make them up all day long. It's nothing but a political witch hunt. This committee has produced the evidence that Joe Biden has taken payments through his son, Hunter Biden, and all their dozens of fake LLCs. You can't buy a Biden product. You can't hire a Biden for a service unless you're a foreign country and you're asking and paying for political favors and political payouts. And that is exactly what the Biden brand is all about. We will hold Hunter Biden in contempt. And if the Democrats are not the hypocrites that they constantly display that they are, then they will vote for contempt of Congress because they voted for it on every other subpoena that didn't go through. And here's the last thing. You guys had your chance. If you wanted to hold people in contempt of Congress, you could have done it last Congress, but you didn't do it, and it would have been a major mistake because you know that it could have been turned exactly back on you. Mr. Chairman, I yield.
Thank you, Mr. Chairman. I think it's really interesting to hear the gentlelady from Georgia speak about Hunter Biden leaving, and she is the person that showed nude photos of Hunter Biden in this very committee room, showing dick pics in this committee room of Hunter Biden. I have my 5 minutes, gentlelady, and so I think it's really ironic, hypocritical, quite shameful that the person who's complaining about somebody leaving when she's showing nude photos of him to this committee, showing nude photos of him to this committee in this very room. And you also talk about decorum. You're talking about January 6th. Ms. Green, I was there with you when we went to the January 6th jail, and when you were hugging, high-fiving, talking to, and providing so much comfort and joy to the insurrectionists that attacked our Capitol. And you were insurrectionists that attacked our Capitol. You were hugging and giving them all the support
Mr.
that
Chairman,
you
the
could.
gentleman
I'd like
has
to-
the time.
Stop the clock. Chair recognizes Mr. Garcia.
I'd like to continue
You
my
have 3 minutes and 50 seconds.
5 minutes. And I just want to remind everyone, that this is, again, about the Donald Trump revenge show. We're here today, and the majority is doing this hearing because this is all about Donald Trump and trying to make sure they do everything they can to support him. For weeks, we as Democrats and Republicans and the chairman demanded a public hearing, and I agree with Mr. Moskowitz. Yet, Mr. Chairman, you have denied it. We want a public hearing. If we need to take a vote or ask unanimous consent, we should hear from Mr. Biden today. That's what the public demands. Democrats are united. We like to see the same thing. And I'd like to see a vote to actually have Hunter Biden actually, with unanimous consent, do actually a hearing and address us today, if possible.
Would my friend yield?
Yes.
Thank you. Well, the fact of the matter is, Mr. Biden showed up this morning and was willing to show up weeks ago to appear at a public hearing, which he was led to believe was his option. And today is all about a combination of chutzpah and delusional theory. We just heard some of the delusional theory from the gentlelady from Georgia. But the chutzpah is a bunch of people who defied subpoenas themselves, now want to have a contempt citation for the son of the president because they don't have sufficient evidence. In fact, they have no evidence of any kind to pursue the president himself. So when you can't go after the principal, try to hurt the people around him, including a wounded member of his own family who has had all too public troubles put before our country. It's mean-spirited, it's cruel, and it's beneath the dignity of this committee and this body. If you want to have political differences with the President of the United States, our system invites it. But resorting to punitive measures against members of his family because you can't get at him, I think crosses a boundary. And by the way, I counseled Democrats in the previous administration to take great care in going after members of President Trump's family because I felt the same dynamic at work. So I would urge that we give real serious consideration to the matter at hand, that we show more respect for the president and his family, whoever that president may be at any given time, and that we respect due process and we hold ourselves to the same standard we are asking this body to act on today in terms of a contempt citation. We've let many of our fellow members off the hook in defying the January 6th subpoenas. I yield to Mr. Askin.
15 seconds.
Can I have the rest of my time? I just want to also, Mr. Chairman, I think Mr. Biden has agreed to address this committee publicly. I just want to ask unanimous consent to swear in Mr. Biden either today or at a future meeting and have every member be able to ask 5 minutes of questioning to the witness. So I'd like to officially ask that, Mr. Chairman.
Yeah, we object. That's not in order.
How is that not in order?
It's just not in order. Time's expired. Chair recognizes Mr. Perry for 5 minutes.
Thank you, Mr. Chairman. I'd just like to remind members of this committee and anybody watching that this is a duly constituted committee under the rules of the House of Representatives. Duly constituted. See Republicans on this side and Democrats on that side. The Democrats on that side were selected by their leadership and their process. Same thing for the Republicans on this side. Why do I mention that? Why do I bring that up? Because this is a stark difference from what is being referenced on the other side of the aisle. The so-called J6 committee, which was nothing more than a Soviet show trial in America. That's what that was. And so every single action that they took, subpoenaing people, disparaging people, referring charges of people, were not legitimate. Were not legitimate. So to compare what's happening today to what happened years ago is completely out of context, and you need to understand that. This is a game for these folks. Sure, they want to support their guy. They don't care about America. They don't care about what the president's doing to destroy America. They're just locking arms to support their guy. And God bless them, they can do that. If you want to vote for people that do that, that's your right. Now, in my opinion, this committee is not interested in prosecuting Hunter Biden. We're not interested in that. Hunter Biden is a sad tale by his own right, by his own admission, by leaving his evidence all around for everybody to see. The other side complains that documents and photographs are shown in this committee about Hunter Biden. Don't blame the person that showed the documents or the photographs. The person that committed the acts is the person who is responsible for the acts. And we do take no joy because it's a waste of time to prosecute Hunter Biden. But he created this for himself, along with the rest of his sad tale of his life, unfortunate that it may be. But we, in this committee, on both sides of the aisle, on behalf of the American people, are charged with finding the facts. And the facts show that President Biden profited from his name, and the person that arranged the deals was Hunter Biden. And so we would like to delve into that. Now, Hunter Biden, regardless of his last name, even though he thinks he's special, he thinks he can leave evidence all around and blame it on the Russians when he knows it was him. He can go on TV and say that he thinks he's special because his last name's Biden and that no one will touch him. Ladies and gentlemen, the great thing about America is that we're all special because the law is blind to each one of us regardless of our station, our economic position, or our political position. Hunter Biden sadly chose to violate federal law. That's unfortunate. But we are duty-bound to do something about it because without law, we have anarchy. And that's what Hunter Biden would like. By coming here today, he shows that he can be here. He shows that he displays that he could show up to a lawfully, legitimately presented subpoena. But he chooses not to, and that's his choice. He can do that. But there are consequences for that, ladies and gentlemen. There are consequences for that. And we are duty-bound.
Will the gentleman yield down here, Mr. Perry?
I will not yield. We are duty-bound. We are duty-bound to pursue the consequences of that so that the American people can trust in the system of justice in the United States of America, which they do not right now. They don't trust in it, nor should they, because this side of the aisle has made a mockery of it for the last 3 years and beyond that.
Will the gentleman yield for?
I will not yield. Mr. Biden is not special. He was given a subpoena. He should have appeared. He chose not to. We have no choice. We have no choice if we are to uphold our oath to uphold and defend the Constitution of the United States. We have no choice except to refer charges and find Hunter Biden in contempt. His choice. That was his choice. Now we have to make our choice. And conflating the so-called J6 committee, unduly authorized, not a committee, no jurisdiction, no authority whatsoever under the law of anything. To conflate that with these proceedings today is an abomination. My friends on the other side of the aisle know what they're doing, should be ashamed, should be embarrassed, but will not be. Regardless, we must forge on for the sake of this republic. I yield the balance.
Gentleman's time's expired. Chair now recognizes Mr. Goldman for 5 minutes.
Thank you, Mr. Chairman. I feel like I'm in Alice in Wonderland after that. Every American receives the same application of the law, and it does not matter what your last name is. So I guess that means if your last name is Perry, that subpoenas apply to you as well, lawful subpoenas. Now, I appreciate the gentleman from Pennsylvania's argument that the January 6th committee was not a duly constituted committee, and in fact, he and many others made that same argument to a number of courts of law. The courts are charged with interpreting our laws and whether a committee is a duly constituted committee and whether a subpoena is a duly constituted subpoena. And even though my friend from Pennsylvania may not like the fact that a neutral judge, multiple judges in fact, didn't agree with him, it still remains the law of the land, not what Mr. Perry says, not how I would interpret the January 6th committee, but how every single court of law interpreted it and said it was a validly constituted committee, and every single subpoena issued by that committee was a duly authorized lawful subpoena, no different than the subpoena to Hunter Biden.
Will the gentleman yield for a question?
No, unfortunately, sir, you did not yield to me, so I will not yield to you. The fact of the matter is that subpoenas should apply equally. And for my colleagues to actually claim that we on this side of the aisle are hypocritical because we will not vote to hold someone who has made every effort to comply in every way other than the specific means of providing the evidence is somehow should be held in contempt when 3 members of this committee refuse to comply in any way, shape, or form with a court-determined lawful subpoena is beyond me. Now, I find it interesting that my friend from Pennsylvania also chastises us for just supporting our guy. And I wonder how he would define supporting our guy. Would he define supporting our guy as trying to instigate a coup at the Department of Justice to install a lackey and remove the Attorney General and the Deputy Attorney General so that he could keep his guy in office even though he lost? Is that just supporting our guy? Because that's what Mr. Perry did. The reality is that we are here because, plain and simple, 2 reasons: retribution for Donald Trump and the fact that the Republicans have no evidence. And you will hear them talk about evidence. You will hear them say, we have so much evidence, we have so much evidence. And we're going to get into some of these details as we go forward. But the reality is that you have been moving the goalposts the entire time because you cannot make any connection, notwithstanding all of your false statements, to the president. So instead, let's subpoena Hunter Biden. Because what we will expect is that he won't testify, or that he'll take the Fifth Amendment because he's under criminal indictment. And then we get to say, aha, all of our specious allegations must be true, because if they weren't, he would come here and testify. Well, he called your bluff, and now you're scrambling. Will the gentleman yield to a
No, I will
question?
not. And now you're scrambling.
You sure?
Now you are desperate to find anything to divert attention away from your abject lack of evidence connecting President Biden to any business venture of Hunter Biden's, to any wrongdoing. So we're going to hold us here on a contempt hearing because you don't want to see him testify in public. You just want to be able to filter his testimony in closed-door testimony as you have been doing this entire Congress.
Will the gentleman yield?
I will yield to my ranking member. Thank you.
Thank you. The District Court for the District of Columbia, Judge Kelly, obliterated the argument that
Time's
Mr.
expired. Chair
that the gentleman
recognizes
from Pennsylvania made.
Mr. Biggs for 5 minutes.
Thank you, Mr. Chairman. At the risk of taking the bait, which is all this is, it's laying a little bait and might be just too attractive for me, so I got to get in on it, just a little bit. I'm intrigued by the assertions of my colleagues who claim that the Hunter Biden violation of the subpoena scenario is the same as issuing subpoenas to 4 members of Congress. I'm intrigued by that. I really am. It's interesting. Had the illegitimate J6 group decided to enforce its dubious subpoena against me, my counsel was prepared to argue that service of that subpoena was insufficient. And so asserted to counsel for the J6 committee. Had the illegitimate J6 gaggle sought to enforce its subpoenas, my counsel, and I believe the counsel of each member of Congress who had been subpoenaed, ostensibly subpoenaed, putatively subpoenaed, would also have asserted successfully a privilege under the Constitution of the United States. Those questions never arose formally because the now defunct J6 committee, which has no authority anymore because it passed with the closing of the last session of Congress. I think that cabal surely understood that its tenuous claims, how tenuous its claims were, and chose not to try and enforce its questionable subpoenas. And why do I say that? I say it because in reporting to Reuters, the committee's own chairman, Benny Thompson, said this, quote, "There are some questions of whether we have the authority to compel testimony from Republican colleagues." He knew you didn't have that authority, but yet you still tried to assert it. Now, what's the distinction? Well, Hunter Biden has no claim to insufficiency of service of process. Why do we know? Because he stood on the lawn of the Senate the same day that he was supposed to be here and asserted publicly, hey, I'm supposed to be somewhere else. I'm supposed to be giving a deposition, but I won't do it. I won't do it. Secondly, Hunter Biden has claimed no privilege against testifying before this committee or the Judiciary Committee pursuant to the subpoena, except for the privilege that he has claimed throughout his life. And as the LA Times said about Hunter Biden, quote, "Biden is still on the nepotism gravy train," close quote. As the Daily Mail reported, quote, "Hunter admits he got $50,000 a month job on the board of Ukrainian gas company Burisma because of his family name," close quote. And it goes on and on. Again, the LA Times describes Hunter Biden as a, quote, "child of privilege," close quote. That's the only privilege Hunter Biden has ever asserted. He asserts that not that he should be exempt from testifying because there is some constitutional proscription, that even the chairman of this committee would agree to, as Benny Thompson agreed to on the J6 committee's issuance of subpoenas to members of Congress. No, he doesn't assert that kind of privilege. He asserts only the privilege that he does not need to come and testify before the United States Congress, who has issued him a subpoena. His attorneys acknowledge that subpoena, and he personally has acknowledged that subpoena for the simple reason that he is a Biden. So, where are we? Merrick Garland has authorized pursuing Republicans for contempt of Congress. He must also authorize prosecution of Hunter Biden. Failure to do so on the part of the Attorney General will show his contempt for Congress as well. But it will show even greater contempt for the American people who now recognize the weaponization of the federal government and the two-tier system promulgated by Democrats. Mr. Chairman, to Mr. Thompson's, to former Chairman Thompson's questioning of his own authority to actually issue subpoenas to members of Congress, Chairman Jordan requested legal analysis and authorities. But Chairman Thompson never responded. That committee could have pursued contempt if they thought there was valid subpoenas issued and a contemptible warranted contempt citation. They chose not to. Their authority expired, and ours is not expired. We should issue contempt. I yield back.
Gentleman yields back. Chair now recognizes Mr. Conley.
Thank you, Mr. Chairman. 3 names: Jordan, Perry, and Biggs. Not a law firm. 3 members of this body who defied a legitimately issued subpoena upheld by courts of law. I think it's really important to remember that when the word hypocrisy is thrown around by some of our friends on the other side of the aisle. The other thing I think that's really important, before I yield to the ranking member, Mr. Biden, Hunter Biden, knows that if he appeared in camera and in secret to be deposed, Republicans would cherry pick what he said and leak it. He preferred sunshine. He preferred to come here out in the open and testify before the entire American public, this body, and everyone watching, and take his chances with public testimony that could not be used to his detriment by cherry picking and distortion. That is and ought to be the right of an American citizen. I yield to the ranking member.
Thank you kindly, Mr. Conley. I wanted to introduce for the record, Mr. Chairman, United States District Court for the District of Columbia opinion in RNC versus Nancy Pelosi, rendered by Judge Tim Kelly, rejecting, obliterating, and demolishing every argument that we heard from Mr. Perry and Mr. Biggs. Their whole argument seems to be that Republicans were entitled to blow off subpoenas of the United States Congress that came from the January 6th committee because they didn't like the committee, they didn't think it was legitimate, they thought it was not validly authorized. The courts roundly and uniformly rejected those arguments. So now they purport to render the law for themselves. If they don't want to comply with the subpoena, they won't, and yet they would now hold other witnesses like Hunter Biden to a standard they won't accept for themselves. That's a remarkable thing. I started off this hearing, Mr. Chairman, by saying we believe that everybody should respond in good faith to the subpoenas of the United States Congress. Now, Mr. Biden asserts that he responded in good faith to what you repeatedly publicly asked him to do. And he's at least got an arguable, colorable claim that that's true. All the case law I've been able to read, Mr. Chairman, suggests that the committee is supposed to engage in good faith negotiation with witnesses, which is precisely what the January 6th committee did. The dates don't always work out. The times don't always work out. Some people want to assert a privilege. Some people don't. There are certain questions that are agreed to or not. So there are negotiations. But as I read at the beginning of this
Will
hearing—
the gentleman take a question?
But I will as soon as I get to that.
Excuse me, it's my time.
Oh.
Mr. Raskin.
Thank you, Mr. Conley. Why is the committee not engaged in that negotiation with Hunter Biden? I just don't understand that. I mean, he's a guy who appears to be 99% willing to do what you even asked him to do in the written subpoena, but he's given 100% good faith compliance with what you repeatedly publicly challenged him to do. So I don't understand why you won't meet with them and work it out, which is what every court in the land has said. The courts don't want to be involved in all this stuff, especially when you've got a guy like him who's overwhelmingly complying with what you're asking for, unlike all of these colleagues on the other side of the aisle who unfortunately 100% defied the subpoenas of the United States Congress, which is what they did. And I don't think those people should be able to vote on any subpoena relating to any witness in this committee until they render cooperation with the January 6th committee and come forth and tell us what they know. Now, there's another point that I need to make, and I want to thank Mr. Connolly for his indulgence here. Our good friend, the gentlelady from Georgia, referred to the murder of Ashley Babbitt. Well, the Department of Justice, the United States Attorney, and the U.S. Capitol Police Inspector General all rejected the idea that there was any
Point of
murder.
order,
There was
Mr.
no-
Chairman. Or inquiry.
There's no such thing.
There's never been a court hearing.
Mr. Chairman, we agreed.
Michael Byrd was
hold
never
on.
charged.
Reclaiming order here. The time is Mr. Conley's. I yield back to Mr. Conley.
Thank you, Mr. Chairman.
But I will submit for the record a document entitled Department of Justice Closes Investigation into the Death of Ashley Babbitt, United States Capitol Police. Document USCP completes internal investigation into the January 6th officer-involved shooting. I think it was a scandal. It was a tragedy that people died because Donald Trump put them at risk, as many of the former insurrectionists are now willing to say publicly, that he said you got to go and you got to fight and fight like hell, or you will not have
Time's expired, Mr. Conley's time's expired. Mr. Conley's time is expired. Mr. Conley's time is expired. Order, order.
I was trying to reclaim the time the gentlelady stole from me.
Oh, we stopped the clock. I watched it. I'm paying close attention. I do feel compelled to respond to this. We have engaged in good faith negotiations. We've offered every witness a narrow scope of topics, documents in advance. They can choose the date. Hunter Biden's lawyer has not engaged with the committee regarding Hunter Biden. Chair now recognizes Mr.
Did you respond
Waltz,
to their
our
letters
newest
to
member,
offer to
for 5
cooperate,
minutes.
sir? Mr. Chairman, did you respond to the lawyer's offer to cooperate with the committee and meet with the committee?
Do what? Yeah, Chair recognizes Mr. Waltz for 5 minutes.
Thank you, Mr. Chairman. This is an incredible first hearing with this committee.
Welcome to the Oversight Committee.
It was, but this was entirely predictable. I think what we were going to hear and see today. We saw that Hunter came and staged a PR stunt with my friend from Florida, Mr. Moskowitz. That was clearly organized and recognized. But what I'm hearing from the ranking member and his colleagues that claim that transcripts are subject to, quote, partisan and twisted leaks and distortions is incredibly rich. Let's talk about calling the kettle black first. The country suffered through an entire impeachment proceeding of a president of the United States because of a false dossier in a SCIF, a compartmented facility where every hearing and every transcript started with, this is an unclassified proceeding, then to have it selectively leaked and lied to the American people, to the great damage to this nation, but then bring it to this committee because I'm new. I watched yesterday as committee Democrats continued to spin false narratives, several of which went out just yesterday as interviews were ongoing with Hunter Biden's art dealer, which is rich in and of itself, that Congressman Golden on the other side of the aisle went to the press during the interviews and spun a narrative while it was going on, but he conveniently omitted that 70% of the art buyers were Biden donors. So we can go down the line and talk
That's
about
false, sir.
spin.
That's not the facts.
But the other thing that we're hearing today, well, member so-and-so, Congressman so-and-so, Congressman Jordan, they didn't comply with their subpoenas. But let's have a quick lesson on the Constitution. Article 1, Section 6 of the Constitution, the Speech and Debate Clause, essentially protects all of us from abiding by each other's subpoenas. Otherwise, this body would do nothing but subpoena each other. So I would encourage my colleagues to look up Article 1, Section 6 and look at the case law of the Speech and Debate Clause and why my colleagues rightfully did not abide by that subpoenas. But let's talk about precedent for a moment of a president's son abiding by lawful subpoenas of the Congress. Donald Trump Jr. came before this body. He came before the House Intelligence Committee. He came before the House Judiciary Committee. He came before the Senate Intelligence Committee twice. He came before the so-called Jan 6 Committee, all behind closed doors where lawyers can sit down, both sides of the aisle, and have a conversation, go through documents, all under oath, which is the precedent for any committee. Don Jr. came before committees and came before this body 5 times behind closed doors. What is Hunter Biden afraid of? What won't he do? And Ranking Member Raskin, you're going to reap what you sow, my friend. I mean, you insisted on depositions for those who appeared before the Jan 6 committee when Steve Bannon agreed to testify publicly. You argued, sir, that he should have to sit for a closed-door interview, just like every other witness. Quote, the way we have treated every single witness is the same. They come in behind closed doors. They talk to the committee there. You said on an interview in front of CBS in 2022, but now that Republicans are doing the same process, following House rules, doing the investigating, somehow Hunter Biden, because he's a Biden, should be held to a different standard. At the end of the day, we had a government official and the President of the United States, a vice president, set up 30 shell companies. Why? What product did those companies sell? Nothing. Vice President Biden was charged with 2 countries in his portfolio, China and Ukraine. While the vice president, his son, traveled on official business on Air Force Two and received massive monetary contributions afterwards. We have laws in place, colleagues, that prevent foreign powers from influencing government officials. Were policies changed as a result of the dinners, the calls, the text messages that we know President Biden engaged in through his son? We have a duty to get to the bottom of it. We will reference this contempt, and we will see if the Attorney General will uphold a fair standard of the law.
The time's up, Mr. Chairman.
And prosecute Hunter Biden.
Time's
Thank you, Mr.
expired.
Chairman.
Chair now recognizes Ms. Crockett for 5 minutes.
Okay, all right. So we love the Constitution today, and we also want to talk about foreign money coming in. Have y'all seen the report that was just produced where this chairman decided that he was going to block this committee from receiving additional information about y'all's guy, Trump, and all the money that he took? From what we did receive, we know that Trump got almost $6 million that we can account for, and we know that there's more there. From China specifically, we found almost $8 million total that he accepted from foreign governments while he was serving as the president of these United States. But we're concerned about the president's son who has not been involved in his administration. I just want to run it back, though, to the very beginning, because this is something that I just can't get over. I can't get over the gentle lady from South Carolina talking about white privilege. It was a spit in the face, at least of mine as a black woman, for you to talk about what white privilege looks like, especially from that side of the aisle. And let me quote your now ousted speaker and what he had to say about the Republican Party and y'all's lack of diversity. When you look at the Democrats, they actually look like America. When I look at my party, we look like the most restrictive country club in America. So let me tell you something. Y'all don't know what white privilege looks like, but I'm gonna show you a little bit of something. You see, you want to talk about a 2-tier justice system, and this is the only time that y'all have ever referenced it, when this country has a history when it comes to black and brown folk of having 2 separate sets of rules. And right now what you want to do is have 2 separate sets of rules because Mr. Moskowitz offered y'all a fair situation. He said he would vote for Hunter to be held in contempt if y'all voted to hold all, even if you remove all of the members of Congress. There's still other people that y'all haven't decided that y'all have excuses for, but y'all don't want to hold them in contempt. But for some reason, it makes sense to hold Hunter Biden in contempt, who has tried to comply. And let me tell you why nobody wants to talk to y'all behind closed doors, because y'all lie. That's just the bottom line. You have done it thus far in this investigation. You have done it this far as it relates to this committee. In every single hearing, y'all spin, spin, spin. I don't know how y'all are still standing right now, because you should be quite dizzy from all the spinning that you're constantly doing when it comes to spinning the truth. You talk about free and fair elections, but you back a guy who we know tried to steal the election. And this isn't about what Democrats have to say. Let me remind you, for those of you that don't know how the justice system works, it's not a matter of the president went in and indicted Trump, but we are
talking about grand juries. Grand juries are comprised of American citizens, and the people that have entered pleas of guilty that will be flipping on your leader in a minute, they are Republicans. I do want to point that out. And half of them were Republicans that were handpicked by Donald Trump himself. So, to be clear, whatever happens to your little leader, it's going to be because of the actions that he took. So you can talk all you want to about how January 6th was nonsense, but all of y'all were running at that time. Y'all were grabbing y'all's gas masks and y'all were running to your offices because you didn't know if they were coming to kill you. You should have cared that somebody was there to protect you, but instead you want to play games because you found out that it was your leader that decided that he wanted to propagate an insurrection on our country. So don't tell me that you care about the Constitution, because you don't. All you care about is Trump getting reelected, and I'll yield the last of my time to my leader.
Thank you very much, Ms. Crockett, for your eloquent and powerful and irrefutable remarks. I'd like to just add a couple of points to what you've said. On January 6th, Senator Ted Cruz described it as terrorism. They later came to attack him during their revisionist, Orwellian, Stalinist attempt to rewrite history. Unfortunately for them, we know that there were 147 or 48 of our officers who were wounded, bloodied, and hospitalized by the rabid mob that beset the Capitol that day. We know that Kevin McCarthy, one of their deposed leaders over on their side, called Donald Trump from his office to complain about how his people were storming the Capitol and putting people's lives in danger. And Donald Trump said, no, those aren't my people, those are Antifa. And McCarthy corrected him and said, no, those are your people, Mr. President. To which Donald Trump said, well, maybe they just care a little bit more about who won the election than you did, Kevin McCarthy. You guys have got to deal with reality here. By the way, the speech and debate clause stands for the exact opposite principle who our distinguished new member just spoke about a moment ago. It says that members of Congress cannot be questioned anywhere else other than Congress. So he should read the speech or debate clause aloud.
Let him finish his sentence there. Now, Chair recognizes Mr. Burchett from Tennessee for 5 minutes.
Thank you, Mr. Chairman. My colleagues seem to want to talk about the justice system, so let's talk about it. November of last year, the chairman issued a subpoena to Hunter Biden to appear on December 13th, for a closed-door deposition. Instead of respecting the rule of law, Hunter Biden chose to give a press conference on the front steps of the Senate. To show such contempt for Congress without fear of repercussions highlights a theme throughout this administration and Democrat administrations before it. If you're a big-name Democrat, then you are immune to prosecution. Former Attorney General Eric Holder said as much in a memo he wrote regarding collateral consequences. For those who don't know, the collateral consequence policy allowed prosecutors to consider whether charging a company or individual will result in greater societal harm than not charging them. It's why the banks weren't held criminally accountable to the fallout of the 2008 financial crisis. It is why Jeffrey Epstein's clients aren't behind bars. It's also the mindset of President Biden and his family. Too big to jail. Not too big to fail, too big to jail. The two-tier justice system is a disgrace to our country and the principles it was founded on. I thank the chairman and the committee for the hard work they put in to hold the Biden administration accountable, but I doubt our Justice Department has the guts or the wherewithal to do anything about it. And I would like to yield my time to my friend from Florida, Byron Donalds.
Actually,
I'll yield. Let me yield to Miss May. She hasn't gotten enough quality TV time today, so I'll give her a little more time.
Thank you, and then I'll yield to my colleague from Florida as well. I'm going to try to be quick here because I was accused by my colleague on the other side of the aisle about my white privilege. I want to say, number one, as the former ranking member of the Civil Rights Subcommittee under Chairman Raskin last session, I take great pride as a white female Republican to address the inadequacies in our country. I come from a district where rich and poor is literally black and white, black versus white on most days. My largest jail in my district, which is the largest jail in the state of South Carolina, has had 7 or 8 deaths in the last 2 years. And I was there with our black and African American council members trying to get the right thing done. And I come from a district where black men have been killed by law enforcement, tased to death in our jails, and I've stood with those black families because I know the differences that they see day to day in their life, and I try to do the best that I can. I come from a district where the first African American, first black man in the U.S. House of Representatives was Joseph P. Rainey, represented my district back in the 1800s with that. The last black member of the U.S. House of Representatives before Reconstruction came from South Carolina, George P. Murray, the black man, former slave, and entrepreneur who founded the Republican Party in South Carolina. One of the founding members was named Robert Smalls, who commandeered a Confederate ship and gave it to Union soldiers and served his country admirably in the process. In my district, it was Harriet Tubman, and you can see it in the movie Harriet, who rescued more than 700 slaves in one night in Beaufort County, South Carolina. So I am very well aware of our rich history and try to recognize it as best as I can in the position that I have, and I resent the fact that you're going to throw that in my face up here. I'm one of the few people that you'll see on my side of the aisle trying to do the right thing for the right people every single day, and I would like to yield the remaining balance of time to my colleague from Florida.
This has been a very interesting hearing. Mr. Waltz, welcome to Oversight. Yes, it usually gets like this. Look, let's be very clear. This isn't about Hunter Biden's white privilege. It's about Hunter Biden's Democrat privilege. Because Donald Trump Jr. showed up for 5 congressional subpoenas. There was never this circus where he was subpoenaed by House Democrats and he showed up on the Senate side or showed up at the White House to answer in some fake, phony, lame press conference, not actually going to the House and doing what he was compelled by a subpoena to do. Hunter Biden did that. And then he has the unmitigated gall to show up here when we know that we're going through actually the legislation for contempt, with, by the way, Mr. Chairman, we should actually get to the legislation of contempt. The speechifying is great, but let's do our business, members. He has the gall to come here, show up, and then when the Democrats are saying, hey, he wants to speak, he leaves. This is a joke. This is a farce. The man has been subpoenaed by Congress. Oh, and by the way, the January 6th committee, Mr. Raskin, which you did sit on, by the way, that was not a normally ordered committee of Congress because Nancy Pelosi did not want the Republican members that then Leader McCarthy put up.
According to the courts, it was.
My time, sir.
Will you yield for a correction?
I was respectful of your time. I didn't say anything. So, ladies and gentlemen, let's move forward with our business. He should be held in contempt. There was a subpoena. He did not answer it. Any other American will be held in contempt by Congress. Any other. This is Democrat privilege of the highest order. Let's do our jobs. I yield.
Gentleman yields. Chair now recognizes Ms. Ocasio-Cortez from New York.
Thank you, Mr. Chair. Just to address briefly, quickly, that moment about privilege and all of this that we're seeing here. It was a very beautiful speech by the gentlelady, who, as she mentioned, was helped lead on the now majority side, the Civil Rights and Civil Liberties Subcommittee. But I think it's so exemplary of the point that she also oversaw the elimination of the Civil Rights Subcommittee on this committee, which really kind of gives the whole game away. We show up, we give speeches, we give flowery words, but at the end of the day, participate in the structural erosion of the rights and representation of people that are marginalized, women, people of color, people that just need to see their due process and civil liberties protected in this country. But I will move on. As also the Republican side had mentioned in their many raisings of the January 6th committee, that it's not just Hunter Biden, you, me, any individual subject to equal treatment under the law, to be held up to accountability under the law, but it is also these committees and this committee that is subject to oversight and law. We must comply with the law here as well. Now, I may be one of the very few people that actually believes in Congress, in this country, but I do, and many of us do here. And we have an obligation to engage in good faith participation to execute and comply with a subpoena. The chairman said in front of the country several times to Hunter Biden, you can show up here in front of the world, in front of the public. Hunter Biden took him up on that offer. He said, I will show up in public. I will show up in public. He showed up here today. He showed up here in the past. And Mr. Chairman, I know you do your best with what you've got, but you've got members here that have submitted falsified evidence to the record. You have members here that have submitted and mischaracterized closed-door hearings, and people want to say back and forth at the end of the day. It doesn't matter what party it's happened from. You've got members who've engaged in revenge porn in this committee. So it is understandable why Hunter Biden would want to testify in front of the public for the American people to be able to witness that testimony for themselves. You've got members who've defied subpoenas. You've got members who we are 1 year into the term asking what the rules are at the beginning of the committee. The book was given to us on day one. And so what we should do is allow the man to testify. I believe in the power of the Oversight Committee. Frankly, I believe in it regardless of whether Republicans or Democrats have the chair, because I believe that this committee should have the power of oversight, and we cannot do that on a partisan basis. And so for that, I implore this committee to allow Hunter Biden to testify publicly. I implore and I ask for that to happen. And we cannot do that by getting engaged in this back and forth on a defiance of the subpoena. Let him comply. Let him do it today. Let him do it tomorrow. But let the man do it. And with that, I yield back to the ranking member.
Thank you, Ms. Ocasio-Cortez. I think you went right to the heart of the issue here. If this ended up going to court, Mr. Chairman, and I hope it doesn't, I really hope that this committee will act in a way to negotiate and achieve a compromise with the witness. But if it goes to the court, it's going to present a novel question. What happens when a committee represented by its distinguished chairman goes out in public and repeatedly invites and challenges a witness to come before the committee, and then that witness gives the answer, yes, I will come in? At that point, the committee pulls a bait and switch and says, well, we actually don't want you to come before the full committee as was offered repeatedly in public by the chairman, but instead, we'd like you to come to a back room and do it there in a closed deposition. Now, undoubtedly, if that had been the original offer, the committee would stand in a very good place, the way we did with Mr. Biggs and Mr. Perry and Mr. Jordan, because they were told to come in, they were subpoenaed, and they blew off the subpoenas of the committee, which is why I don't think anybody should be voting on that side other than Ms. Mace, because Ms. Mace is the one who took the position that the rule of law means something. And I take the position, if we give somebody a subpoena, they should come in. But there's a very sticky problem now. What happens when we give them one offer A and then switch it over to offer B? That's why I hope you will work it out, Mr. Chairman. Thank you for yielding.
Gentlelady's time's expired. To respond to the gentlelady, he can come in for a hearing after the deposition. Chair now recognizes Ms. McClain for 5 minutes.
So I just want to bring everything back home. This hearing is a contempt of Congress hearing for Hunter Biden. It's not about January 6th. It's not about Mr. Perry. It's not about white privilege. It's a contempt of Congress hearing about Hunter Biden. Although I appreciate the diversion tactics, like my colleague from Florida said, let's get back to our business, which is actually the contempt of Congress. I also want to thank my colleague, Ms. Cortez. I agree. Let him comply, right? Let him comply. And with our ranking member, let's follow the rule of law. So in contrast, let me read the rules of the committee real quickly. It's on page 9 of the rule book, right? And it talks about notices. Notices for the taking of depositions shall specify the date, the time, and the place of examination. Depositions may continue from day to day. Then you go to section D. Consultation with the ranking minority member of the committee shall include, listen for it, 3 calendar days notice. So although I'm sure any defendant would like to come in and say, Judge, I want to come in on this day, and the defendant is going to tell the judge and the legal system how the trial is going to run, unfortunately, that's not how it works. It's really simple. So I do agree with you. Let him comply. Let him comply with the subpoena that we gave him. He chose not to. So therefore, we are holding Hunter Biden in contempt of Congress. And I would also like to say, you had the opportunity when you all were in charge, or y'all were in charge, to do the same with the members on our side of the aisle. You didn't do that. That's not our fault. That's yours. So we're here to talk about Hunter Biden. For everyone watching today, and for my colleagues on the other side of the aisle, I want to be clear again what this hearing is really about. Hunter Biden was subpoenaed to answer Congress, right? That's it. Questions. But he violated federal law by failing to appear before the committee. You can't spin that, for my colleague on the other side of the aisle. You can't spin that. The bottom line is, Hunter did not show up, and he committed a crime. You see, we are a land of laws, and we must follow those laws. And that's what we're here to do today. Instead, he was on the grounds of the U.S. Capitol where he made a public statement without taking questions from the media, conveniently. So instead of showing up for his legal obligation, he showed up just steps away from a hearing room to spit in the face of this Congress. And unfortunately, that is Hunter Biden's MO. We're merely doing our job. What we're doing here today is showing the country that Hunter will not receive special treatment due to his last name. It's very, very simple. And he will be held to the same standard that every other American citizen would be expected to do. Can you imagine if you're average America and you get a subpoena and you go in and tell the judge, hey, let me tell you, here's how it's going to work, judge. I'm not showing up. I'm not showing up. I'm going to do it my way. I know we have laws, but don't worry about those laws because that would never fly. But that's exactly what Hunter Biden's doing. And if we care about this institution, if we care about democracy, at some point in time, we have to hold the law and people who break the law accountable. Or, like my colleague said, we are going to have anarchy. So simply put, it's not about anything else. We're talking about Hunter Biden and his non-compliance. And you can get up and scream and holler and rant and rave and talk about everything but the fact we subpoenaed Congress legally Hunter Biden, and he chose not to show up. Read the rules. He has to follow the law. I know that's a very foreign concept, but you have to do it. And for the Biden family, you too have to follow the laws. And with that, I yield back.
Gentlelady yields back.
A quick parliamentary inquiry, Mr. Chairman.
Yes.
The gentlelady makes an excellent point about the 3-day notice requirement for subpoenas. I don't think that's ever been complied with in this committee. Will you commit to?
That's not my issue. I'm just reading the laws.
No, it's my time, Mrs. McLean. Thank you so much. Would you commit to honor the 3-day notice requirement that Mrs. McLean properly invoked?
Would I comply?
I'll say this to answer the ranking member's question, then I'll recognize Ms. Stansberry. We have complied with the.
And you, okay, well, we might have a dispute about it, but you will continue that going forward. You will continue going forward.
We have followed the
That's my
rules.
question. Will
We
you
don't
comply?
have the chair, Mrs. McLean, and you don't have the time.
We have followed the rules. This is,
it's simple.
Chair now recognizes Ms. Stansberry.
Thank you, Mr. Chairman. Well, it's always a wild and interesting adventure here in the Oversight Committee, and this morning certainly doesn't disappoint. I want to talk for a few moments about the resolution that's been proposed in the ANS here, because that's what we're here to debate this morning, and really the content of that, including the assertions about the investigation that led to the moment that we're at here today. But I am really glad that my colleague mentioned that we are a land of laws and that every citizen should have to comply with them, including members of this committee, not to mention a chairman, who was subpoenaed during the last Congress and refused to respond. So if we're going to apply these laws, then they must apply equally, I would think, to even members of this committee, and certainly to the frontrunner in the GOP's presidential election, which I'll get to in a moment. But let's talk a little bit about this ANS and about the background and correct the record a little bit. First of all, I want to talk about the evidence that was presented to this committee as part of this investigation. More than 62,000 pages of records from the National Archives on top of 20,000 pages that were already made publicly available, 30,000 pages of private bank records, 2,000 pages of activity reports provided by the Treasury Department, dozens of hours of testimony from special counsel, U.S. attorneys, DOJ officials, FBI, IRS agents, financial advisors, friends, business partners, evidence provided by the Ways and Means Committee, and expert witness testimony by the GOP's own witnesses right here in this committee in September, who sat right there at that table and said there was not sufficient evidence to support proceeding with an impeachment. In fact, there are numerous members of the GOP currently serving in Congress who do not believe there is sufficient evidence. So my question is, where are the receipts? You have reviewed thousands of pages of documents, countless hours of testimony, talked to expert witnesses, including your own witnesses, that can't provide a single iota of evidence of wrongdoing by this president. But last week, House Democrats released this. We have the receipts. In fact, they're all right here in the Mazars report. And for any of you that have not dug in on this report, I want to talk a little bit about what this report shows, because it's actual receipts from foreign governments who spent $7.8 million at Trump properties during his presidency while they were actively seeking to influence foreign policy and decisions by the administration.
Will the gentlelady yield to the question?
Let's talk about some of the receipts that are in here. Malaysia, over $250,000 was spent by representatives of Malaysia while their ex-president was being investigated for a massive corruption scheme, and which Trump's ex-fundraiser was indicted for illegally lobbying on. Saudi Arabia, tens of thousands of dollars spent by the Saudi government and by the Crown Prince and his staff.
Do you yield to a question?
Later give $2 billion to Jared Kushner's private firm. Qatar, tens of thousands of dollars spent by Qatar during what was described as a charm offensive and an arms sale to the government of Qatar by the Trump administration. Kazakhstan, thousands of dollars spent by the president of Kazakhstan on a controversial visit which raised questions about human rights violations, business dealings, and a money laundering scheme involving Donald Trump's properties in New York. So my question is, if the GOP actually cares about criminal activity, how about they investigate the receipts that we have right here?
Can I answer that question?
Of influence peddling by Donald Trump, and a man who is currently facing trial in 4 jurisdictions on 91 counts of criminal activity, who's been twice impeached by this body and is currently trying to run for president again.
I would love to answer your question.
Of this committee has already endorsed. This is not factually based. This is a farce. This is a political stunt, and it is designed to help Donald Trump secure the nomination this November.
Will you yield to a question?
So let's call it what it is. And with that, Mr. Chairman, I yield my time back to the chair.
4 seconds.
4 seconds, 3, 2, all right. Time's expired.
Mr. Chairman, I ask unanimous consent to enter information for the record.
What's the information?
Oh, my God.
State the information.
Thank you.
I reserve the right to object. The minority has not provided a copy of the material for the record. In the past, she's displayed pornography. Is pornography allowed to be, or pornographic photos allowed to be displayed in this committee room, Mr. Chairman?
It's not pornography.
Okay, well, you're the expert.
I'm not an expert, Mr. Raskin.
Seems like it.
Mr. Chairman, I object to the unanimous consent
Mr. Chairman,
request.
Mr. Chairman.
All you need
I
is one
object.
objection.
We need decorum. I'm gonna let the lady state, and then if you object still, we'll go from there.
Mr. Chairman, don't we have the opportunity to review the material before
I reclaim my
provided?
time. I reclaim my time. Mr. Chair, I reclaim my time. I'd like to enter for the record an excerpt from a bank statement.
there's a
bank
objection,
statement that's
Mr. Chairman.
public in regards
object?
to Hunter Biden
Mr. Mifune
and
has
his
already
bank
objected.
accounts, in his payments.
Mr. Chairman, I object
Okay.
to this styrofoam board. It's not a
Reclaiming
document.
order, reclaiming order, reclaiming order. We'll,
Clearly, Democrats today don't want the truth to come out.
Mr. Chairman,
But
this just
I-
means that
I would
any
like to
member will
enter
be able
for
to
the
add to
record-
their 5 minutes by putting on a display of
Mr.
placards.
Chairman, I'd like to enter for the record.
I think that all
Mr. Chairman, I
members-
from
I
a
object.
bank report that shows
Can we get some order
proof of
here?
Hunter
Mr.
Biden's
Chairman,
bank
where
accounts
are we in
and
the-
human
all right,
trafficking.
okay. Let's hold off on this. There's several objections. We're gonna talk staffs between each other, and then we'll go from there. But I understand, I think what you're saying is from the laptop.
Someone on this committee accused me of revenge porn, and I have a right to respond to that, and I'd like to introduce
But within the rules of the
evidence
committee,
don't.
everyone.
for the
Mr. Chairman,
record. This is important evidence for the record, and it pertains to our investigation into Joe Biden and Hunter Biden, and this comes
So
from.
do it behind closed doors like you do
It-
everything.
it's not- It doesn't appear to be bad, but you ought to.
but Mr. Chairman, she's got
is the
9
relevance
placards
of
there.
it?
Does she get an additional 5
But
minutes or 10 minutes?
I don't understand how any of you who support the
Well, what's
genital
the order?
mutilation of
Okay.
children
We're
and
gonna
drag
sus-
queens
we're
showing
gonna-
their
we're
body
gonna
parts
reclaim
at parades
order here.
are
We'll
offended.
suspend and let the staff discuss the evidence from the laptop being entered into the record. Chair now recognizes Mr. Fallon from Texas.
Thank you, Mr. Chairman. Yeah, so
Okay, hold on. We suspend, so we need to stop for a moment. Okay, hold on. We'll get this. Y'all gonna discuss? You wanna go?
Yeah, you see, you just submit it and you put it in. You don't get a speech.
Right.
You don't get a speech to UC. You get the request, you say what it is, and you put it in.
So we're going to move on. We're going to call on Fallon now. Okay. All right. Reconvene. Chair now recognizes Mr. Fallon from Texas for 5 minutes.
Thank you, Mr. Chairman. You know, you have to acknowledge that there's a concentrated effort to deflect and distract, and this is not about January 6th, and unfortunately for the Democrats, it's not about Donald Trump. This is about Biden family corruption, plain and simple. And what really gets me is from just an individual and from an American to being an American is the fact that I disagree vehemently with most of our friends across the aisle when it comes to politics. I will submit that most folks that serve in Congress, whether they're Democrats or Republicans, are not corrupt. They're not on the make. They're not trying to enrich themselves. Hunter Biden is. The Biden family was. And so to sit here and defend a fella that doesn't merit that kind of defense is just interesting, and quite frankly, I find it sad as well. And I think he's a coward to come in here with this stunt, again, because, you know, you can define someone that's all about themselves by the way in which they act, and he clearly does that. That's what we're here to discuss. So let's talk about the process, because we've been told that, hey, he was here, he's ready to testify, just let him testify. For the American people, to make it very clear and digestible, when you are deposed in Congress, the majority gets an hour and the minority gets an hour, and it can go on indefinitely. So what usually happens is you can get 100 hours of questions in. You can go drill down. You can get into the efficacy of the procedure because you can go in depth, and you can hold whoever is the witness to account. If we have just public testimony, what happens here is we all get 5 minutes. Times roughly about 60 equals 300. Doing the math without a calculator, that's 5 hours. So instead of hundreds of hours, you only get 5. And witnesses are very good with their counsel to deflect and distract and answer really slowly, etc. That's why this is about procedure. 100 hours, 200 hours, and then we can come in to public testimony and ask questions about what we have read and make that public. So what I would have loved to, he was here, he left, unfortunately, because I would have loved to at least ask questions while he's in the room for the first time. I've never laid naked eyes on the man until just now. But I would have loved to have asked certain questions like, why did he feel special that he could evade paying taxes on millions of dollars of income? Why doesn't he pay it back? I know a lot of it is already outside of the statute of limitations, so he can't be prosecuted for it, but he can certainly still pay it back. That's a moral obligation that any American has. I'd like to ask him what he did, his company did, to earn $3.5 million from Yelena Baturina, who was married to a corrupt oligarch who used to be the mayor of Moscow. What did he do to have Kenish Razhikev from Kazakhstan wire him $142,300? The very next day he bought a Porsche. What did he do for Mr. Razhikev? What did he do? Did he get bribed, naked bribe of $5 million by Mykola Zlochevsky? And did he have any experience in the energy sector prior to his father becoming vice president, because Zlochevsky paid him $1 million a year? Interestingly enough, the CFO of Burisma, Vedant Pazarsky, had dinner after he paid Hunter Biden millions of dollars, had dinner with his then sitting vice president dad at Cafe Milano. Did that happen? Because it seems like it did. Did Kenish Razhikev, who gave him, but essentially bought him the Porsche, he also had dinner with his dad. And yes, coincidentally, Yelena Baturina as well had dinner with his sitting vice president father at the time. Who I would also like to have asked him, having been an entrepreneur and business person myself, why create 30 shell companies if you have a legitimate business? What did your business do? What services did they provide? What goods did they sell? Who pockets seed money? I have never met anybody in business that pocketed seed money. It's the lifeblood of your venture. Why did you take millions from foreign entities? And who was the big guy? Mr. Hunter Biden, was it your dad? 10% for the big guy? When you said in that WhatsApp message that I'm sitting right here with my father, was your father really there? Will you give up your geolocations on your phone with your dad so we can determine if you guys were actually in the same room at that time? Why did you email your daughter or text her and tell her about, boy, I wish I didn't have to give 50% of my salary to dad? This all is just questions that under a deposition, when we have hundreds of hours, we could ask this. And I'm only one member of a committee of 60. I'm sure my colleagues would have plenty of questions as well. So this is what it's about. It's about justice. And think about who you're defending here. He's not worthy of your defense. Mr. Chairman, I yield back.
Gentleman yields. The chair recognizes Mr. Lynch for 5 minutes.
Thank you, Mr. Chairman. I will agree with my friend and colleague, the gentleman from Texas, that this is a sad day, but perhaps sad for different reasons. This whole process has become such a sham. The underlying purpose at the beginning of these hearings was that, as was the title of one of the first hearings we had, a hearing on the basis for an impeachment inquiry against President Joseph R. Biden. And at that hearing, the Republicans and the Democrats had an opportunity to bring witnesses forward that would actually provide evidence to the committee so that we could make a decision to substantiate or to undermine the call for an impeachment. And we sat in this hearing, and the Republicans brought their witnesses in, and I have to admit, witnesses that had considerable experience and expertise and impressive resumes. And so we asked them, so this is the big moment. We asked these expert witnesses that the Republicans had brought in, are there any basis or underpinnings that would warrant an impeachment inquiry at this point? And these witnesses had reviewed almost all of the 14,000 documents that have been provided, transaction reports, Treasury reports, and I'll give you the answers. These are the Republican witnesses. This is Jonathan Turley and I think Bruce Dubinsky was a consultant. One witness said, and I quote him, he did not believe that any of the current evidence would support articles of an impeachment, close quote. That's the Republican witness that you had your moment. You had your moment to bring in the witnesses.
Would the gentleman yield?
No, I will not yield. I will not yield. The other witness that the Republicans brought forward against President Biden, he said under questioning he had no basis to even suggest that there was corruption, fraud, or any wrongdoing on the part of the president. Now, we are all familiar with Hunter Biden's, his conduct. There have been explanations of his drug addiction that have been widely publicized, something that maybe a few families of members of this committee might be familiar with, when people go sideways because they're addicted to drugs. But the very moment to pursue the underlying purpose of these hearings has been completely diverted. There's been no evidence brought forward against the President of the United States. And as to this witness coming here today, or his reluctance to submit himself to private investigations, can be, I think, credibly explained given the lack of trust that has surrounded these hearings. There have been story after story about leaks coming from those private interviews. Blatant misinformation and disinformation that the chairman and other members of the committee have offered to the press. So-called bombshells, that's what it was on Fox TV, bombshells, turned out to be a dud, turned out to be completely false. But under the auspices of this committee, those members, including the chairman, put out these stories in the press because they could not be refuted. They were not subject to cross-examination. They were not provided for or provided by any credible witness. It was just made up in the minds of the chairman of those members. That's why this gentleman wanted to testify in public, so someone could not distort his statements and leak them wrongfully to the press. The chairman.
Chair now recognizes Ms. Luna for 5 minutes.
This contempt proceeding is about upholding the rule of law. You know, with recently what happened with Jeffrey Epstein and the client list, we can see that many rich and powerful people, to include people in Washington, were held above the law, and that is simply not fair. Interestingly enough, though, one of the victims of Jeffrey Epstein, Virginia Giuffre, actually vindicated Trump. What you'll notice is that the media did not want to cover that, but why is that? It's because it will show a double standard that exists within our justice system, and also the media bias against those, especially Republicans and conservatives, that are simply not guilty of what they are accusing us of. So I just want to put this in perspective. The reason we are doing this today is because Hunter Biden failed to comply with our subpoena. Hunter Biden, I don't care about his drug addiction. Yes, you are. Many of us have experienced some of these awful things impacting our family, but that doesn't mean that Hunter Biden gets a pass or that we should feel any sympathy for him breaking the law. I want to just point to behind me, U.S. Code 192, a refusal of a witness to testify or produce papers. It means that you should be, one, subject to a misdemeanor, a fine up to $1,000, and anywhere from 1 to 12 months in prison. For your average American that doesn't have the connections that Hunter Biden has, this is what you face. So I want to just point out that when my colleague, Representative Alexandria Ocasio-Cortez, says we must comply with the law, I agree with you. When Ranking Member Raskin pointed out that that Donald Trump's allies should be held and we should not tolerate these contemptuous violations of the rule of law, I agree with that. But then let's use these exact same standards against their own. Frankly, I think that as of right now, there is a double standard that exists. We have to hold him accountable. He broke the law. He will be held accountable, and that's exactly why I'm supporting this contempt proceeding. Thank you.
Chair now recognizes Ms. Tlaib for 5 minutes.
Thank you, Mr. Chair. I'm going to yield to our ranking member, but before I do, I just, after coming back and being in our districts for so long, no one is asking me about this. They can't pay their bills. There is a lot of cost of living struggle all over our districts, and I just wish we would use this committee to talk about those issues. I mean, even on having the Sadler folks in here and talking about that, the cost of insulin. I mean, Mr. Chair, I would love to work with you in a bipartisan way to talk about those issues that I think really there's responsibility all over the place in regards to the fact that so many of our American residents and communities across the country are struggling. With that, I yield to our ranking member, Raskin.
Thank you, Ms. Tlaib, for your tremendous and enduring devotion to your constituents and the public good of all Americans. Why are we here, colleagues? Well, between January of 2017 and January of 2021, we suffered the most lawless presidency of our lifetime. It began by Donald Trump saying that he would keep his more than 500 businesses going. That's right, and he wouldn't divest himself of any of those businesses, and he would not adopt a rule in honor of the emoluments clause, consistent with the emoluments clause, declining to take money from Saudi Arabia, China, United Arab Emirates, and so on. And then he proceeded, as we've learned, to collect at least $7.8 million from foreign governments, and that's actually a tiny fraction of what he got, because that was only for the first 2 years before the chairman, in his wisdom, decided to tell Mazars to stop complying with the judicial court order. And so that was all we got, was 2 years for 4 businesses out of more than 500, and that was just for 20 countries out of 195 countries on earth. But the lawlessness lasted up until yesterday, when Donald Trump's lawyer got up before the D.C. Circuit Court of Appeals and asserted that President Trump, or any other president for that matter, has a right to order assassinations of his political opponents and not be prosecuted for it unless he's impeached and convicted first, which is completely at odds with the text of the Constitution, the history of the Constitution, but he asserted a right to assassinate other citizens unless first he's impeached or convicted, which means all you got to do is kill your political opponents and then kill enough of your political opponents in the House and Senate to keep yourself from being impeached or convicted. My friends, please don't look at your phones and papers right now. This goes to the heart of the republic. Take a position on it. Even if you're going to support it, take a position on it. Don't stick your heads in the sand. Donald Trump is doing this to our country. He's asserting the right of the president to murder people and not be prosecuted for it. Well, so why are we here? Well, Donald Trump insisted to numerous Republicans and in public and on Twitter and on Truth Social that Joe Biden be impeached. Why? Well, because Donald Trump was impeached twice, the last time for inciting a violent insurrection against his own vice president, against the Congress of the United States to overthrow an election. And if you don't believe that, you've got to tell me that if Mike Pence had buckled under to weeks and months of pressure, that Donald Trump would have said, oh no, I was just kidding. I'm not actually going to seize the presidency. Come on, if you believe that, you're too innocent to be let out of the house by yourself. So anyway, Donald Trump says, I don't want to be the only one running for president who's been impeached. Impeach Joe Biden. Figure out something. We were here for a year. You guys did not lay a glove on Joe Biden. You don't have a single credible piece of evidence, not one iota, showing any crime by Joe Biden. As Mr. Lynch says, even your own witnesses came up and said they didn't see it at the one hearing that you had on impeachment. So why are we here? Well, we can't go after Joe Biden. He's clean. Let's go after Hunter Biden. Let's go get him. And that's why I'm so suspicious of where we are today, Mr. Chairman, because I heard you numerous times say, come before the committee, come and testify before the world, come and tell everybody what happened. And he took you up on it, and he said yes. And I said, finally, we'll get to hear from Hunter Biden. We'll get to hear answers to all those questions Mr. Fallon posed. But then you wouldn't take yes for an answer. You said, no, we want to go to a back room and do it there, and then we will leak out appropriate details, which of course we have seen has allowed for radical distortions of people's testimony before this committee. You have not released the vast majority of transcribed interviews that have been in the back room so we can leak out specific details. So that's not right. That's why we have questions about it. But I'm with Ms. Mace. Let's bring them all in. Let's bring in all the Republicans who still haven't testified about what they know about what happened on January 6th, and let's bring Hunter Biden in. Let's do that all together. I'd be for that. And thank you for yielding, Ms. Tlaib, and I yield back.
Chair recognizes Mr. Langworthy for 5 minutes.
Well, we've certainly had enough distractions here today, and in the political stunt that we saw here at the beginning of this hearing, Hunter Biden strutting in here like a real tough guy while he refused to sit for a deposition that he'd been lawfully subpoenaed to do. It must be embarrassing to have to defend all of this, and we certainly have Trump derangement syndrome on display in a big way in this chamber today. Over the last year, the Oversight Committee has uncovered a plethora of evidence that is directly pointing at the corruption from Joe Biden and his family. This level of corruption is what you'd expect to see in a third world country, not the United States of America. If the volume of evidence was uncovered on any other influential family in the United States, my colleagues on the other side of the aisle would no doubt initiate thorough investigations. Now, just imagine if Hunter was a Republican. The president's son does not deserve special treatment, period. Holding Hunter Biden in contempt of Congress is the responsible reaction to his blatant disregard for federal law and our duty to investigate potential wrongdoings by the President of the United States. This committee has analyzed thousands of pages of bank records, leading to the discovery of $24 million of wire transfers and payments from foreign companies and foreign nationals directly to this Biden family. Through interviews with Biden family closest associates, the committee discovered that Hunter Biden used his father's name and influence in meetings with foreign nationals over 20 times. Witness testimonies proved that Hunter Biden dined with foreign individuals from countries such as Russia, Ukraine, and Kazakhstan alongside his father, who is the sitting vice president of the United States. And the list of evidence goes on and on. The president himself has been exposed for lying. Both the White House and Hunter have used every tool at their disposal to obstruct this investigation and to block the gathering of evidence. This blatant corruption must be held to account. It's one of the major duties of this very committee. And that's why on September 12th, 2023, as a result of the significant evidence against the current president, the Speaker of the House asked the Oversight Committee to conduct an inquiry to determine whether or not sufficient grounds existed for the impeachment of President Biden. Hunter Biden's testimony is a critical component of the impeachment inquiry into whether President Biden or his family personally profited from his office as vice president or his current role as president of the United States. And these facts cannot get in the way. We have got to get on with this investigation and end the distractions that we've heard here today. Let's get this contempt provision put forward, and let's move forward with this impeachment inquiry.
Will the gentleman yield? Will the gentleman yield?
Mr. Gosar.
We'll yield my time to Mr. Gosar.
Thank you very much, Mr. Langworthy. You know, to the ranking member, you know, we're cherry picking, and to Mr. Lynch, we're cherry picking because if you go back to those individuals we had as witnesses, they all said there doesn't exist that information now, but there exists the potential to be there. And the inquiry is different than an impeachment. It is a search for that document. So I think we got to be very, very careful when we're on both sides, when we're talking about this, that we give the whole picture, not part of the picture, the whole picture to this.
And what's been found since then?
Well, once again, there's stuff there. So
I'm sorry?
There is stuff there.
There's stuff there?
Yeah.
Can you share it with us?
Because you stack up these random corporations. What are you producing? If I'm a manufacturer, I would do that because I have different businesses accomplishing that. They have nothing to sell. Some paintings, it was access to the president. So now whether that reaches high crimes and misdemeanors, I don't know. I'm not an attorney. But last but not least, I want to make sure that we also get to this, is that you did the process and you stated it. The language has been repeated over and over again. You do this massive hunt with attorneys, not people like dentists or others. You do it with attorneys to gather that information. And then they selectively compile it. You guys get questions, we get questions, and we cover the ground more efficiently. That's why this process works. I agree with you. You do the behind the doors, then you come out here for the public. I think there's no difference there. I yield back.
Good. Chair now recognizes Mr. Gosar for 5 minutes.
Thank you, Mr. Chairman. My distinguished colleague, the gentlelady from Florida, held up a poster board saying we should hold Hunter Biden in contempt because of a provision saying refusal of a witness to testify. But that doesn't apply in that we have a witness that was here and is willing to testify. Now, I'll give everybody credit here. There seems to be disagreement about whether to do the closed-door deposition, but there is an area of agreement. And the area of agreement is to have a public hearing. And so what I'm interested in, I'll yield a minute of time over to you, Chairman, or somebody from the other side. We've been here for hours, and I have still yet to figure out why we don't have Mr. Hunter Biden here to answer our questions for whatever period of time we want in front of the Oversight Committee. So I want to understand. I want to give Mr. Fallon due credit from the great state of Texas for saying, well, he wants to make sure we have enough time. Mr. Chairman, I'm sure we could agree to whatever amount of time was necessary, but I'm having a lot of trouble understanding why the Republican majority won't take yes for an answer and ask questions of Hunter Biden here publicly. I think we would really learn, because all I've been hearing on TV news is over and over again that we need to ask Hunter Biden questions. He's saying we can. Why refuse to have this public hearing that it sounds like?
Are you yielding me?
Yeah, I'm happy to yield you 30 seconds.
So we've obtained thousands of pages of bank documents. We've reviewed 170 suspicious activity reports from banks filed against the Bidens. From my banking background, that's unprecedented to have that many bank violations that allege very serious things, from money laundering to tax evasion to bribery. And we have a lot of questions. We want to treat him like any other witness. He doesn't get to set the rules. We will depose him. And look, we split time with Democrats. You all get an equal amount of time with Hunter Biden. Then we'll have a public hearing.
But I guess my question is, if there is disagreement, and it sounds like there is, around the deposition, why not have the public hearing? Is there
Well,
a
we
reason?
will
Is
after
there a
the
reason?
deposition.
I understand, Mr. Chairman, but nobody has explained to me clearly yet, and I think to your own districts, to my district, why not call Hunter Biden in tomorrow? Why not ask him in next week? We're ready.
Will
to
gentlemen
schedule-
yield? I'd love
would
to answer
you
that
yield?
question.
Would you? Yeah, so I would have loved to have deposed him right here today.
We
But
had a
there's
motion-
rules.
we had
There's
a motion to do
rules.
it.
You have 3 days.
Let's do it in 3 days.
No, but
Who
my whole
wants to
point
sign up?
is behind closed doors. I would have gone right there. He's here. He's got his legal representation there. Let's play this game. But we have rules that say you have 3 days.
I'm not playing game one. I'm sure we could waive the 3 days. Second, we could have it here in 3 days if there's agreement about if what we're hearing from the Republican side over and over and over again is they've got questions for Hunter Biden. The quotes from this hearing. Hunter Biden's testimony is critical. I want to delve into questions I have for Mr. Biden. Why not ask for those? Why not ask for that tomorrow? We could
The
see if he
deposition
would.
tomorrow?
No, we would have him here in public tomorrow in front of everyone.
After the
I understand
deposition.
you're saying after the deposition, but my question for you is just very clearly, why not have the public hearing tomorrow?
Will the gentleman yield to that question?
Yes, sir.
Mr. Chairman, if
and
you
Mr.
may.
Donalds, I want to compliment you because I remember our first Oversight Committee hearing, you said it would be good to have these real conversations, so I genuinely
I
want
am
to
all for this, Mr. Kassar. I actually enjoy this part if we ever get to it. Look, the reality is, and you have attorneys on your side of the aisle, there is never any proceeding that takes place without a deposition of the witness. The reason why is because if something comes up in the round of questioning, either A, members of this committee may not be prepared because they don't have all the information from the witness, because the witness was never given an opportunity with his attorneys present to actually give out that level of information. So you need the deposition process before you bring a witness into open hearing. This happens all the time. This is actually the protocol of the House. And Mr. Kassar, what your side of the aisle is requesting, with all due respect, is a deviation from the historical precedent of the House of Representatives.
I'll yield back to the ranking member.
Well, but thank you for moving the ball forward with that explanation. That has been the practice sometimes, not all times. The vast majority of witnesses who come before this committee come without being deposed first. We come and ask for their testimony. But in any event, even for a witness who's being subpoenaed, like Mr. Biden was, we have a completely different situation when the chairman goes out publicly and says, we will give you the choice, A or B. You can have a deposition or you can come in the hearing, but I challenge you, I invite you, I insist that you come before the committee, and repeatedly says that. So that's why I think legally it's a very complex question, but I don't see why we take this all the way to all the way to court. If you guys really want to hear from him, let's have a public hearing and then depose him afterwards. But he's saying he doesn't want to be misrepresented. Thank you for yielding.
Time's expired. Chair recognizes Mr. Burleson from Missouri.
Thank you, Mr. Chairman. What should be obvious to the American people, what I think we need to just say to the American people is to point out that this kind of food fight, this circus that we've experienced is the reason why we want to have a deposition. In a deposition, you don't get people distracting the American public with all these other topics. And during a deposition, they don't get to lie to the American people for 5 minutes at a time. They don't get to distract, they don't get to lie, and they don't get to divert from the facts of what's happening. But what I see happening is what's being telegraphed here is that they're building a case, a political case really, because that's what this is. It's all politics that they're entering into for why the Department of Justice, or giving Merrick Garland an excuse, which we all knew that he would not prosecute, probably not prosecute these contempt charges, because it would be hypocritical if he did so. Because he prosecuted Steve Bannon, even though Bannon was actually working for the president, and was able to raise the speech and debate clause that was mentioned in the Constitution. Merrick Garland still prosecuted him for that. Here's what's really frustrating to the American people, and they see right through this. We're now going through a second process over really the same crimes that were committed when Joe Biden was vice president. And those crimes include the creation of dozens and dozens of limited liability companies, dozens of bank accounts. When people say, where are the facts? Well, I want to ask, what facts are you looking for? Because to me, bank records are facts. Suspicious activity reports are facts. Copies of checks are facts. When you juxtapose that with the WhatsApp message and what's on the Hunter Biden laptop and the deposition from witnesses like Mr. Archer, when you add to it further depositions, as we're going to hear about soon, the art dealer, when you layer all that together, that's a compelling story. There's a lot of facts. And you know what? I would hate to be on the other side of the aisle and try to defend this situation. And so I think that the only outcome would be to distract, to try to make this a political process. But it still stands as a fact that when the Democrats were in charge, they brought in the president's son. They brought him in multiple times, and they brought him into depositions, and he agreed. And this should be should be the takeaway message to the American people. When the Trump family was asked, when they came in and they gave depositions, the Biden family, once again, Hunter Biden feels that he's privileged. He's privileged. He doesn't have to pay taxes like everyone else. He's privileged that apparently he can traffic sex workers across the globe and get away with it. He's privileged in that he can get away with acting as a foreign advocate and be able to get away with it when other people are prosecuted and sent to jail for the very same thing. The American people see that there's two standards of justice. And when we're trying to go about the people's business in a serious manner, we end up allowing a food fight, which is exactly why he did what he did when he went across the street as far away as he could from this building and had his press conference, and then why he today showed up when the hour is way too late. I yield the remainder of my time.
Ms. Brown.
Ms. Brown. Chair recognizes Ms. Brown.
Thank you, Mr. Chairman. I am not a lawyer, and nor do I try to pretend to play one on TV. But it is plain for all of us to see we are here on behalf of one man, the self-proclaimed dictator on day one, the twice impeached, 4 times indicted, insurrection initiator and supporter, election denier, convicted fraudster, and maniacal manipulator from Mar-a-Lago, the one who lost and lost badly. We are here because my colleagues on the other side of the aisle have no positive agenda to run on. They have not accomplished one thing in their year in the majority to improve the lives of the people around this country. We are not here to hold the president in contempt of Congress. We are not even here to hold a member of President Biden's administration in contempt of Congress. For some reason, the majority has gathered us here to hold the president's son, his son, who I will remind all of us is not and has not ever been a government official, in contempt of Congress, despite his willingness to come testify publicly before this committee. So getting to the truth was never their actual goal. Instead of working together to solve big problems on behalf of the American people, my Republican colleagues continue to pursue a meritless, groundless, baseless investigation into the president's family. Meanwhile, back in my district, during our recess, I was literally dodging bullets at a funeral of a gun violence victim. And I never felt so powerless and vulnerable because I know that when I got back here, my colleagues on the other side of the aisle refused to do anything about it. Yet, they continue to make efforts to ban books, rewrite history, make it harder for people that look like me to vote, and to make it harder for women to make their own health care decisions. We see nothing on the other side of the aisle, but distraction, diversion, deflection, delusion, divisiveness, and dangerous destruction of our ever so delicate democracy. So with that, I am tired of the political theater. I want to get to work for the people back home in the 11th Congressional District because they, quite frankly, don't care about Hunter Biden.
Will the gentleman
And with
yield?
that, I will yield the balance of my time to my ranking member.
Ms. Brown, thank you so much. You know, you started off by saying something pretty profound, which is we are here instead of doing the business of the American people because the Republicans have offered us no positive agenda in their year in office. We know we've wasted countless weeks in them just trying to pick a speaker. And we've wasted countless weeks with their inertia and their do-nothing policies. But Ms. Brown, I don't know if you recall, I just don't want people having to take your word for it. I think numerous Republicans have gotten up on the floor of the House complaining about the fact that they have no agenda. I think our colleague Chip Roy from Texas said that the Republicans have not given him one thing, a single thing, I remember him saying, to campaign on. So I just want to ask you, when you're saying that they have no agenda, that's not a partisan point. You're getting that from Republicans, aren't you?
That is correct.
One of our colleagues said that there was Trump derangement syndrome, and of course, Trump derangement begins with Donald Trump himself. He thinks he has a legal right to assassinate U.S. citizens. He thinks he can grab women by their genitals, although that's not the word that he used. He said that if Joe Biden is reelected president, there will be World War II. He is obviously deranged and disoriented, but the real Trump derangement syndrome that I see is those people who cannot break from Donald Trump after he's proven himself to be completely and totally unworthy of your support. Because I'm looking at talented, gifted people on the other side of the aisle, the ones who have not left Congress in frustration or because they've broken with Donald Trump and clashed with him. But I'm still looking at people who have their wits about them, I think, but you're acting like cult members, like you're sleeping on the basement of a cult, listening to tapes all night, and I beg you to get over your Trump derangement syndrome. Thank you very much for yielding, Ms. Brown.
Chair recognizes Mr. Donalds from Florida for 5 minutes.
Thank you, Mr. Chairman. A couple of things. First, it was said in this hearing, Mr. Chairman, about you specifically, that you repeatedly said you would give Mr. Biden any opportunity. He could choose which one to come and speak in front of this committee. He could do it by deposition. He could do it by open hearing. It was up to him. The truth of the matter, though, is that the chairman's words are not binding. Like no other member's words of Congress are really not binding. The binding article.
Point of order. Does the chairman agree with that? Point of order. Does the chairman agree?
Are you going to restore my time?
Point of order. Just point of order. Does the chairman agree that the chairman's words are not binding on the committee?
That's not a point of order. It has nothing to do with the order of this hearing. Thank you. Can I go back to 4 minutes and 34 seconds? That's where I was before I was interrupted by Mr. Raskin.
Yes, reset the clock.
Thank you. What is binding is the actual written document, the written language in the subpoena, because a subpoena from this committee is also signed off on by the clerk of the House. That is the binding document that matters here. That is what governs. That's number one. Number two, that was said in this hearing. It was said that our witnesses said that there was no basis for an impeachment. But remember, members on the Democrat side of the aisle, what was said by Mr. Turley at the time was that there was plenty of evidence for the continuation of an impeachment inquiry. And the purpose of that hearing was the relevance basis for an impeachment inquiry. The House has now voted for an impeachment inquiry. And one of the first things that the House did after the vote of an impeachment inquiry was to subpoena Hunter Biden to appear. Hunter Biden has evaded that subpoena. So flagrantly did he evade it that he decided to show up at the Senate side to give a press conference, and Eric Swalwell, a member of the House, helped him get that time on the Senate side to give a press conference. That's a flagrant violation of a congressional subpoena. Secondarily, he has the gall to show up here when we're actually discussing contempt. And he didn't stay. He was sitting right over there. He's not here now. He said he wants to talk. He could have stayed through the whole proceeding. He chose to leave. That's his business. But he was subpoenaed to come here. back in December. He chose not to of his own volition. He's in violation of that subpoena, a subpoena that was executed with the signature of the clerk of the House of Representatives. That is the document that is binding. That's what we work off of. Mr. Chairman, I actually want to submit for the record an article from The Hill written by Jonathan Turley, and it is titled Eric Swalwell and the Politics of Contempt.
Without objection, so ordered.
Thank you. I'm glad something got admitted to the record. Last, a couple other points. One quick point I want to make, and this is in reference to the minority's report about this $7.8 million. I want the minority to understand one very important distinction between President Biden and President Trump. President Trump has an international real estate portfolio that he has amassed over decades. I'm quite sure if you go back through all of the hotel receipts before he was president of the United States, that you had foreign dignitaries staying at Trump hotels all across the world.
Will the gentleman yield?
I'm not going to yield, Mr. Raskin. I'm making a point because they're actually very nice hotels. They look good. People like staying there. President Trump was not running the Trump Organization when he was president of the United States. To my recollection, Eric Trump, the president's son, was actually running the Trump Organization when President Trump was president of the United States. So if he had a portfolio of hotels and people choose, through Expedia, through Kayak, through hotels.com, if they choose to go and stay there, how is that the president being in violation of what the emoluments clause? That's what you're citing? Stop. Ladies and gentlemen, America, this is ridiculous. The Biden family has no business. They've never had a business except for politics. And the one thing that the Oversight Committee, in conjunction with the Ways and Means Committee and in conjunction with the Judiciary Committee, has always been able to demonstrate is that they shook down foreign nations for millions, 26 million at the latest count and growing, millions. And there was never any business entity involved except public corruption and a pay-for-play scheme. The House Oversight Committee would like to get to the bottom of this under the impeachment inquiry of the House. We have questions for Hunter Biden. We issued a subpoena for him to answer said questions. He ignored a congressional subpoena as a private citizen. There are many attorneys on the other side of the aisle. If you had one of your clients in your private practice ignore a congressional subpoena as a private citizen, you would advise them not to, because they would be held in contempt and they would actually be punished by the Department of Justice. So I find it interesting to see today. I'm not going to yield, Mr. Goldman, because I had a question for you earlier. You didn't want to take my question, so I'm not going to take yours. Thank you. So, in closing, I will say, private citizens, yes, they have a responsibility to answer congressional subpoenas. They do. Hunter Biden had it, and he was flagrant. He decided to give a press conference. So we're going to do this business, and he should be held in contempt by the full House of Representatives. I yield back, Mr. Chairman.
Very good. Chair now recognizes Ms. Norton from Washington, D.C. for 5 minutes.
I yield my 5 minutes to Mr. Raskin.
I'd like to thank the distinguished delegate from the District of Columbia, and I need to correct the record because of several false statements made about the Foreign Emoluments Clause, Article 1, Section 9, Clause 8, although I do appreciate the gentleman from Florida's attempt to at least engage on the matter of substance that was raised so powerfully by Ms. Crockett. Now let's start with this. Article 1, Section 9, Clause 8 says that neither the President nor any member of Congress can receive a present, an emolument, which means a payment, an office or a title from a prince, a king, a foreign government, quote, Mr. Donald, of any kind whatever. Of any kind whatever, without going to Congress first and obtaining the consent of Congress. There's no hotel exception, Mr. Donald, to the Foreign Emoluments Clause. There's no international real estate syndicate exception to the Foreign Emoluments Clause, Mr. Donald. And also, I will take you up on your challenge to see whether the Trump Hotel in Washington, the Trump Hotel in Las Vegas, the Trump Hotel on Fifth Avenue, the Trump Hotel at UN Plaza, the 4 of the more than 500 businesses that we got documentation for, whether they actually had the same level of business coming from Saudi Arabia, the communist bureaucrats of China, who were the leading spender, as you know, if you've read our report, the United Arab Emirates, Indonesia, India, Egypt, and so on. We will make that comparison about what was done before if you get the chairman to call off the ban on further documents coming from Mazars. So
Have you ever stayed at a Trump hotel, Mr. Raskin?
Excuse no, and I never would stay at a Trump hotel. I've got too much self-respect and
stay at
concern
bad
for
hotels.
hygiene. So, but in any event, Mr. Donald, you're totally wrong about what the Foreign Emoluments Clause stands for. Abraham Lincoln was given 2 elephant tusks by the king of Siam during the Civil War, and he liked them very much. He wanted to keep them, but he went to Congress, which is what every other president did before and every president did since, right up until Donald Trump, and he asked whether he could keep the tusks, and Congress, though they loved Honest Abe, said, no, you can't keep them. I mean, John F. Kennedy was offered citizenship by the people of Ireland because they loved him so much, and he refused to take it, saying that even though it didn't violate the letter of the Emoluments Clause, it violated the spirit of the Emoluments Clause. And Donald Trump converted the presidency into an instrument for self-enrichment. He raked in millions of dollars from the most corrupt governments on earth, who came in with specific favors that we document in our report that they got from Donald Trump. I beseech my colleagues, I will read any book, any magazine, any speech you've given that you want me to read. Read this report and come back and tell me if you think Donald Trump did the right thing in converting the White House into a for-profit operation. No other president in American history has come anywhere close. And you ask why he's so determined to stay in office that he would unleash violence against his own vice president, the brother of your colleague, of our colleague. Why would he do that? It's because it was a money-making operation, and it was a great business grift for a guy who went bankrupt several times. And yet, out of some misguided partisan loyalty, you're going to stick with him. I don't even know why you stick with him. He was a Democrat longer than he was a Republican. He wanted to run for president on the Reform Party. You guys have been taken over by an absolute con man. And now you're acting like members of a religious cult who don't even remember how you got in the first place. We say return the profits, Donald Trump, $7.8 million. I've got a letter, Mr. Chairman, I'm going to share with you telling Donald Trump to return these $7.8 million. It's a small fraction of what he raked in. We want to know about the other 2 years in office. We want to know about the other businesses, not just those 4 that we were able to get information on. And we want to know about every country on earth, not just the 20 autocracies and dictatorships that we found. This is our government. This is our Constitution. And we're going to stand up for it against Donald Trump and anybody who follows him to the path of oblivion. Abraham Lincoln started your party as a third party to replace the Whigs because they wouldn't take a moral stand against slavery. It was a pro-freedom, anti-slavery, pro-union, pro-honesty party. And your party has been reduced to a corrupt, authoritarian cult of personality. And everybody does whatever Donald Trump tells them to do, which is what we're doing here today with this stupid attempt to hold Hunter Biden in contempt when he has come forward to say he will testify and give you everything you want, as the chairman of the committee repeatedly offered in public. So forgive my outrage and indignation, but enough is enough. Let's get back to the business of the people, as Ms.
Chair
Brown
recognizes
said.
Mr. Higgins for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, the American people may be surprised to know some of my colleagues across the aisle hasn't served as long as we have. Might be surprised to know that Representative Raskin and I had been building quite a colleague friendship in my original years of service. Prior to J6 especially, we would visit and we would debate constitutionalist questions, and he honored me by observation of my what he would sometimes call compelling. So it's with sincerity that I say congratulations to my colleague, Mr. Raskin, because you have obviously fully recovered from your cancer treatments.
Thank you, my dear friend, and I do love you.
You're quite animated, and I believe there's a direct correlation between your testimony against former President Trump and his poll numbers, because I'm watching a live feed. The more you talk about him, the more his numbers go up. So I may yield you more time. But I would, honestly, I'd like to ask you, if I could, regarding the deposition, just from a calm, if we could take a step back from the emotion here and the political conflict and this sort of prepared for battle debate we're in here. Just regarding depositions, we've all been through depositions in one way or another. They're very cold and calculated, and you have your attorney there, and then the bad guys, there's always the other guys. They have their attorneys, and you're either being sued or you're part of a suit. You're either the defendant or the plaintiff, and you're in a room for hours until all the questions have been asked. So, sincerely, why, if you were Hunter's attorney or advisor, why would you advise him not to participate in a deposition wherein his own attorney is there, it's private and everything is transcribed, his words cannot be twisted by the fake news? Just tell us, Mr. Raskin, and I yield for your answer.
Thank you kindly. And I should tell you that your feelings are not unrequited. I still have very fond and warm feelings for you. I'm sorry that January 6th came between us, and I look forward to a day in our republic when we will be really good friends again. But in a direct answer to your question, if I were his lawyer and I were his advisor, I would never advise him not to come and testify before the committee, except for one thing. And this is why, and I started out this way.
But specifically, I'm asking about depositions.
Yes, about deposition.
Because we want the deposition first,
I would
clarify, and then the public testimony.
Just to answer your question, I would recommend it, except that they were publicly given the offer numerous times to come before the whole committee, and they state a fear on their part, which is not unreasonable, that their words will be distorted and the transcript of the interview will never be released, because the vast majority of the transcribed interviews have not been released. And I would use this as an opportunity to call on the chairman.
Let me just say that I think that's solid counsel, but that brings us to our next point, my next point, which is that as a free American, which, I mean, to a certain extent, we still have some individual rights and freedoms, including to not comply with a subpoena. But so as a free American, Hunter Biden has a right to not comply with the congressional subpoena, but we have the right to take the next step as a Congress. If we believe the subpoena was righteous and his noncompliance with that subpoena was unrighteous, if we believe that our subpoena was lawful and we have presented probable cause and lawful argument to support that subpoena, then we have not only the right, but we have the obligation to consider that he was in contempt of Congress when he took that stand of noncompliance, which is where we are right now. Doesn't have to be emotional. The man had the right to not show up. We have the right to hold him in contempt, and that's what's happening. So, by all means, as my colleagues have stated, let us move forward with the people's business. The people's business today in this committee is to move forward with the vote to hold Hunter Biden in contempt. Mr. Chairman, I yield.
Gentleman yields back. Does any other member wish to be heard before we begin the amendment process? Seeing none, I understand there's an amendment at the desk. Oh, Mr. Cloud. I'm sorry, I didn't recognize. Mr. Cloud from Texas for 5 minutes.
Well, in the true DC meeting maxim of everything's been said, but not everyone's said it, since I haven't said anything yet, I'll go ahead and mention it. But we've heard words about irrefutable evidence being presented, and, you know, I just have to say, I don't think that word means what you think it means. And there's a stark contrast, as been pointed out, between how the Democrats have investigated and how we investigated. They are opposed to a closed-door deposition, which they've held a number of times. As a matter of fact, during the impeachment hearings, I sat in the skiff along with others while they withheld the transcripts that they are worried about. And so oftentimes it seems like their motivations they're portraying their motivations on us, and that's just not the case. I remember sitting, for example, in one of the hearings, and one of the witnesses who worked at the White House was asked, did you Did the president talk to you before coming here and said, well, we passed in the hallway and had a conversation? What did he say? Just tell the truth. Ironically, that part didn't leak from the committee hearing, but a number of lies did. And let's also look at how these two investigations got started. One was based on evidence that was false evidence that was paid for by a political opponent of Trump as a candidate, and created a whole Russian collusion narrative that we spent millions of government tax dollars on, perpetrating this big lie that our colleagues on the other side helped promote. This one began with a laptop that Hunter Biden produced himself, and then was backed up with bank documents, and then evidence of shell companies all over the place. And then there's talk about the business, the fact that Trump's business has made money from people who stay at the hotels. Is that not shocking? I think every American expected that people in other countries where some of his hotels are might have stayed at those hotels. That is not a shocking thing. But the big difference, of course, is that President Trump and his son is not manning the reservation desk. And they're not the ones answering the call and handing it over and saying, the big guy sitting with me, would you like a room at the hotel? That is not happening. But yet for these shell companies that Hunter Biden has set up in the Biden family, that's exactly what we've seen has been happening. And I would say that money that comes into the Trump organization doesn't go directly. Now, I'm sure there's some return on the investment that the Trump family has made, but it also employs several employees that get money from what comes in. I doubt that these 20 shell companies have nearly the employees of one hotel that Trump property has. Probably not as many hotels or as many employees as you would find in the lobby, working the lobby of one of these hotels. So this is completely different. They're trying to compare apples and oranges and confuse the American people back home. It's totally not the case. And getting back to the point of today's hearing, this really is about contempt. And so what we've seen happen is Hunter Biden has come here now twice just to not speak to this committee. So contempt is defined as a lack of respect or reverence for something, a willful disobedience or open disrespect for a court, judge, and legislative body. He flew all the way over here the day he was scheduled for a deposition just to not appear and to kind of thumb his nose here at this body. Today he showed up, and the minority is trying to make the case, well, he showed up to speak. We've been here a couple times. I've been in a couple committee hearings, not nearly as many of the members here. Never have I seen a witness show up when they want to show up on any sort of thing to say, hey, I'm here to speak on what I want to speak about. That is not how Congress works. That's not how any meeting on the Hill works. That's ridiculous to think that somebody's going to be able to show up and just mandate the agenda for today's meeting, which is further evidence of why he is holding Congress in contempt. He thinks he's above the law. He thinks it has no weight on him, and understandably so for the moment, because the DOJ refuses to follow up on anything and has done their best effort to work with the IRS and other agencies to shield and protect the Biden family. This is important. We have to hold them in contempt, and I yield back.
Gentleman yields back. Does any other member wish to be heard before we begin the amendment process? Seeing none, I understand there's an amendment at the desk.
Yes.
Mr. Chairman, I have an amendment at the desk.
For what purpose does Mr. Goldman seek recognition?
My apologies for jumping ahead. I have an amendment at the desk.
The clerk will distribute the amendment to all members. Does everyone have the amendment? No. All right, we're going to let the clerk distribute the amendment. I believe it was changed in the last little bit.
That's okay. I would ask that the clerk read the amendment. My apologies, I withdraw.
While we're waiting for everyone to review the amendment, I'll say we had 3 hours of opening statements. So hopefully we can get through these amendments in time. Just a note, we're working on printing the amendment because we just got it.
You want to move to another one? I can go now if you want to just use the time and I can do mine. I mean, I can do the time and we'll see if it's ready.
Yeah, he gave them the whole stack of amendments, copies for everybody. You have them.
Okay.
So they didn't just get them.
Okay. I mean, if you, do you want to start with another one, Mr. Chairman? Mr. Garcia is ready to go. He wants to go now, so either one. Either one's fine.
All right, we're handing it out now.
Okay.
I'm going to proceed with the clerk to read it. Okay. The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute as offered by Mr. Goldman of New York.
Without objection, the amendment is considered as read. I reserve a point of order. The gentleman from New York is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. This amendment would strike all of the resolve clauses and the report, and it would insert language that details all of the extensive efforts to cooperate that Hunter Biden and his attorney have made in response to this committee's requests for testimony and information from him. That began in February when Chairman Comer wrote to request documents and communications related to our investigation of President Biden's involvement in your financial conduct. The following day, his attorney wrote back to Chairman Comer offering to sit down with the staff to discuss the request. Then, 7 months later, Chairman Comer goes on television and said he never got a response back from Hunter Biden, which is flat out false. And that day, Hunter Biden's attorney wrote again to Chairman Comer to say that he did respond, he never heard a response, but that he remains available to have a discussion. So next, without any response from the chairman, you went straight into a subpoena. The subpoena was for testimony, and the witness, Hunter Biden, has put no conditions or limitations on his testimony. There are no limits on the topics. There's no limits on the length of time. He's happy to do it under oath. He has said he would not assert the Fifth Amendment privilege, even though that's available to him. That's in stark contrast to Devin Archer, their star witness, who so narrowly limited the time and scope of his testimony that we could not ask him anything about any of his own criminal conduct. But the only request that Hunter Biden has made is that he wants to give his testimony in public, not behind a closed-door deposition where his transcript wouldn't be released. There's absolutely no certainty or guarantee that there would ever be a public hearing again, and I would bet a lot of money that you will never put him in that witness chair, whether or not he comes in. That's all he wanted, just to speak to the American people. He has not, unlike your dear leader, filed a lawsuit to prevent third parties from turning over financial information. In fact, you've received tens of thousands of bank records. The problem you have is not Hunter Biden's cooperation. It's that all of those bank records, which would show any connection between Hunter Biden and his father, if there were any, has zero money going from Hunter Biden to Joe Biden related to any of his business ventures. So your problem is that the evidence doesn't show what you say it does. It's not that he's not cooperating, so that's why we're here today, so that you can change the topic, can claim that there's some kind of obstruction, and therefore Hunter Biden really did do all of these terrible things, and Hunter Biden should be impeached. Oh, wait, no. It's not Hunter Biden who's being impeached here. Now, this is far worse because the chairman, as we've discussed many times, has multiple times offered Hunter Biden to come testify in public. So if you had wanted a closed-door deposition, I don't understand why you would go on TV, Mr. Chairman, and offer for Hunter Biden to come in and testify publicly, whichever he chooses. So why no public hearing? Why won't you have a public hearing? The only request, this is an incredibly cooperative witness. We've all dealt with many witnesses who put a lot of restrictions on their testimony. There's one request of Hunter Biden, which is to speak directly to the American people, not in a closed door to the Republicans who will control the release, the dissemination, and the misinformation from that testimony. Why not? Well, one of your own colleagues went on the House floor last fall and said that this impeachment investigation was, quote, failure theater, unquote. A Republican said that. So the theory here must be, let's avoid the theater part of that and just keep the failure behind closed doors. Last month, Hunter Biden showed up to the Capitol on the day that he was subpoenaed, ready to testify in this hearing room. You refused to take his testimony. That very same afternoon, you went on the House floor to vote for an impeachment resolution on the rationale that you needed to pass a resolution to get more evidence. You reject evidence in the morning, and then you cry foul about no evidence in the afternoon. He's ready to testify, and this is a dangerous precedent you're setting if every single line in every single subpoena must be adhered to, or you're going to hold in contempt. I know my colleagues on the other side of the aisle who defied subpoenas outright would be very afraid if that became the standard here. And I yield back.
And I'll recognize myself. I oppose this amendment. This amendment claims that Hunter Biden has cooperated with this committee's investigation. How has he cooperated with the investigation if he has not abided by a congressional subpoena? Abby Lowell has never discussed scope or logic with us, and we have identified at least 2 checks directly to Joe Biden where we traced the money directly through the Biden influence peddling schemes. That is a fact. We have published evidence. This isn't like Adam Schiff and the Steele dossier where you just make stuff up. We have produced bank records, and bank records don't lie. So Mr. Biden mocked our legitimate congressional impeachment inquiry and flew to D.C. to hang out outside of Congress and did not show his face for a deposition. He is not in compliance. He openly defied a congressional subpoena. Do any other members wish to speak on this amendment?
Mr. Chairman.
Chair recognizes Mr. Raskin.
I want to yield back to Mr. Goldman. Before I do, I just want to pose a question to you. When you said that there was documented checks involving the president in an influence scheme, are you referring to the auto loan repayment checks between Joe and Hunter Biden?
You mean the Porsche he got from Uzbekistan? Which auto are you?
I don't know what kind of car, but are those the checks that you're referring to?
The checks we're referring to were a check for $200,000 that came through the influence peddling scheme with AmeriCorps Health, and the $40,000 check that came through the influence peddling scheme with China, where I believe Mr. Bobulinski has stated publicly was a company that Joe Biden was supposed to be 10% owner.
Okay, I'll reclaim my time. I think in both cases, I mean, there were a lot of words there, Mr. Chairman, but I think you're referring to the auto loan repayment with Hunter Biden. You're referring to the James Biden repayment. But if you've got documented receipts of foreign governments giving money directly to President Joe Biden, that's an outrageous violation of the Emoluments Clause, like the $7.8 million that Donald Trump pocketed while he was president, which for some reason you guys don't care about because you think the Constitution only applies to Democrats and not to Donald Trump. Because hey, that's an identifying characteristic of an authoritarian political party. It's got a charismatic leader whose word is considered above the Constitution, above the rule of law. You refuse to accept the results of democratic elections that don't go your way if you're an authoritarian party. And then you refuse to disavow or you embrace political violence as an instrument for obtaining and maintaining political power. So you guys didn't like when President Biden said that your party under Donald Trump has fallen into semi-fascist ways of operation. If the shoe semi-fits, you semi-wear it, okay? Now, I'd like to yield back to Mr. Goldman.
Would the gentleman yield to a question?
Well, yeah, I'll take a quick question.
I just want to clarify. We have a wire that went directly from CEFC, which banks have identified as a state-owned entity from China, that this wire went from CEFC to Hunter Biden, then to Joe Biden for $40,000.
Okay.
Joe Biden has been directly implicated in the family influence peddling scheme at least 3 times.
No, you haven't.
You have not.
I've not ever seen that.
You have not
No, read
produced
the bank memo.
You have not
The
produced
40,000 is for Jim Biden.
No. The 200,000 is from Jim Biden. The 40,000 is from Hunter Biden.
All right, but please produce the documentation.
We have it. We have 4 bank memorandums.
Give it to the members of this committee and
4 bank memorandums.
Okay, I'll reclaim my time, Mr.
There
Chair.
has never been a more substantive
I'm saving my time. You go ahead,
investigation
but I'm saving my time.
in the 7 years I've been in Congress.
All right, let me say this. The Democrats undertook a serious investigation despite every effort by the chairman to undermine it, and we determined there were $7.8 million documented receipts from foreign governments to Donald Trump. You guys don't care about that. That's unfortunate.
Will the ranking member yield?
But if you've got documented...
Will the ranking member yield?
Yeah, we will in just a moment. Let me make my point, okay? If you have documented receipts of foreign governments writing checks or giving credit card payments to Joe Biden, show it to us. We've been at this for a year now. We haven't seen anything. Then we show you in our more than 100-page report the documented receipts of money going to Donald Trump, and you don't care about it. In other words, you don't care about the principle that our government leaders should not be on the take from foreign governments. That's outrageous.
Well,
because I will oppose any government official of any political party who's on the take with money from foreign governments, and I hope you would join me in that. And yet we've shown it to you, and yet you guys don't care about it. I mean, that's just unfathomable to me. Now, at least the Trump family has responded to it. I mean, they're very nervous about it. You know what Trump said? The Trump's people say, well, he didn't take his $400,000 government salary. You know what? That's the only thing you're allowed to take is your salary from Americans, not money from corrupt Saudi monarchs who ordered the assassination of journalists, not from Chinese communist bureaucrats crushing the human rights of people in Tibet and the Uyghurs. You're not supposed to be on the take from those governments. That's what our Constitution says. Then they say, well, we return the profits. These guys don't. These guys think it's well, if it's a hotel, they could just keep the money. At least the Trump family understands. Some lawyer told them what the Constitution says. We return the profits. Well, guess what? They didn't give us the accounting of the profits, and that's not what the Constitution says. The Constitution says you can't take any payments at all from a foreign government without going to the Congress of the United States. It's not that you can't keep the profits from foreign governments. Do you guys understand what you're doing here? You're putting that
Gentleman's time's expired. Chair recognizes Mr. Timmon from South Carolina.
Thank you, Mr. Chairman. My colleagues across the aisle missed the point here. The Trump family has pre-existing businesses built over decades, hotels all over the world, and President Trump divested himself of control over those businesses to his children, and business arm's length transactions between foreign governments and between the Trump International Hotel chain, there's actually an arm's length transaction. They're getting hotel rooms, they're getting food and whatever from these hotels. So the difference is this. The Biden family doesn't produce anything. They don't have anything. They don't have hotels. They don't have services rendered. There are none. Hunter Biden has said that he was on the board of Burisma and he has no qualifications. They actually cannot document any service rendered by the Biden family, whether it's Jim Biden, whether it's Hunter Biden. So that's the issue. The issue is that the Biden family, all they have is the big guy and his policy favoritism, and that's why we're here. And I just think y'all are muddying the water, and it's not doing the American people justice.
Would the gentleman yield?
I yield back.
Would the gentleman yield?
Yes, I will yield to.
I thank the gentleman. I do want to point out that, to the point that Mr. Timmons was making, that the operation of the Trump Hotel was a legitimate enterprise that was approved by this committee in 2013, before President Trump was elected to office. But prior to that, it was the old post office. It was losing $6 million per year. The turnaround was a plus $3 million that went to the federal government. And as Mr. Timmons pointed out, it was divested to the family, to the children. It was not run by the president.
Will you yield for a question on that?
I'll yield for a question.
Well, when you say it was divested, are you claiming that Donald Trump surrendered any ownership interest? Because he continued to own it. He put it into a trust for his sole benefit. He said the day-to-day management would be turned over to his sons, but he was still the beneficial owner of it, and he stayed involved, as we know, because he kept talking about all the business that was coming in from abroad.
Well, the gentleman's question is legitimate in the context that most elected officials put their assets in trust for their own benefit after they leave office.
But it was not a blind trust.
He should not be forced to divest himself of the asset, an asset that was approved by this committee.
No, I'm afraid not.
I'm reclaiming the time yielded to me by Mr. Timmons to point out that what is happening right here should concern every American citizen, because we refuse to investigate and prosecute corruption. We are constantly pounded about corruption in other countries, but we've got corruption right here that we do not. We form partisan sides on this thing, and we don't do our job. I've been here 9 years and 7 days and gone through multiple hearings in the Oversight Committee dealing with corruption, and it turns into a partisan battle when we ought to be trying to make sure that we restore the American people's confidence in this government. What Hunter Biden should have done, he should have presented himself in answer to the subpoena. I'm not trying to take sides in this. I want the evidence to speak for itself, and it will never speak for itself if we don't have people come before the committee as they're required to do.
Will the gentleman yield for a question? Would you yield for one final question?
I'll yield to the gentleman.
Thank you kindly. And thank you for the spirit and the substance of your remarks, which I think significantly uplift the tone of the conversation. You would agree with me that the Emoluments Clause applies to government officials, and presumably you would agree with me that Hunter Biden is not and has never been a government official. So this is about a relative of the president, right? So we have Donald Trump, who's collecting $7.8 million at least. It's probably 4 or 5 times that much, and that's just during the presidency. But he was president.
Reclaiming my time.
And he was president.
It's Mr. Timmons' time.
Ranking member, do you have any evidence that Donald Trump received any of this money you're alleging that was received by the Trump Hotel organization?
Yes, he bragged about it, and in fact, he returned what he called the profits to the government, which gave the game away.
So $8 million in revenue, of which you don't know what the costs were associated with that, and you don't have any evidence that the president actually received any of this money. By the way,
we've got all the evidence. Have you read our report yet, Mr. Timmons?
What is the amount of money that you allege he's received?
$7.8 million, and it's a tiny fraction.
That's just factually inaccurate.
Have you read our report?
That's revenue. It's not.
I beseech you to read the report. I'll read any book you want me to read, any poem, any ghost story, whatever it is. Read the report, please. Read the report.
Please.
My time's expired, Mr. Chairman.
Gentleman's time's expired. Before I recognize the next member, since Mr. Raskin's into reading, I'd like to submit to the record the last bank memorandum, the bank memorandum that details the Chinese wire that went to Hunter Biden, then to Joe Biden. It's in the bank memorandum. This is substantive memorandum. This is the 4th memorandum. If you need the other 3, we will resend them to you.
Mr. Chairman, can I introduce something for the record too, before we break?
Yes, but without objection, we entered in the 4th bank memorandum into the record. Now you have something, Mr. Raskin.
Yes, this comes from Newsweek. This is Republican Congressman Andy Biggs warns his party has, quote, nothing to campaign on.
All right, without objection.
I object.
Ordered.
I object. Has nothing to do with the subject at hand.
Oh, well, it was very much discussed by the members today.
I still object.
Okay, could I call for a vote on that then, Mr. Chairman? Yeah?
Yeah,
all right, thank you. Let's get our members to
vote. We'll do a... All right, all those in favor of entering into the record a new story, say aye.
Aye.
All those opposed, no. No. It's okay.
Recorded vote, Mr. Chairman. Recorded vote.
Recorded votes called as previously announced, further proceedings on the question will be postponed. We have votes coming up on the House floor, so, all right. Okay. We have votes on the House floor. Have they been called? Votes on the House floor are going to be called in 30 minutes. We will recess until the last vote has been recorded. Then we'll reconvene and take up the amendments and the votes. So without objection, the committee's now in recess. The committee will come to order. The first order of business is a vote on Ranking Member Raskin's motion to insert a document in the record. All those in favor say aye. If you vote aye, you support Raskin's motion. If you vote nay, you oppose. All those in favor say aye.
Aye.
All those opposed, no. No. The motion fails.
I'd like to ask for a recorded vote, Mr. Chairman.
The clerk will call the roll. Right. So a yes vote means you support Raskin's motion to insert a document in the record. No means you oppose it. Clerk, call the report.
Mr. Jordan. Mr. Turner. Mr. Gosar. Mr. Gosar votes no. Ms. Fox. Ms. Fox votes no. Mr. Grothman. Mr. Grothman votes no. Mr. Cloud. Mr. Cloud votes no. Mr. Palmer. Mr. Higgins. Mr. Sessions. Mr. Biggs. Mr. Biggs votes no. Ms. Mace. Ms. Mace votes no. Mr. LaTurner. Mr. Fallon. Mr. Donalds. Mr. Perry. Mr. Perry votes no. Mr. Timmons. Mr. Timmons votes no. Mr. Burchett. Ms. Green. Ms. Green votes no. Ms. McLean. Ms. McLean votes no. Ms. Boebert. Mr. Fry. Mr. Fry votes no. Ms. Luna. Mr. Langworthy. Mr. Burleson. Mr. Burleson votes no. Mr. Waltz.
No.
Mr. Waltz votes no. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Norton. Mr. Lynch. Mr. Connolly. Mr. Krishnamurthy. Mr. Khanna. Mr. Mfume. Ms. Ocasio-Cortez. Ms. Porter. Ms. Bush. Mr. Gomez. Ms. Brown. Ms. Stansbury. Mr. Garcia. Mr. Garcia votes aye. Mr. Frost. Mr. Frost votes aye. Mr. Kassar.
Yes.
Mr. Kassar votes yes. Ms. Crockett.
Yes.
Ms. Crockett votes yes. Mr. Goldman. Mr. Goldman votes aye. Mr. Moskowitz. Ms. Tlaib. Ms. Tlaib votes yes. Mr. Chairman.
I vote no. How is Mr. Fallon recorded?
Mr. Fallon is not recorded.
Nay.
Mr. Fallon votes no.
Is Mr. Sessions recorded?
Mr. Sessions is not recorded. Mr. Sessions votes no.
Will the clerk report the tally? Okay, how is Ms. Porter recorded?
Ms. Porter is not recorded. Ms. Porter votes aye.
How is Mr. LaTurner recorded?
Mr. LaTurner is not recorded. Mr. LaTurner votes no.
Will the clerk please report the tally? How is Ms. Norton recorded?
Ms. Norton is not recorded.
Ms. Norton vote yes, I assume? Yes. Ms. Norton votes yes. How is Mr. Burchett recorded?
Ms. Norton votes yes.
Make sure that
Mr. Burchett is not recorded. Mr. Burchett votes no.
And how is Ms. Luna recorded?
Ms. Luna is not recorded. Ms. Luna votes no.
And how is Mr. Moskowitz recorded?
Mr. Moskowitz is not recorded. Mr. Moskowitz votes yes.
Okay. Will the clerk please report the tally?
Mr. Chairman, on this vote, the ayes are 10, the nays are 19.
Okay, motion fails. Now, the question is on the amendment offered by Mr. Goldman. Does anyone else seek recognition?
Chairman.
The chair recognizes Ms. Green.
Mr. Chairman, I'd like to talk about the importance of Hunter Biden obeying his subpoena and some of the evidence that we had questions about today when we had arranged with Hunter Biden and his attorneys for him to come in. Then he evaded his subpoena, and there's serious evidence that needs to be discussed. That has to do with many of the bank reports that we had read in the Treasury, outlining very serious crimes that Hunter Biden had committed or has allegedly committed, and then we have evidence of that. Crimes of Mann Act violation, human trafficking, these were in the bank reports, and the American people deserve to know about it. Here's another excerpt from a bank report.
Mr. Chairman, what is
talking about
point of order,
a victim
point
in
of order.
California. I reclaim my
Hold on
time.
one moment, Ms. Green. State your point, Mr. Goldman.
What is the gentle lady just showing to the cameras?
This is her 5 minutes on your amendment.
Well, if it's the suspicious activity reports, there was an agreement with the Treasury Department that the committee would not disclose the information.
It's my understanding what she's showing has already been disclosed in the public long before we started this investigation.
So this is in the public domain?
Yeah.
Wait,
Is that your representation?
Is that a verbal representation? It's in the public domain?
This is in the public domain. I reclaim my time. Victim one is a California resident currently employed with FSS Management between June 2018, October 2021. Victim one, Hunter Biden's victim, was employed by Owasco PC as evidenced by her receipt of biweekly payroll remittances from Owasco PC. However, during this same period of time, victim one also received large round dollar wires from Owasco PC, which reference new hire, K-wage, 10K golf member, and pay. Victim one received 5 wires totaling $44,508 in a 4-month period between June 12, 2018 and October 2nd, 2018. These are reports that are calling so-called employees of Hunter Biden and his law firm victims. And here's evidence of Hunter Biden violating the Mann Act. This is trafficking women across state lines for prostitution. This is an airplane ticket showing that it was purchased by Hunter Biden for this victim, where she flew from Los Angeles to Washington, D.C., and then the next day flew back to Los Angeles. The date is she flew in from Los Angeles on June 14th, 2018, and was flown back to Los Angeles the following day. And this is pictures that Hunter Biden had produced and uploaded to porn websites, and it's marked out.
Mr. Chairman, point of parliamentary inquiry.
Showing
Point of
proof
parliamentary inquiry, Mr.
proof
Chairman.
of Mann
Okay.
Act violations.
All right.
Democrats should not be
Okay.
offended by pictures
Mr.
that
Chairman,
black out.
Have I been
things.
recognized?
They should be
Objection. I have
offended
a
by
point of
actual
parliamentary
human
inquiry.
trafficking.
Mr.
All
Chairman.
right, but state your point.
Thank you kindly, Mr. Chairman. On July 26th, I sent you a letter about the last time this happened when the gentlelady introduced before this committee without any notice to anyone nude photos, pornographic images that were completely irrelevant to the purpose of the hearing itself. And my question to you is, are members allowed to simply put up sensationalistic, voyeuristic, pornographic images if they're not relevant to the actual object of the legislative proceeding? I want a parliamentary ruling on that.
Mr. Raskin, that's probably part of the questioning for Mr. Biden, violations of the Mann Act. Ms. Green's led on that issue.
No, this is a question of the rules of the committee.
These pictures have already been entered into the record.
So in other words, you have accepted the idea that members can introduce irrelevant, sexually based, voyeuristic...
How is this irrelevant?
Well,
how does it relate to Joe Biden?
How does it relate to...
We're not doing a criminal investigation of Hunter Biden.
We've had
point of order, Mr. Chairman. Point of order.
Testified in the FBI, DOJ, IRS that they were told to stand down investigating various crimes of the Biden family.
Okay.
Did Joe Biden tell them to stand down? Who told the IRS, the FBI, and everyone else to stand down? This is what we're investigating.
Reclaiming my time, Mr. Chairman.
I believe it's my time.
No,
I'm reclaiming my time.
I object to the use of this exhibit, Mr. Chairman. This is not a criminal investigation of the Mann Act or prostitution or anything else. It's completely irrelevant to a subpoena, the validity of that subpoena, and whether or not there's been compliance with that subpoena. It's totally extraneous, immaterial, and irrelevant. And someone should explain that to Ms. Green if she doesn't understand.
Point of parliamentary inquiry.
And let the chair rule. You had a point of order. The chair's rule.
I
This
object
is
to the use
evidence.
of this.
You objected. We got that. Evidence that Hunter is a material witness in this investigation.
Well, does that mean you can put up pornographic pictures of other people that Hunter Biden has met in his life? I mean, come on. Like, how far does that go? It's not relevant to your motion.
Well, you can ask him that in the
it's
deposition.
Not relevant. No, honestly, Mr. Chairman, it's not relevant to your motion of whether or not he violated that subpoena. How did those naked pictures have been?
Mr. Chairman, point of order.
This is not the Jerry Springer show. This is the United States House of Representatives.
And let me
Come
say
on.
this. Let me say this. This is not pornography. It's appropriately censored evidence in an ongoing investigation.
Yes.
Okay? It's appropriately censored evidence in an ongoing investigation.
Censored.
Mr.
All right, I
Biggs
just want to
raised
say,
a point.
pursuant to Clause 6 of Rule 17, I object to the use of this exhibit as irrelevant, extraneous, sensationalistic, voyeuristic, and totally antithetical to the legislative purposes of this committee in this House. This is not the Jerry Springer show. Yield back.
Chair recognizes Mr. Biggs for a point of order. Your clock stopped, Ms. Green.
Yeah, my point of order is to
And I appeal the ruling of the chair. If that was a ruling, Mr. Chairman, did you rule on it? Because I appeal your ruling.
So I was recognized for my point of order, and I get it. He wants to have an appeal. So, but I'm trying to keep this in order as much as we can. Mr. Chairman, my question is to you: is now the objection based on relevance going to be encountered here and constrain what can be presented in this committee? And the reason I ask that is because there is virtually nothing. A comment I made in the press about it was totally tangential to this, that they just tried to get in. All of that becomes irrelevant. If that's the case, then the entire Democrat testimony that we've heard today should be stricken as being irrelevant.
No, I think you're...
irrelevant and pornographic.
We're going to have a ruling, So Ms. Green is attempting to enter this into the record, unanimous consent. Mr. Raskins has objected. And we're going to vote on it, just like we voted on the last amendment.
Clearly. They defend all women, don't they? Except women.
Yeah,
Hunter Biden.
the ruling is the point of order will not be recognized, and Ms. Green is in order. If you want to object.
Well, yeah, I object. And Mr. Chairman, you have the authority to bring to the full House under Rule 17 whether or not pornographic material should be entered without a clear showing of relevance. And I would ask you to bring that to the floor of the House. Let the members of the House decide whether that's the new standard, whether the
Mr.
Congressman
Chairman,
Marjorie
may I
Taylor
have
Greene's
my-
standard is going to be
may
the
I
standard for
reclaim
the whole
my
House.
time?
The quorum is within discretion of the chair. We've overruled your objection.
And I appeal that.
You appeal the ruling of the chair.
Yes, I do. I would like
So
to
we're
vote.
going to vote on that.
We're going to vote on the pornography.
May I finish?
Hold on. All right, Mr. Gosar, you're recognized.
I move to table the motion.
Okay. Motion to table the motion that, of Mr. Raskins. This motion is not debatable. As many as are in favor of tabling signify by saying aye. Aye. All those opposed signify by saying no.
No.
In the opinion of the chair, the yeas and the motion, the yeas have it, and the motion to table is agreed to. The committee will now resume.
Mr. Chairman, I would move for a recorded vote. I mean, if that were a book, she would censor it, but she wants to advertise it through the House of
Recorded vote
Representatives.
is ordered. A recorded vote is ordered.
If we're going courtroom, speaking objections don't work, Chief.
The clerk will call the roll. You'll call the roll. If you vote yes, you table the motion. So, clerk, call the roll.
Mr. Jordan. Mr. Turner. Mr. Gosar. Mr. Gosar votes yes. Ms. Fox. Ms. Fox votes yes. Mr. Grothman. Mr. Grothman votes yes. Mr. Cloud. Mr. Cloud votes yes. Mr. Palmer. Mr. Palmer votes aye. Mr. Higgins. Mr. Higgins votes aye. Mr. Sessions. Mr. Sessions votes aye. Mr. Biggs. Mr. Biggs votes aye. Ms. Mace. Mr. LaTurner. Mr. LaTurner votes aye. Mr. Fallon. Mr. Fallon votes aye. Mr. Donalds. Mr. Donalds votes yes. Mr. Perry. Mr. Perry votes aye. Mr. Timmons. Mr. Timmons votes aye. Mr. Burchett. Mr. Burchett votes aye. Ms. Green.
Aye.
Ms. Green votes aye. Ms. McLean. Ms. McLean votes aye. Ms. Boebert. Mr. Fry. Mr. Fry votes aye. Ms. Luna. Ms. Luna votes aye. Mr. Langworthy. Mr. Burleson. Mr. Burleson votes aye. Mr. Waltz. Mr. Waltz votes aye. Mr. Raskin.
No.
Mr. Raskin votes no. Ms. Norton.
No.
Ms. Norton votes no. Mr. Lynch. Mr. Lynch votes no. Mr. Connolly. Mr. Connolly votes no. Mr. Krishnamurthy. Mr. Khanna. Mr. Khanna votes no. Mr. Mfume. Ms. Ocasio-Cortez. Ms. Porter. Ms. Porter votes no. Ms. Bush. Ms. Bush votes no. Mr. Gomez. Ms. Brown. Ms. Stansbury. Mr. Garcia. Mr. Garcia votes no. Mr. Frost. Mr. Frost votes no. Mr. Kassar. Ms. Lee. Ms. Lee votes no. Mr. Kassar votes no. Ms. Crockett.
No.
Ms. Crockett votes no. Mr. Goldman. Mr. Goldman votes nay. Mr. Moskowitz. Mr. Moskowitz votes no. Ms. Tlaib. Ms. Tlaib votes no. Mr. Chairman.
Chairman votes yes.
Mr. Chairman votes yes.
Will the clerk please report the tally?
Mr. Chairman, on this vote, the nays are 15, the ayes are 21.
The yeas have it, and the motion to table is agreed to. The committee will now resume consideration of the Goldman Amendment. Ms. Green has 2 minutes remaining.
Thank you, Mr. Chairman. And again, this information is extremely important because Hunter Biden refused to obey his subpoena, and we are holding him in contempt of Congress for doing so. This is important evidence of human trafficking, Mann Act violations that we had questions for the president's son about. And there's evidence, I'd like to show the evidence of payments. These are payments made from Hunter Biden and his law firm to so-called assistants. These were not assistants. These are prostitutes that he was trafficking. And I think these victims are important. And just because our Democrat colleagues don't like the evidence doesn't mean that it's not relevant. And I'm especially offended by the women on this committee that don't care about these women's rights. They're victims of Hunter Biden. Here's another excerpt from bank reports talking about victims. These are banks. And these banks are identifying these women as victims. Victim 2, talking about victim 2, victim 1, each appear to be in the adult entertainment industry and are receiving payments from Hunter and Owasco PC. It is unclear what relationship Hunter or Owasco PC have with these individuals. And based on public media, it appears possible the payments may be associated to prostitution or adult entertainment services. Victim 2 is a New York resident and employed as freelance. Per internet research, she is a social media influencer and adult entertainer. She received 6 quick pays for $6,250 from Hunter between 3/29/2018 and 11/20/2018. This is clear evidence, Mr. Chairman. These are important questions we have for the president's son pertaining to Mann Act violations. Thank you, Mr. Chairman.
Mr. Chairman, just a point of order. I didn't want to interrupt the good lady, but 2 points here. One is the majority has purported to be in possession of the laptop, and you're supposed to share all evidence with us. We've been asking for a year. Will you make the laptop available to the Democrats so we can look at it? The guy who originally apparently leaked it has said he can't vouch for anything they're talking about because he doesn't understand the chain of custody. We don't know who made those pictures. We don't know who made those statements. If it's coming from the laptop, we don't know where it's coming from. So please, could you please share with us what you've got?
If I can interject, I can give you a copy of it. Marco Polo has the actual entire publication. We can get every single Democrat member a copy of that.
Well, I want to get at least the copy that the majority is using. I don't even know what Marco Polo is.
I will get you, I promise, I'm not trying to be rude. I will
Well,
get you a copy.
you mentioned you wanted to read some stuff. That would probably be something good to read, the Marco Polo report.
But what about your copy? Because you know you have an obligation under the rules to share with us any evidence you claim to have. So as far as we know, all that stuff is completely confected. It's just made up. It's
with all due respect, Mr. Raskin, you spent a lot of time investigating the former president, and you haven't spent any time on this. The American people are keeping up with this investigation.
We want to investigate.
But you all are 3 or 4 steps behind.
Give us the evidence.
So Ms. Green's time.
Okay.
Ms. Green's time has expired. Does anyone else wish to speak on the Goldman Amendment?
Mr.
Mr. Moskowitz.
Thank you, Mr. Chairman. Again, just to reiterate the point, but I rather than my words or my opinion, I think I'm going to quote Senator Ted Cruz, who the chairman appeared on his podcast. And in fact, just to remind the chairman of Ted's own advice to the chairman, I made a board for you, Mr. Chairman. You were on the show with Ted Cruz, in which Ted Cruz said to you, I'm going to give you some unsolicited advice. Now, by the way, Ted Cruz, clerked at the Supreme Court. He knows the Constitution pretty well. But you guys know who Ted Cruz is, right? He's run for president a couple times. So Ted Cruz said to you, Mr. Chairman, you should have Hunter Biden in a public hearing. He actually said his advice to you is just have him in a public hearing. And again, I go back to what is the majority so concerned, or to use some of the words of my colleagues, afraid to have Hunter Biden sit at this desk. Mr. Chairman, you control the rules. You could give everybody 10 minutes. You could give everybody 15 minutes. You could give everybody 20 minutes. You could give your side as much time. We could go on for days here, quite frankly, because again, you control the rules as you just showed. But the one difference that you guys object to is you object to those. You object to the cameras because you don't want the American people to hear the answers. No, you want to take the transcript and release it 6 months after you've gone out and lied about what has happened. And so, again, because the gentle lady from Georgia, I know is such an advocate for women's rights, as she mentioned, and is so concerned about grooming, and apparently we don't have any standards here anymore. Again, I just want to remind my colleagues, because, you know, I don't want them to forget about hypocrisy, okay? I don't want them to forget about hypocrisy. But, you know, Donald Trump was asked about Jeffrey Epstein, and when he was asked, he said, you know, Jeffrey likes him young. Well, how did the president know that? How did he know that Jeffrey Epstein likes him young? Perhaps some people are saying he was there, since you're so concerned, right? But again, I bring this up not to make jest. I bring it
Point
up.
of order, Mr. Chairman.
I bring it up. I thought we weren't going to interrupt.
We're going to stop the clock. We did this with Ms. Green. State your point.
Yeah, I'm just curious about the impugning of the former president's character. That we.
I don't have to do that. He does that himself.
Have we basically thrown that rule out? I'm just curious, or are we going to follow that?
Would you accept a pornographic photo?
Of Bill Clinton?
Yeah, we suspended the rule to the current president, but we didn't suspend it to the former president. But.
Oh, by the way, please, so you're making the point that we can disparage Joe
right.
Biden, but not Donald Trump. Please make that point to the American people. Mm-hmm. Please. Bill Clinton's not running for office.
That's my point of order, Mr. Chairman.
All right.
I'll wrap it up.
Suspended the rule on the disparaging the current president because this is a contempt proceeding with the Biden. So he's part of the investigation.
But the rule remains in place for all prior presidents,
I would say that, but in all honesty, they've broken the rule many times today.
Mr. Chairman, it doesn't apply to prior presidents.
It does not apply to former.
Okay, very good. Thank you.
Listen, I won't talk about the photo and the 11 of them and the fact that he was on the plane and on the island anymore. What I will point out is the hypocrisy of today. The hypocrisy of today is you want to hold you guys break the rules by not complying with subpoenas in the last Congress, and now you're shocked. You can't believe after you broke all of that now it doesn't work. You come up here and talk about Hunter Biden's behavior, and you're so disgusted. But the guy that you all kneel to, okay, associates himself with a pedophile. But remember, I get
Mr.
it.
Chairman,
Mr. Chair.
Mr. Chairman, that should be stricken.
I ask his words taken down.
A statement
That
of a
should be
fact, and it's his time.
It's a fact.
I asked his words to be taken
Okay,
down.
there's a motion to strike the words.
Yeah.
Yes.
On what
Mr.
grounds? On what grounds?
To say that we associate with pedophiles.
No, he was referring to Donald Trump.
No, I said Donald Trump
The man just
associates.
said that we all kneel. I kneel to Christ. I stand for the flag. And if
Support?
you're concerned about
I'll
pornography
change my-
being
I'll
shown
change
in
my word
public,
to support,
Mr. Ranking Member, you might look to
No,
the
fair
library
point. No,
content
okay.
that your people
So
support.
you're referring to the kneel down. Donald Trump said that
I
someone
moved for
took the
his
knee.
words to be taken down.
And I think he withdrew
It's a
that.
motion.
I withdraw my
He withdrew it. He withdrew that. That'll be taken from
We
the
have to accept him withdrawing it.
All right.
Accept
Everybody
it.
good? That's going to be taken
Word
from the record.
withdrawn.
Okay,
Accept
I
it.
withdraw the kneel down. I'll use the word very much support. We okay with that? No snowflakes offended? Okay, wonderful. Anyway, back to the point, Mr. Chairman, is that I just think the American people are tired of the hypocrisy, right? They're just tired of it. Because what they've recognized is when Donald Trump does something, it's just fine. But when someone else does it, it's a crime. Time and time again. What, you think the Chinese stayed at his hotel because they didn't have another choice? You think he wanted to have the G7 at Doral because Doral is the best property in America? Come on, you guys are smarter than this. You know he was trying to make himself rich, but when Donald Trump does it, when Donald Trump does it, it's just fine. But when a private citizen you claim does it, it's a crime. You guys don't have any credibility. You might have credibility on the Charlie Kirk show, but you don't have any credibility with the American people anymore. You just don't. Thank you, Mr. Chairman.
Chair recognizes Mr. Burchett.
Thank you, Mr. Chairman. I'd ask for the last word to be stricken.
Okay. Do what?
And I'd like to yield to Representative Timmons.
Okay.
Thank you, my friend. I want to correct the record. It seems this entire hearing, we're chasing all of these logical arguments that really don't have any merit. And earlier, before we recessed, we were discussing the ranking member's $7.8 million in foreign payments from at least 20 countries during his presidency. And I knew the answer. I knew that that was revenue, and it wasn't actually profits. Hold on, I will let you ask questions at the end of this. And you said, did I read the report? And so I did. And in the report, it actually specifically says these included payments from foreign governments and foreign government-owned or controlled entities to properties owned by Donald Trump, including Trump International Hotel in D.C., Vegas, Fifth Avenue, and this is my favorite, Trump World Tower at 845 United Nations Plaza in New York. So let's just use that one alone, because if you go down to page 20, footnote 23, it actually clarifies where this money came from to include the amount of money. And so what y'all did is you took a building that was built in 1999 and completed in 2001, and you have, it's 100 yards from the United Nations. So these foreign countries owned multi-million, $10 million, $20 million condos in one of the nicer buildings in New York. And I was just kind of shocked because I knew that you were using revenue and you weren't using actual profit that the president or the Trump organization made. You actually used HOA payments. Do you know how duplicitous it is for you to use HOA payments on a $20 million condo in New York? Like, it is outrageous. No, you can, I'm gonna go through. We're gonna go through all of them because you list them. And I see Saudi Arabia, $615, $422,000, Trump World Tower. And you go and you look, there's nothing there that is under $10, $12 million. So you're taking a $12 million property that was owned since 2001, and you're saying that this is somehow similar to Hunter Biden running all over the world and selling the big guy's influence? These are completely different things, and the fact that you even created this report and you're using it to shield us pursuing justice to make sure that this president is not compromised because his son has sold secrets to China, to Ukraine, is so disingenuous, it's so duplicitous. It's not even misrepresentation, it's a lie. I'm happy to hear this from you because, again, you told me to go read it. I read it. That's what it says. I can read you in footnote 23 where it says, this report uses common charges or rent payments. All of these properties were owned prior to 2018. They didn't go out and purchase them because of the president. They were there for decades before this happened. That's the point. That's the difference.
Okay.
We'll let the facts get in the way of a good story.
Absolutely.
Would the gentleman yield? Thank you, my dear friend, for engaging in substance and not ad hominem attack. I very much appreciate that. Having said that, some of the payments, first of all, you said that there are lies in here. Can you find one factual inaccuracy?
So
there's not one.
For you to
in
tell
fact,
the
you're quoting us. You're quoting us. But let me make this point. Which is that China gave $5.5 million.
It's Mr. Timmons' time. It's Mr. Timmons' time.
For you to tell the American people that $7.8 million went to President Trump is an outright lie. It's a fabrication. Hold on. And I'll tell you exactly why. Because you're using businesses that existed decades prior to when he became president. And
you're saying all of them?
Hold on. And you're using HOA fees for multi-million-dollar properties that have been around since 2001. And again, even the fees that they pay for hotel rooms, that is a fee for a product, for a service. There's no service with Hunter Biden other than influence of the vice president or the president of the United States, and that is why we are here, because he will not answer questions in the exact manner that you have required for last Congress and the Congress before that. I mean, it is difficult to chase all of your logical fallacies surrounding this, but at the end of the day, he's gonna do exactly what Don Jr. did. He's gonna do exactly what you required of every other member, except every other person that you've subpoenaed, except for members of Congress who actually do have immunity, which you're pretending like you don't know what that means. We need to get to the bottom of this. The American people demand it. And with that, Mr. Chairman, I yield back.
Excellent.
Mr.
Does any other member wish to speak? You wish to speak on the amendment?
Yes.
Ms. Stansberry is recognized for 5 minutes.
Yes, thank you, Mr. Chairman. Just quickly, before I speak on the amendment, I do want to address the assertions that were just made about this report and the receipts that have been provided about the funding that came into various properties and businesses owned by Donald Trump while he was president. To address the inaccuracy put forward by Mr. Timmons, if you go to the source material, which is the actual receipts from Trump International Hotel, other hotels in New York, yes, there are condo fees. There's a number of different businesses, but it's very clear that there was influence peddling going on. So, for example, there's receipts.
Will the gentlelady yield?
No. There are receipts that show the Malaysian government between September 10th and 13th was spending $10,000 a night, butler service, personal trainers, lavish meals, at the same time that they were meeting with Donald Trump, and the media reports from the time say that they discussed their stay at Trump's hotel in the Oval Office. So this is just not true. Another one, UAE, during a military delegation visit in March of 2018, they were negotiating a arms package with the White House at the time. Okay. They dropped $85,000 at Trump Hotel and were discussing their stay at the hotel while they were negotiating the arms package. The Saudi Crown Prince and his staff dropped tens of thousands of dollars in Trump's hotel while Trump was in office. They were not only negotiating an arms deal, they were seeking the Iranian deal or the Iranian agreements under the previous administration to be overturned. And we know that months after Trump and Kushner left the Oval Office, the MBS committed $2 billion to Kushner against the advice of his own investment advisors. And we know that in Kazakhstan, we had Kazakh president who came and stayed again in Trump's New York and DC properties while there was these very nefarious activities going on. So I would encourage our colleagues to actually look at the receipts and then go look at the dates and what was actually happening in the media. It's very clear that whether or not Trump encouraged them to stay in his hotels or properties, or these foreign governments stayed in them and then told Trump and his son-in-law, they were seeking influence by staying at his property, and thus were trying to bribe him, which is a violation of the Emoluments Clause of the United States Constitution. So let's move back to the amendment here just for a moment. I do want to just establish a little bit of a timeline. And Mr. Chairman, if it's okay, I'd like to just ask some clarifying questions on the timeline. It's my understanding that in February of last year that you transmitted a letter to Biden's attorneys seeking documents and communications from the investigation. Is that correct? I'll go ahead and answer on your behalf because we have the records for that if it's not immediately or at your hands. Our understanding from the witness is that the chairman and his staff never responded to that request. In fact, they didn't hear back until, or they didn't hear another thing until 7 months later when in September, Mr. Comer, you appeared on a TV news station on Newsmax and said, quote, Hunter Biden is more than welcome to come in front of the committee if he wants to clear his good name, if he wants to come and say, you know, that these weren't his dealings, then he could come and clear his name. And so literally the next day on September 13th, Biden's attorney responded and wrote you back and said, you never responded to our offer. I'll come in. I'll come do a public testimony. A couple months later, after the impeachment hearing that just completely fell apart, Chairman, you went on the Ben E show and you extended another offer to Hunter Biden to come testify in front of the American people under oath. And yet again, when Biden's attorney transmitted a letter offering to do so, instead you issued a subpoena to do a closed-door deposition. It's just very odd, right? Like, here we are, there's been a lot of yelling today. I think we're all getting real tired of all of this. But the reality is that Hunter Biden has, even today, showed up in front of the committee ready to testify under oath. So, like, let's be real. And I think the reality is that of all of these tens of thousands of documents that have been provided to the majority in their investigation, none of them have actually shown any wrongdoing by the president. And so it's easier to create a smokescreen, to keep this narrative in the media, and to peddle in disinformation.
Time's expired, and there's so many inaccuracies with your statement. We don't have time to address them all. But Chair recognizes Mr. Donalds for 5 minutes.
Thank you, Mr. Chairman. Members, we should be voting down this amendment. It is not needed. What is clear is that the only document that matters is the fact that there was a subpoena issued by this committee, signed by the Clerk of the House of Representatives. That is the only thing that governs subpoenas before anybody coming to this committee. It does not matter if any member of this committee did an interview anyplace, whether it's the chairman or any other member. That is irrelevant. The only thing that matters is a signed subpoena by the chairman of this committee and the clerk of the House. The semantics about what Hunter Biden thought he could do or what Abby Lowell, his attorney, tried to get him to be able to posture or get out of it is meaningless. And the Democrats know this is meaningless. This is a subterfuge because their guy bucked a subpoena against the law. Period. Full stop. Members, vote down this amendment. I yield back.
The question is on the amendment, on the Goldman amendment. So all those in favor of...
Wait, we have another.
What's that?
We have another.
I yield 5 minutes to the gentleman from New York. From New York.
Thank you. Appreciate my distinguished colleague from D.C. I want to just take this opportunity to address some of the chairman's evidentiary allegations that you made earlier today. First, I would just note that we keep hearing this over and over and over again, that Donald Trump had a business, Donald Trump had real estate, Donald Trump sold widgets or whatever it is. Obviously, there are many different ways of investing or spending money or getting paid for services or for simply putting capital into another company. So I don't know what these investments were that Hunter Biden and Devon Archer and these other folks were involved in. Devon Archer testified that it was private equity. That's a legitimate form of business to invest capital in other companies.
Don't you believe we should get that question under oath?
You got it under oath from Devon Archer, sir. In any event, let's go back to I think the fourth bank memorandum is what you pointed me to earlier today, because you alleged, Mr. Chairman, that there is money that went directly from CEFC, a Chinese company, to Hunter Biden, then to Joe Biden in $40,000.
Through the shells, yes.
Oh, through the shells, You didn't say that. That you didn't say. So I went back.
Well, you've had a hard time understanding what a shell company is, but anyway, go ahead.
Well, you would know, wouldn't you?
Oh, yeah.
So
that's right.
Here we are looking at this Fourth Amendment. We have, well, I'll show this chart first because it shows how clear it is. You've got Chinese company going to Biden-China joint venture, going to a Hunter Biden individual entity, going to James and Sarah Biden entity, going to James and Sarah Biden personal bank account, going to Joe Biden. So that, I guess, is what is directly money from China to Joe Biden. It just had to go from a Chinese company to a joint venture that Hunter Biden entered into with another Chinese company.
Would you yield the question?
I just want to finish going through what you told me to go through, and then I'm happy to yield. Then it went to Hunter Biden's personal company that he generally used for a variety of his business ventures. Then it went to another entity for James and Sarah Biden. Then it went to James and Sarah Biden. Then Jim Biden, almost a month later, sent a $40,000 check to his brother, the president, which said was for a loan repayment, and the same bank records where you got this from showed that a loan went from Joe Biden to Jim Biden.
That's not true.
So this is the kind of duplicity that we're talking about. You want to say there's evidence connecting Joe Biden to Hunter Biden's business ventures, and you make a false and inflammatory allegation that money went from China to Hunter to Joe, when in reality, it's 4 pages, it's 21 bullet points of information to get from A to B to C to D to E to F. There's no possible way that you could ever show that Jim Biden knows. This is my time, Mr. Chairman. There is no possible way Jim Biden you could ever prove under any circumstances that Jim Biden knew where that money came from. And you certainly cannot show with any evidence at all that Joe Biden would know that 1 month before, 6 different transactions earlier, somehow this money came from a Chinese investment that Hunter Biden had. You are desperate. You are misrepresenting the facts. There is no evidence. There's no evidence of Joe Biden's involvement in Hunter Biden's business interests. There's no evidence of Joe Biden's involvement in any Mann Act or prostitution stuff. Hunter Biden should be investigated by the Department of Justice, and he has been for 5 years. He is a private citizen. This is what you call an impeachment investigation into the President of the United States based on complete fiction and smoke and mirrors. There isn't a piece of evidence that links anything that Hunter Biden did to Joe Biden, and this is a complete sham.
Your time's expired, and those accounts that they went through were depleted. It wasn't hard to trace the money. When there's not any money in the account,
he doesn't have the bank
through,
records.
No.
No, but
you have the bank records too. You all get every bit of
no one
evidence
who
we
receives
have.
the money has the
accounts were
bank
depleted
accounts
that they
records.
laundered through. All right, order.
Chairman.
Order. Who's
Mr. Chairman.
Miss Luna's
Can I
recognized.
say something?
Yes, you have
No
5 minutes.
one is above the law. Even if you think that he's innocent, he cannot defy a congressional subpoena. That's what this is about. People here, I'm sure on that side too, have family members that have gone to jail for probably less offenses. So why is he given this special privilege? We have no authority if you have the president's son who's sitting there doing illegal things. I mean, I know it probably doesn't make you feel good to defend the guy, but like, for goodness sakes, he should be held accountable. At least bring him in and admit that.
He should be held accountable by the Department of Justice, where he is being held accountable.
Let him. He should be held accountable by the Department of Justice, but that is what we are voting to do, is to send that to investigation, because he denied and defied a congressional subpoena.
Will the general yield?
Wait, let me finish. If the DOJ doesn't uphold that, though, we have a serious problem in this country that this man is held above the law, and that is why we are arguing here today. We are trying to send it to the DOJ, but you're arguing against that. Yes, I yield.
Thank you. Would you agree that members of Congress who outright defy subpoenas should also be held to the same standard?
I believe that certain members are protected under the speech and debate clause. Some people here can probably school me on that, but aside from that, this is a serious investigation. There's been a lot of personal attack in this entire correspondence that we've had in the last, couple hours that we've been here. But what I will say is that Hunter Biden is not above the law. We want to send him to the DOJ, and we want to trust the DOJ to do their job. But right now, the American people have a serious distrust factor with the DOJ, and for good reason. So we would like to pass this, send it to the DOJ, and let's see if they'll do what they promised the American people they would do. I yield my time.
Very good.
Mr. Chair?
Ms. Tlaib?
Yes, thank you so much. I'd like to yield my time to the ranking member.
Ms. Tlaib, thank you very much. I want to pursue the very interesting conversation that we began about the Foreign Emoluments Clause. And again, I'm just delighted that after 7 years, several Republicans now are actually taking an active interest in the Foreign Emoluments Clause as a part of their investigation into the potential impeachment of Joe Biden, which we've been working on for a year. Let's start with this. When Donald Trump took office, he refused to divest himself of any of his more than 500 businesses, and he refused to put any of his more than 500 businesses in a blind trust. He said he would continue to be the owner of those businesses, but he would transfer some of the day-to-day management to his sons. If anybody wants to contradict me on that, I will stand to be corrected. But that was what Donald Trump said. When he was told by George W. Bush's ethics advisor that he was putting himself in extremely dangerous territory unless he stated that he was going to refuse to accept any money in the future from foreign governments, he ignored and defied the advice of all the ethics advisors for Republican administrations, for Democratic administrations. I want you to recognize the radically unprecedented nature of what he did at that point, and he set himself up for the trouble he got into. Now,
the gentleman yield?
I will. As soon as I make these points, I'll come right to you. Number two, Trump, my good friend makes it sound like Donald Trump was totally innocent. He was a businessman, and he didn't know any of this was going to happen with these foreign governments. Really? Read the report in detail, my friend. For example, go to page 69. Here's a quote from Donald Trump as he was campaigning. I love the Saudis. Many are in this building. Saudi Arabia, I get along great with all of them. They buy apartments for me. They spend $40 million, $50 million. Am I supposed to dislike them? I like them very much. We can find quotes just like that about the Chinese government. This is your guy. Now, the governments knew exactly what they were buying at the exact same time. For example, take ICBC. And by the way, the vast majority of businesses were not paying before as tenants. That's not right. They were patronizing the hotels in Washington and New York. They were going to the golf clubs and so on. A handful of them were pre-existing tenants. That in itself is unconstitutional and illegal. You want to be president of the United States? Then you get out of that. You divest, which is what other presidents have done. Look at what Kennedy said. Look what Obama did. Look what Abraham Lincoln did. Every president before Trump scrupulously followed the Foreign Emoluments Clause. Go to page 10. There's a corrupt Chinese-owned bank called ICBC, one of Trump's tenants, and the Department of Justice recommended sanctions against them for funneling money and services to North Korea, and Donald Trump reversed them because, as he was saying, he collected money from some of these people, like Saudi Arabia. He knew who he was collecting money from. Of course, Donald Trump knew that. He's a businessman. Is there anybody who would dare to challenge that idea? Here's the former Republican chairman, Ed Royce of the House Foreign Affairs Committee, who called on Trump to apply maximum financial and diplomatic pressure by targeting Chinese banks that do business with North Korea like ICBC, and Donald Trump let them off scot-free, just like he did with Saudi Arabia after the homicidal crown prince ordered the assassination of Jamal Khashoggi. They covered up for him. He said, we saved his blank, and he owes us now. And of course, as soon as the administration ended, his son-in-law created a business and brought back, what do you know, $2 billion from Saudi Arabia, even though the Sovereign Wealth National Investment Fund said it was a terrible idea, overruled by the Crown Prince, whose blank was saved by Donald Trump. So our founders would be offended that we even have to get into the specifics of what was done, because they said categorically nobody can take $1 from a foreign government. Do you understand that? No payment, quote, of any kind, whatever. So we don't have to have this ridiculous, humiliating debate about how far one of our presidents abased himself to line his own pockets.
Would the gentleman yield?
Sure, I would love to yield.
So my thought process here is I understand that the president lost money during his tenure.
Really?
Yeah.
Yeah, well, he went bankrupt 5 times. It doesn't surprise me if that's true, but I doubt it, because I think they made more money that year than they had in the several prior years before he became president.
Well, he dropped out of the top 100, so I can tell you.
Well, yeah, because they started finally checking the records. You know that your guy cooks the books a little bit, but in any event, Donald Trump
cooks the books with the rules that Congress predated made the rules for.
He's just been
Are we
punished
ready to
by
vote
the
on the
state of New
amendment?
York.
Are we ready to vote on the amendment? All right. All those in favor of the Goldman amendment signify by saying aye.
Aye.
All those opposed, no. No. In the opinion of the chair, the noes have it.
Recorded vote, please.
Not agreed to. A recorded vote is ordered. As previously announced, further proceedings on the question will be postponed. All right. Now,
where's my?
I understand. Mr. Raskins, you have an amendment at the desk.
I do. Let me find that.
The clerk will distribute the amendment to all members. Does everyone have the Raskin amendment? Does everyone have it?
And she's not going to read it.
Okay. The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute as offered by Mr. Raskin of Maryland.
Without objection. The amendment is considered as read. I reserve a point of order. The gentleman from Maryland is recognized for 5 minutes to explain his amendment.
Thank you kindly, Mr. Chairman. Since we haven't read the amendment, I'm just going to work through the basic terms of it. Resolved that the initial deadline for Hunter Biden to comply with the subpoena issued on November 8th was December 13th, 2023. Resolved that current members of Congress and 3 members of this committee have refused to comply with subpoenas duly issued under the authority of the United States House of Representatives, including Mr. Biggs of Arizona, Mr. Jordan of Ohio, and Mr. Perry of Pennsylvania. Resolved that the aforementioned members of Congress have firsthand knowledge and information related to the January 6, 2021 attack on the Capitol and on this body and on the Vice President of the United States that is of critical importance for the American people and the work of this committee. That the deadline for Hunter Biden to comply with the November 8th subpoena be changed to the date upon which the aforementioned members of Congress supply their knowledge and information to the Committee on Oversight and Accountability. In other words, Hunter Biden has until the date upon which our own members comply with the subpoenas that were issued in the last Congress that have still not been supplied, and that the aforementioned members of Congress shall be ineligible to vote on matters pertaining to contempt of Congress considered by this committee until the date upon which the aforementioned members of Congress supply this knowledge and information to the Committee on Oversight and Accountability. In other words, you should not be standing in judgment on contempt of other people who allegedly have violated their subpoenas when you have violated a subpoena and have not complied with the orders of the U.S. House of Representatives. I would also like to raise a problem that struck me as I was looking through the paperwork on this, Mr. Chairman, which is that the subpoena that was sent to Mr. Biden, which came around a week before, or a couple months before, it was issued on November 8th, 2023, was issued before the House of Representatives had voted on impeachment. I remember there were numerous Republican members who were very hesitant about voting for it because of the testimony of the majority's own witnesses who said there was nothing closely approximating a quantum of evidence that would justify impeachment. And so there had been no vote on it, you'll recall. And on November 8th, the subpoena was issued. The subpoena date for appearance was on December
Mr. Gosar has a point of order. State your point.
Yeah, we're not talking about impeachment. We're talking about impeachment inquiry. We need to be very considerate about that.
Well, exactly right. And that goes right to the point of this question I have. Thank you, Mr. Gosar. The subpoena was issued on November 8th for a subpoena date of appearance on December 13th. And that was the same date when, you'll recall, we were called to the House, and then there was a vote on impeachment. So the underlying subpoena here is at least arguably invalid for the purposes of holding him in contempt of not complying with the subpoena related to impeachment. And I wonder if we could clear that up. But in any event, I would press the amendment. Certainly those members who have outstanding subpoenas from the U.S. House of Representatives who blew off the subpoenas should turn over what they know about the violent attack on the U.S. Capitol, the worst domestic political violence designed to overthrow an election in American history at the Capitol. And they should turn that over. And at that point, then yes, I will. We will yield in 1 second. And then Mr. Biden should also be forced to comply at that point. In the meantime, those members really should not be voting on contempt motions related to other witnesses. And somebody had a question.
I did. Yield?
Yes.
Are you sure that everybody up there actually received a subpoena? I mean, your board says certain people received a subpoena, and in my experience, Some of those people up there did not receive a subpoena, and so notified counsel for your bogus J6 committee.
Well, first of all, every court in the land has rejected the claim there was anything bogus about it. As you know, the courts rejected the idea that it was somehow
Was it heard before every court in the land?
Every court that heard it, do you have any authority on your side for that outrageous proposition? I know you'd like to believe it, but your fantasies are not the law of the United States.
I have great fantasies.
I'm certain you do.
But
You
let
and
me
Ms.
just tell
Green
you
might
this,
want to
one-
discuss them together.
Yeah, but
Okay.
you haven't answered the question. You don't know if those people actually even received the subpoena, and yet you
again-
put it on the board, and you're going forward and trying
reclaiming
to
my
hold
time.
people in
Reclaiming
contempt.
my time. I served for more than a year on the bipartisan January 6th Select Committee to investigate the attack. You might not like Liz Cheney anymore, who was head of your conference, but it was bipartisan, my friends. And so was Adam Kinzinger, who served his country well. But in any event, nobody ever claimed that they hadn't gotten the subpoena. And
go back and check the records.
Well, if
sir.
that's the argument, have them come forward and explain that. I would like them to testify under oath that they never received it.
Gentleman's
Thank
time's
you, Mr.
expired. Chair recognizes Mr. Palmer from Alabama. Chair recognizes Mr. Palmer.
Mr. Chairman, I make a motion that we immediately dispense with the amendment for lack of germaneness.
Okay. I am prepared to rule the amendment is not germane to the bill. Therefore, the amendment is not in order.
Mr. Chairman, I would like to appeal the ruling of the chair. It's clearly germane. It goes right to the heart of what we're doing here today.
Okay. The motion to appeal the ruling of the chair is not debatable. All those in favor of tabling the appeal. Oh, go ahead. Yes, Mr. Gosar. All right. Okay, Mr. Gosar's motion is not debatable. All those in favor of tabling the appeal of the chair signify by saying aye. Aye. All those opposed signify by saying no.
No.
In the opinion of the chair, the ayes have it, and the motion to appeal the ruling of the chair is tabled. The committee will now resume consideration of any further amendments before this body.
Mr. Chairman, I have an amendment at the desk. It's Garcia,
Okay,
number 3.
Who said that?
Ms. Garcia.
Okay, Ms. Garcia.
Thank you. It's
Will the
amendment
clerk
number
please
3.
report?
Amendment to the amendment in the nature of a substitute as offered by Mr. Garcia of California.
Okay, without objection, the amendment is considered as read. I reserve a point of order. Mr. Garcia is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. I know obviously what we're seeing today has been quite insane. We've seen pornographic images. We've talked about white privilege. But what we haven't seen is any sort of evidence linking President Biden to any sort of wrongdoing. There's been absolutely zero evidence discussed today. And as we know, all the demands for a public hearing with Hunter have gone unanswered, even today when we asked for that vote. But what we do have is plenty of evidence that we've uncovered in this committee and that have been against the Constitution with our investigation of foreign government payments to President Trump through his businesses. And what do we have as Democrats? We have receipts, proof, a timeline, screenshots. We have everything we need to prove conclusively that foreign governments were funneling money through Trump properties and into Donald Trump's pockets, all in violation of the Constitution. Now, we don't have access to all of Trump's properties, and he has hundreds, by the way, of properties and business interests. And we don't have access because our chairman actually chose to end that investigation. But my amendment will fix that by demanding a full accounting of Trump's businesses. Now, we know that we can already prove about almost $8 million of foreign payments, illegal payments against the Constitution back to the Trump organization. And that is just a tip of the iceberg, because we don't have access to the other hundreds of businesses and properties. That $8 million of receipts and payments that we have is only from a total of 4 properties of the hundreds of businesses of Donald Trump and his family. No family in history has ever benefited more than the Trumps and the Kushners. And I actually want to talk about Jared over here especially, his son-in-law. His son-in-law was brought in to run Middle East policy at the start of the Trump White House. By the way, having zero experience in doing that work, and against the objections of the Secretary of State, Rex Tillerson. Trump and Kushner, of course, made their first state visit to Saudi Arabia, overruling the State Department. This is at the same time, by the way, that Jared was actually putting together a $110 billion arms deal for the Saudis. But what was happening during that time? The Saudis were paying hundreds of thousands of dollars in room stays and foreign gifts that were illegal under the Constitution back into the Trump organization. Over and over, through hotels and properties, these shady investments by the president, his sons, and his son-in-law, who was an employee of the White House, all worked to enrich the Trump family and Donald Trump himself. And the insane part is that just months after leaving the White House, Jared Kushner received a $2 billion with a B investment fund from the Saudis to manage and being paid directly as well out of that fund that the Saudi government organized. I want to just mention also that our chairman also said, and I quote, that this crossed the line of ethics, end quote. So why have we not investigated the Trump crime family and the current and ongoing abuse by Jared Kushner as a government official? And I remind folks, Hunter actually never worked for the government. He was a private citizen. That's why I want to offer my amendment, which lays out the details of not just the $8 million in illegal, unconstitutional foreign payments, but also demands Donald Trump to pay back the taxpayers. It demands a full accounting of all of his properties, and it subpoenas the Kushner businesses so we can understand the complete grift, not just from Saudi Arabia, but the 20 other foreign governments which we have records for, and the governments that we don't have records for, like places like Russia, which we know there was a series of investments made there as well. And so with that, I urge support for this amendment.
Gentleman yields. Chair recognizes Mr. Palmer from Alabama.
Mr. Chairman, I move to dispense with the amendment immediately. It is not germane.
I'm prepared to rule. The amendment is not germane to the bill, therefore the amendment is not in order.
Mr. Chairman, I would like to appeal the ruling of the chair. It's clearly germane and relevant.
Mr. Gosar.
Yes, I move to table the motion.
Okay, the motion to table Mr. Raskin's appeal is not debatable. All those in favor of tabling the appeal of the chair signify by saying aye. Aye. All those opposed say no. No. In the opinion of the chair, the ayes have it, and the motion to appeal the ruling of the chair is tabled. The committee will now resume consideration. Is there any other amendments?
Mr. Chair, I have an amendment at the desk.
Okay, who's Mr. Frost? Mr. Frost, will the clerk please report?
Amendment to the amendment in the nature of a substitute as offered by Mr. Frost of Florida.
Okay, the clerk will distribute the amendment to all members. What's that? Let's pause. We haven't seen it. Okay, we're. No, you have seen it. You just don't have copies. Yeah, we don't have copies. We're printing it right now. We're waiting on copies of the amendment. Okay, the clerk, have you designated the amendment? You have? Without objection, the amendment is considered as read. I reserve a point of order. Mr. Frost is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chair. I'm offering an amendment to this misguided resolution that would essentially work to take out the lies and the smoke and mirrors and insert the truth of the matter before us. And the fact of the matter is that Chairman Comer has a history of selective treatment of the facts presented to him that would really make any witness concerned about any kind of closed-door procedure or deposition. My amendment outlines how last month Chairman Comer tried to push this fake impeachment by selectively talking about a truck that President Biden initially made payments on while he was still a private citizen that his son, Hunter Biden, later paid him back for. The month before, Chairman Comer selectively released just a 1 page of a 4-page email chain to falsely claim that regulators were concerned that Hunter Biden was money laundering when that wasn't true. What the chairman selectively forgot to share is that the other 3 pages of the email directly contradicted his claims. Regulators explicitly stated that the transactions were reasonably and consistent with the business profile, and that's a quote, and that the entity was transparent. And it doesn't stop there. My amendment outlines how the chairman has misrepresented the mountain of bank records that show no wrongdoing, the fact that Chairman Comer has only released 2 of the 17 witness transcripts so far. We want him to release the transcripts. And we also know that the chairman has interviewed some of Hunter Biden's associates, and it seems that to the rest of America, and no dirt could be found, and because of that, they wanted to bury the truth. But the truth is out because the truth is that this has been a complete waste of time. Republican claims all throughout this case barely hold up to the slightest bit of scrutiny. And it's not just me saying that. We've heard it on Fox News. We've heard it from the Wall Street Journal, the Washington Post, CNN, and others who have been investigating the chairman's false claims of evidence against President Biden. And once again, it's been said time and time again, to hold him in contempt, at least vote yes on this amendment so we can include the full story in this piece of legislation. It is the fear of the truth that has stopped the chairman from accepting Hunter Biden's offer to testify publicly, and my amendment essentially lays it all out on the table. I urge adoption of my amendment, and then let's move on and do the real work of the American people, especially in these difficult times. I yield back.
Does any other member wish to speak?
Mr. Chairman, I have a parliamentary inquiry.
Chair recognizes Mr. Donald.
Mr. Chairman, my inquiry is this, that considering, though it seems to be we're going to be going into these amendments where the context of the matter at hand has been debated since 10 a.m. this morning, I would move, Mr. Chairman, that further debate on amendments will be considered under 20 minutes of structured debate in total, 10 minutes for each side of majority and minority on the committee to fully debate the merits of each amendment going forward, Mr. Chairman. That's my question for the parliamentary.
Mr. Raskin.
Yeah, but I would move to accept that and move by unanimous consent that we accept that proposal.
So without objection, so ordered. 10-minute debate on each side. Does any member wish to debate?
Mr. Chairman.
Further?
Katie Porter, Ms. Porter was next.
Okay, Ms. Porter.
I'm glad that my colleague from the other side has moved to limit debate because this hearing, to put it bluntly, has sucked. There is one thing that Republicans and Democrats seem to have in common today, which is that we're willing to be players in a game. Both sides, at times, using this hearing to take shots at our favorite political nemesis. And I see some members practically patting themselves on the back when they get a good insult or counterpoint in. But this isn't a game. Oversight isn't a game. Under this Republican majority, we have wasted month after month censuring, expelling, holding people in contempt, and almost impeaching. And for what? Okay. Republicans have passed nothing of substance in the House. What our Oversight Committee should be doing, instead of spending now dozens of hours arguing about Hunter Biden, is real oversight of issues that affect all Americans, like corporate price gouging, unconstitutional government surveillance, and waste at the Pentagon. The fact that members think that real Americans outside of this partisan environment on Capitol Hill care about this is everything that is wrong with Washington. So that Americans who love this country and just want a better future don't have to listen to hours of frustrating attacks and procedural debates in a partisan game, let me sum it up. 1, there is zero evidence of President Biden doing anything wrong, including in connection with his son. No evidence of an impeachable offense, not a little, not something, none. 2, Hunter Biden has offered to testify in public in front of this committee. If Republicans only want his secret, private testimony, that is, as the kids say these days, sus. If my Republican colleagues are truly in this to get answers, and I hope they are, stop wasting all our time on holding Hunter Biden in contempt on a deposition and ask him your questions. He'll be here under oath, and the American people can watch. What's more transparent than that? What's better accountability than letting the American people hear Hunter Biden's answers? That's real accountability, not political gamesmanship behind closed doors. This is a game where nobody wins and everybody loses. It is Washington at its worst. And I'll tell it like it is without pointing the finger at either party. This sucks. I yield back.
Does any further member wish to debate on the Frost Amendment?
Mr. Chairman.
Mr. Palmer.
I appreciate the gentlelady's remarks, but I do want to point out that one of the reasons it's necessary for Hunter Biden to appear to give a deposition is that he is a material witness in an ongoing investigation of potential corruption at a very high level. I think, to your point, that this has devolved into partisan politics. When we have an obligation as members of this committee, a very solemn responsibility to pursue evidence and investigate charges legitimately and not let it become what it has become today. And I don't think we're getting there. I do think that Hunter Biden has a responsibility to respond to the subpoena through his legal counsel, if he so chooses, in a responsible way. What he did in showing up outside the steps of the Senate is contemptible. He shouldn't have done that. But we need to investigate this. We need to follow the evidence. And he needs to appear as a material witness to an ongoing investigation. If he comes in to testify before this committee, there are other issues related to his activities that I think would be germane. But I really believe at this point we need to move forward with this. And frankly, I think Hunter Biden should have responded to the subpoena and either himself or through his legal counsel. With that, Mr. Chairman, I yield back.
Chairman yields back. Mr. Boskowitz.
Thank you, Mr. Chairman. You know, I appreciate the gentleman's solemn points and pleas, but the reason why the folks on this side of the aisle have a hard time digesting that is because your curiosity on what violates the law only applies when it's politically convenient. To talk about Hunter Biden when it's pennies, when it's pennies compared to $2 billion from a foreign government. And I'm not saying that Jared Kushner violated the law, but what I am saying is that was probably negotiated before he left, a $2 billion deal. You announce it months after you leave, probably negotiated before. He never run a hedge fund before. We talk about Hunter Biden having no experience. He never had run a hedge fund before. He was put in charge of Middle East. The $2 billion is from the Middle East. He had no experience in the Middle East. But there's no curiosity because it's Jared and because he's Trump's son-in-law. And so coming to us and pleading with us about Hunter wouldn't sound so hypocritical if there was one of you, just one of you, that would look into the camera and speak into the microphone and say, you know what, that smells pretty bad. we should look into that as well. And I think, quite frankly, the American people would believe you more about your inquiry and about Hunter if they saw your curiosity into the Biden family with the same curiosity into the Trump family. And so that's why we are where we are. It's why the American people have no faith in this institution. And it's also why, quite frankly, you know, many members of your own party have gone in front of the camera and admitted the 118th Congress has done nothing. And so we're here. We would like to do oversight and apply the law and the rules universally. But when we talk about Trump or Jared Kushner, you all look down just to make sure Donald Trump doesn't see you on camera. You can't even like look up and be interested that a foreign government, months after someone who actually worked in the White House, Hunter Biden never worked in the White House, months after someone worked in the White House and was in charge of that very region, got $2 billion. Thank you, Mr. Chairman.
Would the gentleman yield?
Sure, yes, I would.
With great respect, your allegations have absolutely nothing to do with what this committee's investigating. And
you're not curious about it, though?
Well, it has absolutely nothing to do with anything that we're investigating.
But don't we get to decide? There are questions. Okay, sorry.
Well, I don't want to use up the time, but I made my point. I yield back.
Thank you, Mr. Chairman. And I just want to respond to my friend from Florida, gentlelady from California. I think this, unfortunately, does devolve into a partisan exercise. And I just listened with interest at what you say kind of, I'm not going to use galls folks on the other side of the aisle and bothers you. And I respect that. So I want to let you know what galls or what troubles us on this side of the aisle based on all the claims that you have made, because many of us, I was one of them, sat in a skiff week after week, day after day. For an impeachment, one of the members of this committee, now, as a staff member then, a staff attorney then, knew there were lies being told to compel the impeachment, to back up the impeachment, to reinforce the impeachment. Lies. Abject, straight-up lies. Not to mention the fact that for years, the other side of the aisle pursued the then duly elected President of the United States based on pure hyperbole about some Russian hoax that has now turned into, you know, it's the same old story from the 1930s in Germany and the 1940s. If you tell a lie enough times, it becomes the truth. We sat and watched you dismantle the country and the presidency and any agenda that the American people have voted for based on that. And to date, to this minute, to this moment, I don't think one of you have ever, to use your phraseology, the kind gentleman from Florida, stood in front of a camera and said, you know, that was pretty bad. Holy smokes, I can't believe we did that. And now, with the benefit of hindsight, we look back, and I look back and I say, how could we have ever done that? How did we ever mislead the American people? How could we have lied? How can we make up for that? How can we recover the lost time? How can we recover the lost reputations? No interest whatsoever. None whatsoever. And again, this isn't about looking back at the past. This is a markup. Said again, and I'll say it, I said before and I'll say it again. I don't think this committee has any interest in prosecuting or pursuing Hunter Biden. He did this to himself. He made this choice. We all make decisions, and there are consequences to the decisions. He did that. Our duty is to say, is this a breach in the law? Is it a breach? Yes or no? Clearly, he can come to Congress. He sat in this very room today. He was on the grounds the day that he was supposed to appear. So clearly he can come. He's chosen not to. If we're going to let everybody, look, Secretary Clinton got away with it, right? She was allowed to be deposed not under oath in her deposition on a Saturday No, holiday weekend, she got to do that. That galls the rest of America, who says, when the FBI or the local magistrate or some law enforcement agency comes knocking on my door and says, you're going to appear, you've been served. Well, see here, I think I'll set the terms of how and where I'll appear. I'll just do that. Me, citizen X. You know who gets to do that? Apparently Hunter Biden, who thinks he's above the law, who thinks he's special, who he and with the rest of his family, and with all due respect, this administration shows contempt for the law, contempt for the American people, contempt for the Constitution, and contempt for the citizens of this country. Contempt. And that's what this markup is about. And if you want to know what galls us is, you're not interested, you're not the least curious about all of that. With that, Mr. Speaker, I yield the balance.
Mr. Chairman, may I respond, since my friend from Pennsylvania directly addressed me? And I'm happy to have this conversation to compare the 2019 impeachment investigation. Why are you leaving, Mr. Perry? I'm happy to have the conversation, because what you saw in that investigation was 17 fact witnesses who came in and testified under oath, and then 12 of them appeared in a public hearing. There wasn't a single thing that any Democratic member of Congress said that was not supported by neutral Trump administration fact witnesses and what their testimony and their documents said. Contrast that with what we have here. We haven't had a single public hearing with a single fact witness. Not one. The only public hearing we had was a complete debacle where the Republicans' own witnesses said that there is nothing approximating an impeachable offense here. So we're done. We're not having anything out in the public. And you haven't even released the transcripts of all of the depositions. When we had our first impeachment hearing with the constitutional law professors, and I would note, I at least admire your fellow colleagues on the Homeland Security Committee, which I also sit. They didn't even bother to bring in any constitutional law or impeachment experts in their first impeachment hearing today. At least they learned from the debacle that was yours. But at that hearing, we moved to have your own fact witnesses come here and testify in public as part of the impeachment inquiry. And you voted it down. You voted it down. So if you want to compare 2019, that's fine, let's do it. Because every single fact that was in a 300-page report was not spoken by counsel, me, by Adam Schiff, the chairman of the Intelligence Committee, by any member of the Democratic Committee, of the Democratic Party. It was testimony from witnesses who had knowledge, who actually had expertise and experience and factual information about the topic at hand. We don't have that here. And when we have a witness who is willing to come and sit here and give you the evidence that you claim you want to have, you say no. You say no. You understand the accommodation process and how that works in Congress. That means that Congress issues a subpoena, and the receiving party works with Congress to accommodate the interest of both parties so that Congress can get what it needs and the interest of the witness can also be served. Hunter Biden's attorney has done that. He has agreed to every single thing in your subpoena. Every single thing. Under oath, any questions you want, any topic you want, any date you want. He will not raise privileges available to him under the Fifth Amendment. He will answer your questions. The one accommodation he wants is to do it in public in front of the American people, and you are too afraid to let him do that, and I'll yield the remainder of the time to Mr. Raskin.
Now, Chair's going to recognize, Mr. Raskin will have 1 minute and 3 seconds. The Chair's going to recognize Mr. Gosar. I just have to throw in, you must have been absent when the IRS whistleblowers testified with respect to the number of crimes and evidence that the IRS had on the person who we're voting to hold in contempt today. You remember that
Was
hearing?
being
Chair recognized
prosecuted
Mr.
by the
Gosar.
Department of Justice because
Chair recognized
he
Mr.
insisted on it.
Gosar.
I will tell you, the gentleman from New York has got some facts wrong. You know, when we were talking to these witnesses, these constitutionals, Jonathan Turley, they said they rose to the occasion of impeachment. But they said there was a suspicion, and that's what the impeachment inquiry was all about, to go get that information, if there is. They all said that there was a suspicion based on these shell corporations. So they did say that. They didn't say what you just said. You mischaracterized that. So, you know, from that standpoint, we got to be very, very careful with how we're cherry picking this information. Maybe we do it, but you do it too. And you did it right there because they did not have.
Will the gentleman yield for a question?
I'll give you
a quick question. What I said was, and I just want to make sure we're on the same. I said that the witness testified that there was insufficient evidence to impeach Joe Biden.
It was an impeachment inquiry
Inquiry.
hearing.
No.
It was he said there was more than enough evidence to proceed with the impeachment inquiry. That's what we're doing. Let's be
But
clear
did he
about
also
what we're
say
doing
that there
here.
was insufficient
Wait,
evidence?
not
to
Mr.
impeach
Gosar's
him?
time.
No. Yeah.
He said both. He said both.
You know, and when we're comparing apples to apples on the two impeachments of Mr. Trump, you didn't even go through an impeachment inquiry. You didn't even vote on the floor on one of those. So if you're talking about apples and apples, we're not even close to that. You know, the one thing I thought was the lady justice is blindfolded. She's got the scales. You put the information in there, and she's going to give you a result. She's blindfolded. She doesn't see who that is. You know, Trey Gowdy made that comment. We're missing the point here, is that the information that we got is from factual based. There's information there that is suspicious. Why would you stack all these shell companies up? You got the IRS folks that said this were whistleblowers. They've been exonerated. I got to tell you, they're not liars. They're not liars. They do one thing, they're good at auditing. So I think what we do is we got to get back to the order of business. That is Hunter Biden violated the context of the subpoena. You know, he's not above the rule of law, so we ought to be just continuing that vote. I yield.
Right. Now, Mr. Haskins has 1 minute and 3 seconds.
First, to my friend, Mr. Gosar, we did not launch an impeachment inquiry for the second impeachment because Donald Trump tried to overthrow the Constitution on January 6th, 2 weeks before he left office, and we were the targets of that impeachable offense. So we all saw it. We were the witnesses, and we were the ones to vote on it, and we didn't quite have time for all of those niceties, but all of us knew exactly what happened. Secondly, I am sorry that Mr. Perry left the room at Josh Hawley's speed when Mr. Goldman began to speak there because he made two really important points. One was he said that if you get a subpoena, you comply with the subpoena, you answer it. Yes, I would like to tell him, Mr. Perry, you comply with your subpoena, but no, he decided to arrogate the law to himself and to claim that the January 6th committee was invalid, it was illegal, it was unconstitutional. All claims that were rejected by federal courts. They do not have a single case authority for that at all. And yet he's going to now lecture other people about complying with subpoena. I mean, he should, I think, delegate some of his time to some other members to speak on that. It's a little uncomfortable there. And finally, I'm sorry?
The gentleman.
Yes, I will yield. Yes, go ahead.
Will allude to good process builds good policy, builds good politics. Would you agree?
Yes, I totally agree.
You don't skip, in the severity of impeachment, you never skip that process. But you did.
Donald Trump was already arguing that he couldn't be tried because it was too late at that point.
Okay.
He was already arguing
All right.
that.
Your all's 10 minutes has expired. Mr. Fallon, I think we have 1.5 minutes.
Thank you, Mr. Chairman. You know, what this has devolved into is deny, 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 counter accuse. It's an old adage, and it's unfortunate because, again, and we've been talking about this now 5, 6, 10 times, the difference between a private deposition is hundreds of hours can be expended, and you can really drill down, and you can have accountability. You can get an in-depth interview. And then at that point, after we've all read that, we can come here and each of us can get our 5 minutes. This is a very big difference, and it's a distinction that needs to be, again, reiterated and refuting some of the Democratic arguments. And then I read this actual amendment, and I see this footnote number 17, this amendment where the author says, Chairman Comer has also dishonestly and repeatedly suggested that the then Vice President Biden had the prosecutor of Ukraine fired as a part of a bribery scheme. Where's the proof? And then you read the footnotes, and there are opinion pieces. The fact is that according to the FBI, the informant, the human source, was very reliable. They paid him over $100,000, and they've been working with him for almost 10 years. Did Victor Shokin, the prosecutor, get fired? Yes. Who was advocating for that? Joe Biden was advocating for that. Mykola Zlochevsky, the corrupt oligarch who was the CEO of Burisma, paid his son millions of dollars. And Victor Shokin, the prosecutor, had seized land, a few homes, and a Rolls Royce from Zlochevsky. So he was apparently doing his job. And even when he was fired, the president of Ukraine, on the call to Joe Biden, said, we thought he was doing a good job, but you wanted him fired, so he's gone. Biden bragged about that. These are all facts. So I'm going to vote against the amendment because the amendment is factually incorrect. And I yield back.
Time has expired for both sides. The question is on the Frost Amendment. All those in favor of the Frost Amendment signify by saying aye.
Aye.
All those opposed signify by saying no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
Recorded vote, please.
A recorded vote is ordered as previously announced. Further proceedings on the question will be postponed.
Mr. Chairman.
Does any member wish to be recognized? Ms. Stansbury?
Yes, thank you, Mr. Chairman. I have an amendment at the desk.
The clerk will distribute the amendment to all members. What?
So our reading of this is non-germane, because this is trying to talk about, it's saying that the evidence shows no wrongdoing by President Biden, but this contempt report is all about Hunter Biden not showing up for a subpoena and ask him questions. So we can have that prepared. So the procedural question is this. Several of these, I don't know how many, but some of our members just got called up to the Speaker's office for a meeting.
That what?
Several of our members got called up to the Speaker's office for a meeting.
This is what happened the last time.
I know it's Donald, I know Perry, and I don't think they appealed the ruling last time, but they didn't ask for a recorded vote. If they ask for a recorded vote, we're gonna have to hold the vote open to get people here.
So what are you saying?
I think we still can just pull it under me, but just be prepared that we may. Because it's not germane. It feels like I'm no purpose. We're taking the really. Do you think we're just louder? Can we tell them that we're going to rule it non-germane because of that? Tell them that that's what they're going to do. We're going to hit your touchdown.
The clerk will designate the Stansberry Amendment.
Amendment to the amendment in the nature of a substitute as offered by Ms. Stansberry of New Mexico.
Without objection, the amendment is considered as read. I reserve a point of order. The gentlelady from New Mexico is recognized for 5 minutes to explain her amendment.
All right, well, thank you, Mr. Chairman, and I appreciate the opportunity to offer what I hope is a pretty straightforward amendment. We've heard a lot today. There's been a lot of high emotion and intensity and yelling, but this is really about getting the facts correct in the resolution itself. So, Mr. Chairman, this amendment actually corrects the ANS, which is replace the original resolution text to correct the record in this resolution in the section that begins on page 5 of your resolution and goes to page 7 on the background on the investigation. And with all due respect to my colleagues who were yelling a few moments ago about this only having to do with Hunter Biden, it's very clear this is a political act, and you don't really need to dig much further than to actually read the resolution itself, because what the resolution does is make conclusions that are not based in evidence, which are not factual. And Mr. Chairman, I'm going to be honest, I'm a former Senate staffer. I'm embarrassed. I mean, we can't send this to the floor. It's not factual. It's filled with all kinds of misinformation. So what my amendment would do is clarify the actual evidentiary background that was conducted as part of this investigation, which I'd like to note, it didn't just begin, though there was a vote on the floor a few weeks ago. This actually began last year, at the beginning of last year, and I'll get back to that here in a moment. But over the course of this investigation, 82,000 pages of records have been reviewed from the National Archives. There's been 30,000 pages of bank records reviewed, 2,000 pages of Treasury report records, dozens of hours of testimony from special counsel, U.S. attorneys, DOJ officials, FBI, IRS agents, financial advisors, business partners, Ways and Means provided evidence. We had expert witnesses come and testify under oath live in front of the committee, including during the impeachment hearing in September, and other witnesses who've been called in for depositions and recorded interviews. And so there's been a massive body of evidence actually brought before this committee. And in fact, in the September impeachment hearing, as has been said many times here today, the witnesses that were called here, including the GOP's own expert witnesses, concluded that there was not sufficient evidence to proceed with an impeachment. Now, I understand that there's a rhetorical argument here being made about an impeachment investigation, but, Mr. Chairman, with all due respect, that's not actually what your resolution says. Your resolution makes declarative statements about the president. It makes statements about his involvement in his son's activities, which are just factually untrue. We don't have any evidence. There's no material evidence that's been provided before this committee. So what my amendment does is it corrects the record about what evidence has come before the committee, so that if you are going to send this to the floor next week for a vote, which we understand that you are, it's actually factual. I mean, that's what we're here to do, right? The other kind of comments I'd like to add here is, Mr. Chairman, you said yourself just a few moments ago, we can't just make stuff up. We're the Oversight Committee, so we want to make sure that the evidence that we're telling the American people about is clear and factual, and that what we're telling the American people about what is happening not only publicly in this domain, but also within the committee's investigation is factual. And, I had the opportunity yesterday to sit in one of the taped interviews with one of the witnesses who's been called before this committee. And I have to say, Mr. Chairman, I was really shocked. We sat there, the witness answered the questions of the majority, and man, those members who were sitting in that room, they ran downstairs as soon as they heard the first few minutes of testimony, and then they went directly to the press gaggle and shared a complete misrepresentation of what happened in that room. And that's why Mr. Biden is trying to appear under oath publicly in front of the American people, because time and again, and I saw it with my very own eyes yesterday, we have members who are participating in this inquiry who are misrepresenting the facts. So let's get the facts correct inside of this resolution. Now, finally, I want to just point out that this impeachment inquiry actually precedes even some of the conspiracy theories that are even being put forward here today. We heard, back in the summer that 2 members of this committee had competing impeachment resolutions on the floor, one of which had nothing to do with the evidence that the committee is trying to bring in on this matter. So, and they got in a vocal fight on the floor of the House because they were, so ravenous to prove to Donald Trump that they were his supporters and going to help impeach Joe Biden. So let's not play games. This is a political activity, but if you are going to engage in a political activity, let's make sure it's factual. With that, I yield back.
Mr. Chairman. Mr. Chairman. Mr. Chairman, I move that this motion be immediately dispensed with and tabled. It is not germane to the markup.
Parliamentary inquiry. Can you explain what is not germane about it?
Well, I haven't ruled, but I'm going to rule it's not germane. It violates the fundamental purpose of the report.
In other words, it addresses the fundamental purpose of the report.
No, it violates the fundamental purpose of the report. That's the ruling of the chair.
Okay, I'd like to appeal the ruling.
All right.
Mr. Chairman, could
Mr.
you
Ghost?
please, point of order, please.
Yes.
Could you please clarify what you mean by the report? Because my understanding is the ANS is a resolution to hold Mr. Biden in contempt, but this amendment is to correct the resolution so that there is a factual accounting of the...
There is a factual accounting. We've been very transparent. This has been a very transparent, substantive investigation.
Mr. Chairman, with all
right.
due respect, I encourage
Gosar.
the American people to read...
No, I think the American people are keeping up with this. Well, we'll see.
In this resolution, not
Gosar.
report, I also encourage the chairman to use the correct terminology when engaging in parliamentary procedure.
Yeah. I'm sorry?
Yeah, I see.
Yes, Mr. Gosar.
Move to table the motion.
Okay. The motion by Mr. Gosar is to table is not debatable. All those in favor of tabling the appeal of the chair may signify by saying aye. Aye. All those opposed signify by saying no.
No.
In the opinion of the chair, the ayes have it, and the motion to appeal the ruling of the chair is tabled. The committee will now resume consideration of any other amendments. Are there any other amendments? Ms. Crockett.
Mr. Chair, I have an amendment at the desk.
The clerk distribute the amendment? No. I got time to use the bathroom. Okay.
I don't have my daggone thing.
Will the clerk designate the Crockett Amendment?
Amendment to the amendment in the nature of a substitute as offered by Ms. Crockett of Texas.
Without objection, the amendment is considered as read. I reserve a point of order. Ms. Crockett is recognized for 5 minutes to explain her amendment.
Thank you, Mr. Chair. I'm introducing this amendment to emphasize the importance of telling the truth. Chairman Comer has given us alternative facts about the testimony of Mr. Devin Archer provided to this committee, the Democrats and Republicans, but behind closed doors. Again, it's common sense not to trust my colleagues on the other side of the aisle when it comes to stating the facts, because they are the same ones that gave us alternative facts about the election, they gave us alternative facts about January 6th, and thus far they have given us alternative facts, at least to the American people, about their motivation for this impeachment inquiry. So I do have a few receipts that I'd like to go through. On December 6, 2023, Chairman Comer tweeted out that President Biden emailed with his son's business associates. But let me be clear, when consulting the transcript, it was determined that those were alternative facts. The actual facts found in Mr. Archer's transcribed interview show that President Biden was not involved in his son's business activities and that during his more than a decade-long business relationship with Hunter Biden, Archer never witnessed President Biden have any involvement in his son's business dealings or take any official actions to benefit Hunter Biden or his businesses. And Archer never witnessed Hunter Biden discuss the substance of his business with his father or ask his father to take any official actions. Again, in August of 2023, Chair Comer stated in an interview to Newsmax that Mr. Archer, quote, admitted that the Burisma executives were squeezing Hunter Biden to try to do everything he could to get the prosecutor Shokin fired because they were going after their corrupt energy company. And lo and behold, a few days later, Joe Biden actually did that. After consulting the transcript, yet again, it was determined another alternative fact. The actual facts are that Mr. Archer specifically spoke about Ukraine and Hunter Biden's role with Burisma, the Ukrainian energy company on whose board they both served, and repeatedly stated Hunter Biden never discussed Burisma with his father and never asked his father to take an official action to benefit him or Burisma. Mr. Archer further stated that he had no reason to believe Vice President Biden's call for Shokin's removal was driven by anything other than the U.S. government's anti-corruption policy in Ukraine. Chairman Comer again tweeted, he loves his Twitter, on December 6th that President Biden was on speakerphone with the Biden family business associates over 20 times. We consulted the transcript and it was determined again, another alternative fact. Mr. Archer's transcribed interview actually states that while Hunter Biden spoke frequently with his father, sometimes when Hunter Biden was with other people, Mr. Archer stated he never witnessed any discussion of substantive business during these calls. Again, Chair Comer's association with reality about information brought forth by witnesses he demanded come in, well, Chair Comer, we spun it. Again, about Mr. Archer's statements when it came down to President Biden. When we consult the transcript over and over and over, it's been determined that the facts that have been laid out by the members of this committee on the Republican side have been alternative facts. When Mr. Archer was directly asked during the transcribed interview if President Biden was the brand, Mr. Archer clarified that D.C. was the brand and that he and Hunter Biden helped to assemble a team of attorneys, lobbyists, and public officials, public affairs professionals to handle Burisma's government relations, and President Biden was not part of the D.C. team. It is no wonder that Hunter Biden wanted to come before everyone in public because, Mr. Chairman, it is vital that we continually have to set the record straight and make sure that alternative facts are not what's being handed out to the American people, but instead the facts, the real facts, reality.
Well, the gentlelady,
I would also like to, yes.
Just for a quick question, Ms. Crockett, and I thank you for that illuminating intervention, because I'm starting to wonder if the Russian hoax should apply to the lie about Burisma, which sits at the very heart of this investigation. That's the real hoax, isn't it? In fact, In fact, the Lev Parnas, who helped make it up, has been out there begging Chairman Comer and the Republicans to end this wild goose chase and to have him come testify about how they tried to concoct the lie in the first place. And yet, that's a witness that they don't want to hear from. I thank you. I yield back to you, Ms. Carter.
They don't want to hear that. And if we care about making sure that the American people know that we have transparency and truth on this committee, then I would implore this committee to release the transcripts publicly instead of tweeting out alternative facts about what has been testified to.
Mr. Chairman.
As previously approved, each side has.
Mr.
As
Chairman.
previously approved, each side has 10 minutes debate. Will the Mr. Chair now recognize Mr. Palmer?
Mr. Chairman, I make a motion that we table this amendment. It is dilatory and not germane to the markup.
But, Mr. Chairman, didn't we already agree, I think, to have 10 minutes on each side? I'm not sure Mr. Palmer was aware of that agreement.
Yeah. Okay. We've already agreed to have debate, 10 minutes debate. I'm sorry I didn't make that
withdraw the
clear.
motion.
So, does anyone wish to speak? Mr. Goldman.
Thank you. I think this amendment is very important because it goes to the heart of the dispute that the chairman and the witness seem to be having, which is where would his testimony take place? The chairman is insisting that it be done in a closed-door deposition, whereas the witness is insisting to take up the chairman's original offer to do this in a public hearing. And one of the reasons that the witness continues to push for a public hearing is the Devon Archer closed-door transcribed interview. That is one of only 2 transcripts of, I believe, at least 18 transcribed interviews or depositions that this Republican majority has released. But it gives us really, really good insight into exactly what the chairman and the majority would plan to do with Hunter Biden's closed-door testimony. Let's take, for example, just I think earlier this weekend, Chairman Jordan of the Judiciary Committee, also a member of this committee, said on television that the most powerful evidence of President Biden's wrongdoing is the testimony of Devon Archer. So I wonder what is that testimony that is so powerful? Was it the testimony of Devon Archer when he said that President Biden was never involved in any of Hunter's business ventures? Or was it the testimony that President Biden never received any money from Hunter's business interest? And remember, Devon Archer testified he was Hunter Biden's primary business partner. He was on the board of Burisma with Hunter Biden. So he had firsthand knowledge of all of Hunter Biden's business deals. Now, maybe if it wasn't those, it was the fact that President Biden, according to Devon Archer, never received any bribes from the Ukrainian government. In fact, maybe it was even that he said that President Biden never discussed business with Hunter Biden or Hunter's business associates. It must be that he was focusing on the times when President Biden met or spoke to Hunter Biden's business associates. That clearly has to be what the chairman was talking about. So it must be that when you look at the transcript, what he was referring to is when Devon Archer repeatedly said that they never discussed business, that they only talked about, quote, niceties, including, and this is according to Devon Archer's testimony, how the weather was, and that none of the discussions ever related to business. So the best evidence that these Republicans want to put forward is testimony that completely absolves President Biden from any involvement, association, benefit from, or other interactions with Hunter Biden's business interests. Now, Chairman Comer You were asked a few weeks ago on CNN what you thought the best evidence was of wrongdoing by President Biden, and you said that the allegations of the bribe from the Burisma founder, should we call it, I guess, the Burisma hoax now? Because unlike with Russia's interference in the 2016 election, which Special Counsel Mueller unequivocally determined was known to the Trump campaign, was welcomed by the Trump campaign, and was used by the Trump campaign, in this case, Vice President Biden's urging Ukraine to fire the Prosecutor General of Ukraine, which was consistent with official U.S. policy. It was consistent with the European Union policy. It was consistent with a bipartisan Senate delegation who urged it as well, was actually bad for Burisma, and therefore it was bad for Hunter Biden. And who should we look to determine whether that is the case? How about Devin Archer, the star witness, who was also on the board of Burisma? Nope. Devin Archer said that it was his understanding that Burisma had Shokin, the Prosecutor General, under control, and that getting rid of him would have been bad for Burisma. And of course, it was bad for Burisma, because as soon as Shokin was gone, after he had allowed a British case to lapse, the next Prosecutor General came in and did start investigating the founder of Burisma. So it turned out to be exactly correct. This is why Hunter Biden wants to testify in public, is because if you had not released that transcript and we had just relied on the false representations of the majority members of this committee about what Devin Archer said, we would never have known that Devin Archer actually absolves Joe Biden of any involvement of any wrongdoing related to Hunter Biden's business interests. And we would not know that this entire investigation, the public would not know that this entire investigation is a complete sham. And I yield back.
The minority will have 4 minutes. The majority has 10 minutes. I'll go first. I must oppose this amendment, but I have to state something. And I want everyone to understand this. A lot has been said about people on this committee running to the press during a deposition or during an interview. During the two main interviews of this impeachment inquiry investigation, the Devin Archer interview and the George Burgess interview, the very first person on this committee to run to the reporters was none other than Dan Goldman. That is a fact. Does anyone want to dispute that right now? The very
I would like you to identify one thing that I said that was not consistent with the transcript.
You're talking about you are talking about running to the press and leaking.
Why don't you release the Burgess transcript?
You said Hunter Biden didn't want to come because of leaks. You're the leaker. You are the leaker, Mr. Goldman.
You do your check.
You have 4 minutes remaining. This is my time. You're out of order. You're out of order. I let you sit there and regurgitate your baloney for 6 minutes. I oppose this amendment. This amendment strikes the entire section about why Hunter Biden's testimony is necessary for the committee's legitimate oversight investigation. The amendment discusses a single deposition with Devin Archer and gets rid of all other relevant information as to why his deposition is important. The amendment distorts the reality of how the committee has handled this investigation. Devin Archer has stated publicly that claims made by the Democrats in this amendment are categorically false. Specifically, Devin Archer stated that Democrats' claims that President Biden was not involved in Hunter's businesses in any way was false. Devin Archer said that's categorically false. He said Joe Biden, quote, was aware of Hunter's business. He met with Hunter's business partners. I recommend that all members of this committee oppose this misguided amendment, and I ask to submit to the record Devin Archer's interview where he says one Democratic claim about the Biden business is categorically false, and that was what I just mentioned with respect to Joe's involvement, knowledge in his businesses. Without objection, so ordered. Now the minority party has 4 minutes remaining. Chair recognizes Ms. Stansbury.
Thank you, Mr. Chairman. I just very quickly want to clarify that when I mentioned that the majority had run to the press and misrepresented what happened in that interview yesterday, the point was that they misrepresented what happened in the interview. And I know that for a fact because somebody shared with me the text message that the Republican staff sent around all the members, and I also heard directly from the press what was said. So that's what we're talking about here is misrepresentation of the facts. And with that, I yield to the ranking member.
Thank you very much. And but I'm fascinated by this exchange because most committees I've been on, when the transcripts are released, it serves the vital function of transparency, but it also keeps people from misrepresenting and distorting the facts in advance. But if you withhold all but 2 transcribed interviews, I think there's something like 16 or 17 that haven't been released by the majority, then that does become an incentive to misrepresent and distort. I don't blame Mr. Goldman if he ran to the press to try to get out the true story before others go out and tell a lie about what's taking place if we're not going to turn the transcripts over. And I wonder whether you, Mr. Chairman, could commit to turn over all of the transcribed interviews to
the gentleman yield for question
and to the Congress and to the people of the United States of America.
Ranking member,
Yes, by all means.
A question.
Yeah.
Does the ranking member presume that his Republican colleagues intend to lie about transcripts?
But
You seem to have that presumption.
What I will presume is based on the fact that there have been multiple distortions and misrepresentations in the past, and the vast majority of the transcribed interviews have not been released. Someone give me the exact numbers, but I believe only 2 transcribed interviews out of 17 or 18 have been released. I've never seen that before, and I'm baffled by it. I don't understand it.
In the ranking member's esteemed background and knowledge of judicial affairs, when there's ongoing investigations and multiple witnesses in complex cases, isn't it common for full transcripts to not be released?
No, it's not.
Within the parameters?
No, but I don't think so. But in any event, we're talking about some that took place 6 months ago, 8 months ago. But somebody's going to give me a list of how many we're talking about here. There's 17 total. Only 2 transcribed interviews have been released. So then it does become a race to get out to say, what you think happened. Why don't we just give the people the transcribed interviews? We talk about transparency and accountability. That's the dominant theme of this committee. Isn't that something we can agree to?
Will the ranking member yield for 1 minute?
Yes, by all means.
I yield.
I have a question for the ranking member. If it is generally the practice of an investigator to withhold all of the transcripts during the investigative phase, would that normally also include releasing 2 of them?
Well, that strikes me as odd. That does look like, the famed cherry picking. It's as if to say, well, 2 of these interviews helped us. 15 or 16 of them don't help us, so we're going to bury them someplace. So that's odd, but I want to presume the best of my colleagues, Mr. Higgins, and that's why I'm asking the chairman to explain what is the practice here.
Well, you complain that we don't release transcripts. You complain because we do release transcripts. Honestly, we released those 2 transcripts because you had misrepresented so much what Devin Archer said. That's probably one reason he went on Tucker Carlson's show to call you out for misrepresenting what he said in the transcribed interview. But
so you are able to get them ready. You are able to get them ready, in other words, and you thought that it was
we have other witnesses
important.
to interview. You know how it works, Mr. Raskins. You're playing like you don't know how this works. You're playing and trying to act like you've never done an investigation before when you've led both impeachments in the January 6th.
I didn't lead the first impeachment, but
I wouldn't want to admit to leading that first impeachment either.
I would have 10 nicknames from President Trump by now if I'd led that one.
Well, I think your all's time is pretty much expired. Does anyone on our side have anything to add? I don't see anything. So, who's that? Mr. Gosar.
Yeah, we talk about facts. It wasn't U.S. policy to do what Biden did in Ukraine.
The Obama administration actually said that Ukraine had complied with the law and that the loan should go through. Yes, they did. And that the vice president changed it on an audible over there. So the other thing I want to point out is if the president didn't know anything about Hunter Biden's businesses, how do you explain the 14, 15, 16, I can't remember now, how many times his partner actually went to the White House? How do you explain that? How do you explain this guy, Devin Archer, shows up at the White House? Who are you? Normally, the person's going to say, well, I'm Hunter Biden's business partner. That's typically what the average person would say. So how come you didn't know anything about that?
Mr. Gosar, for the 6 people in America who are still watching our hearing, could you just explicate what you think the presidential crime is?
Oh, I'm just saying right now, we're just talking about the facts. The facts here are misplayed. I mean, you complain about us, I'm going to complain about you
Would
because
the gentleman
you're
yield
distorting the facts.
for 1 second?
I'll give you a second.
Mr. Gosar's time.
Just, I'm not going to ask you to take my representation for it. I would ask you to go read the transcripts of the State Department witnesses in the first impeachment who were in the Ukraine embassy and in the State Department and were the ones who created and made the official U.S. policy, who all testified that Vice President Biden was acting consistent with official U.S. policy.
Okay, well, that's not what we received. And when you start looking at this, you know, the courts, you know, I know the ranking member always goes to the courts. You know, you had a judge that basically said this honeypot of a deal for Hunter was no good. No one was going to get that. How do you explain the slow walking, you know, by the Justice Department on the IRS claims? And how many people get a chance to do that?
Well, with the gentleman yield, that's a great point. And when the courts ruled against Hunter Biden, I don't think you heard a single complaint from anybody on our side of the aisle. We said, let the justice system proceed. But when the court said that the January 6th committee was validly and constitutionally composed, we still have people today who violated their subpoenas who are whining about how the committee is illegal. I mean, come on. I mean, how do you feel about that one?
Could I ask you a question about that?
Yes.
Just out of curiosity, why did you all not hold them in contempt?
Hold who in contempt?
The people that didn't.
Oh, we didn't have time at that point. I mean, we got up to the very end of the Congress.
I was just wondering.
But if you want to work on it now, let's do it.
No.
I'm totally with you, Mr. Chairman.
No. I was just curious as to why you didn't. All right.
Well, let's make it bipartisan.
I'd like
Everybody
to
good?
mention that
We're
we
square?
hold anyone who's violated
No, I was just wondering. I mean, that's a tool that Congress has. If someone, you've been on TV several times saying that people should honor congressional subpoenas.
And I
when
believe
they don't, you hold them in contempt.
Whether it's Steve Bannon, Dan Scavino, Jim Jordan, or Hunter Biden, if somebody is...
But you did hold
if
the
somebody,
other two.
I'm sorry?
You did hold those 2 of those in contempt of court.
We did. Well, Steve Bannon's been convicted by a jury, by a court. He's been convicted in
Department of
court.
Justice
And
went
still,
after
I don't think we
him.
could get a single person on your side of the aisle, other than Ms. Mace, to utter a word about people who violated subpoenas in the last Congress. I mean, that's extraordinary. And all that I've been saying about Hunter Biden is he accepted what was your original offer. You didn't like that offer anymore. You put out.
Let me say this, and then your time's expired, and we're going to get to the vote. Hunter Biden is more than welcome to come for a hearing after the deposition.
Okay, you didn't say that before, but that's cool. You've changed the offer.
Chairman, hold on. Will you
No,
guarantee
the time is
that
expired.
there will be
Mr.
a
Goldman.
public
You have
hearing?
talked and talked.
Will you
and
guarantee
talked.
that there will be a public hearing if he were to come in?
After the deposition, I
You
guarantee.
say right now
yes.
you will have a public hearing
Yes.
with Hunter Biden.
Absolutely, we've said that. All right.
Yeah, I know. We heard a lot about public
Okay.
hearings that have
Very
not
good.
happened.
The question on the amendment, I don't even remember who offered the amendment. Ms. Crockett. The question is on the Crockett amendment. All those in favor of the Crockett amendment signify by saying aye.
Aye.
All those opposed signify by saying no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
Recorded vote on that, please.
A recorded vote is ordered as previously announced. Further proceedings on the question will be postponed. Pursuant to the previous order, the chair declares the committee in recess subject to the call of the chair. We will plan to reconvene in 15 minutes to get everyone together. The committee stands in recess. The committee will come to order. The committee will now resume consideration of the report's amendment in the nature of a substitute. The question is now on the previously postponed amendment to the amendment in the nature of a substitute offered by Mr. Goldman from New York. The clerk will call the roll on the Goldman amendment.
Mr. Jordan, Mr. Turner, Mr. Gosar. Mr. Gosar votes no. Ms. Fox. Mr. Grothman. Mr. Grothman votes no. Mr. Cloud. Mr. Cloud votes no. Mr. Palmer. Mr. Palmer votes no. Mr. Higgins. Mr. Higgins votes no. Mr. Sessions. Mr. Sessions votes no. Mr. Biggs. Mr. Biggs votes no. Ms. Mace. Ms. Mace votes no. Mr. LaTurner. Mr. LaTurner votes no. Mr. Fallon. Mr. Donalds. Mr. Donalds votes no. Mr. Perry. Mr. Perry votes no. Mr. Timmons. Mr. Timmons votes no. Mr. Burchett. Mr. Burchett votes no. Ms. Green. Ms. Green votes no. Ms. McLean. Ms. McLean votes no. Ms. Boebert. Mr. Fry. Mr. Fry votes no. Ms. Luna. Ms. Luna votes no. Mr. Langworthy. Mr. Burleson. Mr. Burleson votes no. Mr. Waltz. Mr. Waltz votes no. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Norton.
Yes.
Ms. Norton votes yes. Mr. Lynch. Mr. Lynch votes aye. Mr. Connolly. Mr. Krishnamurthy.
Aye.
Mr. Krishnamurthy votes aye. Mr. Khanna.
Aye.
Mr. Khanna votes aye. Mr. Mfume. Ms. Ocasio-Cortez.
Aye.
Ms. Ocasio-Cortez votes aye. Ms. Porter. Aye. Ms. Porter votes aye. Ms. Bush. Mr. Gomez.
Aye.
Mr. Gomez votes aye. Ms. Brown.
Aye.
Ms. Brown votes aye. Ms. Stansbury. Ms. Stansbury votes yes. Mr. Garcia. Mr. Garcia votes aye. Mr. Frost. Mr. Frost votes aye. Ms. Lee. Ms. Lee votes yes. Mr. Kassar. Ms. Crockett.
Aye.
Ms. Crockett votes aye. Mr. Goldman. Mr. Goldman votes aye. Mr. Moskowitz. Mr. Moskowitz votes aye. Ms. Tlaib. Mr. Chairman.
No.
Mr. Chairman votes no.
Will the clerk call the roll? How is Mr. Kassar recorded?
Mr. Kassar is not recorded. Mr. Kassar votes yes.
How is Mr. Fallon recorded?
Mr. Fallon was not yet recorded. Mr. Fallon votes no.
How's Mr. Langworthy recorded?
Mr. Langworthy is not yet recorded. No. Mr. Langworthy votes no.
How's Ms. Tlaib recorded?
Ms. Tlaib is not yet recorded.
She voted yes.
Ms. Tlaib votes yes.
Let's go. clerk report.
Mr. Chairman, on this vote, the ayes are 18, the nays are 22.
Okay. The noes have it, and the amendment is not agreed to. The question now is on the previously postponed amendment to the amendment in the nature of substitute offered by, who? Frost. Mr. Frost. The clerk will call the roll.
Mr. Jordan. Mr. Turner. Mr. Gosar. Mr. Gosar votes no. Ms. Fox. Ms. Fox votes no. Mr. Grothman. Mr. Grothman votes no. Mr. Cloud. Mr. Cloud votes no. Mr. Palmer. Mr. Palmer votes no. Mr. Higgins. Mr. Higgins votes no. Mr. Sessions. Mr. Sessions votes no. Mr. Biggs. Mr. Biggs votes no. Ms. Mace. Ms. Mace votes no. Mr. LaTurner. Mr. LaTurner votes no. Mr. Fallon. Mr. Fallon votes no. Mr. Donalds. Mr. Donalds votes no. Mr. Perry. Mr. Perry votes no. Mr. Timmons. Mr. Timmons votes no. Mr. Burchett. Ms. Green. Ms. Green votes no. Ms. McLean. Ms. McLean votes no. Ms. Boebert. Mr. Fry. Mr. Fry votes no. Ms. Luna. Ms. Luna votes no. Mr. Langworthy. Mr. Langworthy votes no. Mr. Burleson. Mr. Burleson votes no. Mr. Waltz. Mr. Waltz votes no. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Norton.
Aye.
Ms. Norton votes aye. Mr. Lynch.
Aye.
Mr. Lynch votes aye. Mr. Connolly.
Aye.
Mr. Connolly votes aye. Mr. Krishnamurthy. Mr. Krishnamurthy votes aye. Mr. Khanna.
Aye.
Mr. Khanna votes aye. Mr. Mfume.
Aye.
Mr. Mfume votes aye. Ms. Ocasio-Cortez. Ms. Ocasio-Cortez votes aye. Ms. Porter. Ms. Porter votes aye. Ms. Bush. Mr. Gomez. Mr. Gomez votes aye. Ms. Brown. Ms. Brown votes aye. Ms. Stansbury. Ms. Stansbury votes yes. Mr. Garcia. Mr. Garcia votes aye. Mr. Frost. Mr. Frost votes aye. Ms. Lee. Ms. Lee votes yes. Mr. Kassar. Mr. Kassar votes yes. Ms. Crockett.
Aye.
Ms. Crockett votes aye. Mr. Goldman. Mr. Goldman votes aye. Mr. Moskowitz. Mr. Moskowitz votes aye. Ms. Tlaib. Ms. Tlaib votes yes. Mr. Chairman.
No. And how is Mr. Burchett recorded?
Mr. Chairman votes no. Mr. Burchett is not yet recorded.
Mr. Burchett votes no. How is Mr. Turner recorded?
Mr. Burchett votes no. Mr. Turner is not yet recorded. Mr. Turner votes no.
Will the clerk tally? It's 24 to 20.
Mr. Chairman, on this vote, the nays are 24, the ayes are 20.
The noes have it, and the amendment is not agreed to. The question is now on the previously postponed amendment in the nature of substitute. This is the chairman's amendment. Right? Oh, on the Crockett amendment. The clerk will call the roll on the Crockett amendment.
Mr. Jordan. Mr. Turner. No. Mr. Turner votes no. Mr. Gosar. Mr. Gosar votes no. Ms. Fox. Ms. Fox votes no. Mr. Grothman. Mr. Grothman votes no. Mr. Cloud. Mr. Cloud votes no. Mr. Palmer. Mr. Palmer votes no. Mr. Higgins. Mr. Higgins votes no. Mr. Sessions. Mr. Sessions votes no. Mr. Biggs. Mr. Biggs votes no. Ms. Mace. Ms. Mace votes no. Mr. LaTurner. Mr. LaTurner votes no. Mr. Fallon. Mr. Fallon votes no. Mr. Donalds. Mr. Donalds votes no. Mr. Perry. Mr. Perry votes no. Mr. Timmons. Mr. Timmons votes no. Mr. Burchett. Mr. Burchett votes no. Ms. Green. Ms. Green votes no. Ms. McLean. Ms. McLean votes no. Ms. Boebert. Mr. Fry. Mr. Fry votes no. Ms. Luna. Ms. Luna votes no. Mr. Langworthy. Mr. Langworthy votes no. Mr. Burleson. Mr. Burleson votes no. Mr. Waltz. Mr. Waltz votes no. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Norton.
Aye.
Ms. Norton votes aye. Mr. Lynch. Aye. Mr. Lynch votes aye. Mr. Connolly.
Aye.
Mr. Connolly votes aye. Mr. Krishnamurthy. Mr. Krishnamurthy votes aye. Mr. Khanna.
Aye.
Mr. Khanna votes aye. Mr. Mfume.
Aye.
Mr. Mfume votes aye. Ms. Ocasio-Cortez. Ms. Ocasio-Cortez votes aye. Ms. Porter. Ms. Porter votes aye. Ms. Bush. Mr. Gomez. Mr. Gomez votes aye. Ms. Brown. Ms. Brown votes aye. Ms. Stansbury. Ms. Stansbury votes yes. Mr. Garcia. Mr. Garcia votes yes. Mr. Frost. Mr. Frost votes yes. Ms. Lee. Ms. Lee votes yes. Mr. Kassar. Mr. Kassar votes yes. Ms. Crockett.
Aye.
Ms. Crockett votes aye. Mr. Goldman. Mr. Goldman votes aye. Mr. Moskowitz. Mr. Moskowitz votes aye. Ms. Tlaib. Ms. Tlaib votes yes. Mr. Chairman.
No.
Mr. Chairman votes no.
Does any other member wish to vote? Seeing none, will the clerk report the tally?
Mr. Chairman, on this vote, the ayes are 20, the nays are 24.
The nays have it, and the amendment is not agreed to. The question is now on the amendment in the nature of a substitute to the contempt report. All those in favor signify by saying aye. Aye. All those opposed signify by saying nay. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute to the report is agreed to. The question is on favorably reporting the report. The clerk will call the roll.
Mr. Jordan. Mr. Turner. Mr. Turner votes yes. Mr. Gosar. Mr. Gosar votes yes. Ms. Fox. Ms. Fox votes yes. Mr. Grothman. Mr. Grothman votes yes. Mr. Cloud. Mr. Cloud votes yes. Mr. Palmer.
Thank you for coming.
Mr. Palmer votes yes. Mr. Higgins. Mr. Higgins votes yes. Mr. Sessions. Mr. Sessions votes yes. Mr. Biggs. Mr. Biggs votes yes. Ms. Mace. Ms. Mace votes yes. Mr. LaTurner. Mr. LaTurner votes yes. Mr. Fallon. Mr. Fallon votes yes. Mr. Donalds. Mr. Donalds votes yes. Mr. Perry. Mr. Perry votes aye. Mr. Timmons. Mr. Timmons votes aye. Mr. Burchett. Mr. Burchett votes aye. Ms. Green. Ms. Green votes yes. Ms. McLean. Ms. McLean votes yes. Ms. Boebert. Mr. Fry. Mr. Fry votes aye. Ms. Luna. Ms. Luna votes aye. Mr. Langworthy. Mr. Langworthy votes aye. Mr. Burleson. Mr. Burleson votes aye. Mr. Waltz. Mr. Waltz votes aye. Mr. Raskin.
No.
Mr. Raskin votes no. Ms. Norton.
No.
Ms. Norton votes no. Mr. Lynch?
No.
Mr. Lynch votes no. Mr. Connolly?
Nay.
Mr. Connolly votes nay. Mr. Krishnamurthy? No. Mr. Krishnamurthy votes no. Mr. Khanna?
No.
Mr. Khanna votes no. Mr. Mfume?
No.
Mr. Mfume votes no. Ms. Ocasio-Cortez?
Nay.
Ms. Ocasio-Cortez votes nay. Ms. Porter? No. Ms. Porter votes no. Ms. Bush? Ms. Bush votes no. Mr. Gomez? Mr. Gomez votes no. Ms. Brown? Ms. Brown votes no. Ms. Stansbury? Ms. Stansbury votes no. Mr. Garcia? Mr. Garcia votes no. Mr. Frost? Mr. Frost votes no. Ms. Lee? Ms. Lee votes no. Mr. Kassar? Mr. Kassar votes no. Ms. Crockett? Ms. Crockett votes no. Mr. Goldman? Mr. Goldman votes nay. Mr. Moskowitz? Mr. Moskowitz votes nay. Ms. Tlaib? Ms. Tlaib votes no. Mr. Chairman? The chairman votes yes. Mr. Jordan is not recorded. Mr. Jordan votes yes. Mr. Chairman, on this vote, the ayes are 25, the nays are 21.
Recommending that the House of Representatives find Robert Hunter Biden in contempt of Congress for refusal to comply with a subpoena duly issued by this committee. We will move the report to the full House. Without objection, the motion to reconsider is laid upon the table. Pursuant to House Rule 11, Clause 2, committee members shall have the right to file with the clerk of the committee supplemental, additional, minority, and dissenting views within 2 days. Without objection, so ordered. Additionally, the staff is authorized to make necessary technical and conforming changes to the reported today, subject to the approval of the minority. Without objection, so ordered. If there is no further business before the committee, without objection, the committee stands adjourned. Thank you.